Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. And don't forget, comment, like, and subscribe. And if you love this channel, please become a member.
Good morning, everyone. This is June, the head mod. Ada is still down. Hopefully, she will be popping in a little bit later on. She has a big day today. Wish her good luck and pray that she is getting on the recovery side. Right now, they just walked into court, so we are going to go there straight away. So grab yourself a cup of coffee, your favorite snack, and let's go to the closing arguments of Brian Walsh. Oops, I forgot to do something.
Counsel present in court. Counsel starting with the Commonwealth. Kindly identify yourselves once again.
Good morning. Good morning, Your Honor. Tracy Cusick with the Commonwealth.
Morning. Good morning.
Good morning, Your Honor. Larry Tipton for Mr. Walsh.
Good morning. We'll wait for Mr. Walsh. But while we're waiting, I'm just going to pass you out
A couple
of versions of something to look at.
I have a preference.
Commonwealth, or how does the Commonwealth intend to safely put those seen done cases, and most often comes up in the context of a knife going back. I've seen other DA's offices basically take the knife and it's like they put it on a hard board and then they strap it down. So the jury can see the item but can't hurt themselves unwittingly with the item. It seems that the same could be done of the tools in this case, if you have the capability to do that. I think I've seen that done in Middlesex, Plymouth. That's how they sort of handle the issue. How are you planning on handling it?
We're working on this one.
Okay. So what I have in my mind, just so that, and I think law enforcement in the past has done it for the DA's office. So they may have the strapping mechanisms, but as long as I'm assured that they can go in safely to the jury deliberation room, either with a sheath cover on it or preferably strapped down to a hard board, it seems to me that that would be a good approach. Anybody object to that?
No, Your Honor, we'll work with defense counsel, but we're trying to get some supplies to do that this morning.
All right. So I passed out to you two versions. I went back to look at different instructions I looked at a few different things, and this relates to the direct and indirect evidence instruction. And the version 1 is what I will call I put this in air quotes, I'll call it the Superior Court version of what I most often see in the Superior Court, which is different than the district court version, which is a little clunkier, I think. But anyway, you always like what you like, right? That is probably the more traditional, old-fashioned perhaps. As I read through it last night, I think it reads better than the version that I put into the first draft, but I don't have strong feelings about it. So if we have agreement between the parties as to which one you like better, I'm happy to read that. I think both of them are accurate representations of the law. I have a preference for version 1. Take a look at that and let me know when you've finished looking at them and have an opinion.
Your Honor, the Commonwealth doesn't take a position. Neither one seems
Fine.
comfortable.
Normally, honestly, I don't spend a lot of time on this in most cases but this case is one that I spend a little more time on it. Yes, Attorney Porges.
Your Honor, we're requesting version 2. So if no one else has a position, I'd ask the court read that one.
All right, which is my version 1, I guess, right? It's the version that was in the instructions yesterday.
I believe so.
All right. Both are correct recitations of the law, so if you wish to draw from any of them, they're all good. And I'm not sure that they make a huge difference. All right. Any other edits to the draft instructions beyond those that I've just incorporated?
Your Honor, on page 12 of the 155 instruction on reaching a verdict, I believe there's some references for each charge, and I would suggest that that might have been a carryover, the plural version.
The four-person,
I have page 12, reaching a verdict, the third paragraph for each charge,
for the charge, yeah.
and then has proved every element of the charge beyond a reasonable doubt, then you should find that Mr. Walsh is guilty of the charge or just is guilty.
Okay,
In the next paragraph,
and same thing, particular?
yes, Your Honor, particular, and then the on that charge.
I'll just end it at not guilty.
Your Honor, on page 13, role of the jury, second paragraph. Do not be influenced by the nature of the,
Charge?
yes, Your Honor.
Mm-hmm. I think I already made that change. I just didn't tell you I did.
Your Honor, on page 31, alternate jurors, I believe there's a reference to 3, and I believe it's 4.
It is. I made that change later in the day too, and I didn't tell you about that either.
That's all the Commonwealth has identified, Your Honor. Thank you.
Anything additional from the defense?
No, Your Honor, content, except for the previous exceptions made.
Although now I think most of the previous exceptions you made have been removed,
Just being cautious.
but I get the point. All right, let me step off the bench quickly and make these changes. And the reason for that is I want you to each have a copy, well, to have a copy so that you can follow along while I'm doing it. It shouldn't take me very long.
All right.
Okay, well, she's off the bench right now. First of all, I would like to say good morning to Ada and welcome Diane. Hope you have a wonderful weekend with Diane at her or with Ada at her graduation. Hopefully, maybe a little bit later on today that they might be able to come on and say hi to everybody. Uh, Michelle,
Hi.
go ahead. I could barely hear you, but go ahead.
Good morning, everybody. Can you hear me?
Yeah, go ahead.
Well, we got in about 1:30 in the morning and didn't get to sleep probably until almost 3, but she's an interpreter for students in schools remotely, and so she's on my computer interpreting till about 11. So anyway, actually had a decent night's sleep for the first time in 2 weeks. So yay. June, I sent you a message in private chat. Thank you guys for joining us. We greatly appreciate it. And more importantly, I also appreciate my mods and all the hard work that they're doing. Thank you so very, very much. I look forward to Monday being back to normal. All right, back to you, babe.
Okay. I'm sorry. I was kind of like, no, no. I was looking at something. Okay, so hopefully this won't be that long. And what do you think? Put it in the chat. Do you think will be a verdict watch today? And if so, how long do you think the deliberations will be? And we'll do a poll on, guilty or not guilty. But let us know how you feel about the case, about him not really putting up a defense. This is really interesting. A 4 week trial in 10 days. After we get done with the closing arguments and when they go into the verdict watch, we will be going over to the E.M. Mitchell trial. But we're going to start be doing um, uh, where we stopped at yesterday in the E.M. Mitchell trial. To carry on. Yes, we have verdict. Yes, we will be in verdict watch today, but it's very possible we will still be in verdict watch on Monday. Yeah, that's very true. I agree. Do you think it'll be a quick one? What do you think? 1 to 3 hours? See, honey, I predict shenanigans and BS in the closing argument and 3 to 4 hours in deliberation. Yeah, with the way these two attorneys like to go at it, I can see that. Let me see. Okay. All right, we have a person on. It looks like it's from Twitch. Date dated game. Hey, you stream pretty well, and I love it. Keep it up, but it's not so easy to stand out among millions of people on Twitch. So, okay, I'm not sure about the rest of that. um, okay. And good morning, everybody who came in.
Hey, June,
See
I had
today's
a debate. I had a friend ask me questions about yesterday in the trial,
okay. And what was the debate
and they
about?
were wondering if I felt that the defense was focused and fighting too much on the social media issues and not the procedural issues that should be focused on, is basically what she said. What were your thoughts about that yesterday, June?
On procedural issues and what?
Instead of them focused on hammering out the procedural issues and um, basically motion and limines and that kind of stuff yesterday, that they were hyperly focused on in the Charlie Kirk trial on the social media aspect.
Oh,
Do you
okay.
think that the defense made a bigger brouhaha out of it than needed?
In my personal opinion, yes. Um, but it seems to be like the MO of that one of Attorney Nestor, because I followed her in another case. which is going to be uh, on later this next coming year. And she did the same exact thing um, with that trial, where she tried to get basically a blanketed gag order on anything. Basically, everything was going to be private. Everything was not going to be released. Try to do a trial in secret. And then she tried also to get that prosecuting the DA office removed off the case. Um, and then she also tried to get the cameras kicked out of court. It's like she doesn't want any of her cases to have any kind of sunlight because it's like she's afraid of being exposed. Um, and one of the other things is she's also one of the I believe DP approved certified attorneys for that state. So yeah, they did. They should have done more of the motion stuff instead of the social media. But it seems like a lot of the courts are going on to the social media, like blaming them for their cases falling apart. It just seems like a pattern now. We have a bad case, we're going to blame the media if we lose type attitude. That's my opinion. Okay, what else do you think? Oh,
Well, I kind of focused with her a little bit, and I said, well, what bothered me is she was throwing her knickers in the air over the fact that the camera caught his shackles. And I'm thought, well, we've already seen him on a Zoom. He was shackled and handcuffed, and he was in jail uniform. You did not fight to get his image off of that Zoom call, which was aired nationally, internationally. You didn't have a problem with that being on YouTube, but now you do. It's like, if you know you're going to do this, then you set the precedent at the very first public hearing, whether it's Zoom or in court.
yes,
If she's worried about prejudicing the jury, that should have started with his first appearance, not now. Because I'll tell you what would be more impactful to a jury is seeing him sitting in a jail cell on a Zoom call in jail garb with handcuffs and shackles versus just having shackles in a courtroom. I would
yeah,
have more respect for her position if she would have been consistent from get go.
yes,
She's using the fact that she's worried it's going to taint the jury. Well, boo, they've already been tainted because you didn't do this to begin with. They could have had the camera off. The judge could have said, I want to see everybody before we go live. He can see that he's there. And then, like we have, you just have our avatars. And then when they went live in court on Zoom, they could have just put an avatar up for him and protected that right. So the jury would not have seen him in that position. What do you think?
I agree. You know, um, in fact, when they first when they first did his arraignment, even in his jail garb and it was televised, so people had seen him in his jail guard, and now they want to make a big deal of it. It's like Brian Coburn. They made a big deal about him being in his jail clothes during all the pretrial stuff. So they put him in his civilian clothes, just like they did with this guy here. Do they really think we're that dumb that we don't know that he's in jail? You know, um, but they keep throwing the right to the fair trial, the right to the fair trial. Well, yeah, they have a right to a fair trial, but you know Do they have the right to lie to us on his status or whether he's free or not? We know he's in jail. We know he's in handcuffs. I mean, take a look at the other case that we're watching right now, Brian Walsh. We watch him bring him in, and we watch him take off his shackles, and we watch him take off his handcuffs. What's the difference?
Yeah, that's exactly my point. I think that you're acting too late on this. I was like, woman, you're behind the ball. So we'll see how the judge sides with this. But if I was a judge, I would have told her, ma'am, you seem to not have a problem with this to begin with because you allowed it. So you can't put the crap back on the horse. You can't backpedal.
That is very, very true, and I don't know why they're doing that. We know he's there. We've seen him there. Um, what's the big difference? You know, does anybody have anything in chat that they would like to debate with us on this topic of are they putting too much emphasis on social media motions versus motion and
Give me a
lemonades?
minute, June. We're switching places and I'll be live on with you. Just give me a minute.
Okay, okay. I try not to keep too much dead space. I'm still kind of learning how to do certain things. Okay,
Hey, June, you're doing a great job, boo. I appreciate you so very much.
okay. Well, I enjoy this back and forth uh,
Yeah.
debate. I'm
And I'll
a
move the
little at
background
loss
things.
sometimes with what to say. So, is Diane in the room with you? Oh, wait a minute.
Yes, she is, but I'm having to
Oh,
set her up in the other half of my room. I
okay,
got to
we're
put
getting
the
ready.
green screen behind her.
Okay, well, we're getting ready to go back live.
We got court coming back.
Yep, we got court coming back.
Everyone else set?
Hey, Ada, I'm hearing something in the background.
All rise, jurors entering. Hear ye, hear ye, hear ye. All persons having anything to do with the Honorable Justice Diane Frenair, Justice of the Norfolk Superior Court, draw near, give your attendance, and you shall be heard. Such are the Commonwealth of Massachusetts in this honorable court. Please be seated. Please turn off your cell phones.
Jurors will start today, as we have every day together, with the 4 questions. Jurors, were you able to comply with my order that you not be on any social media or any news media?
Yes.
And were you able to comply with my order that you not do any research about this case?
Yes.
Are you able to comply with my order that you not speak to anyone about this case?
Yes.
And you all still have open minds?
I will, I will need until these charge.
A what?
I need the plugs until these charge. Sorry.
Oh, no, we're good.
Then parties will do their closing arguments. And then depending on how you're doing, given the time that's passed since then, we may have a short break, bathroom break. Then I'll come back and give you the more generalized instructions on the law. To break it in, deliberately break it into 2 chunks, more consumable for you that way. So jurors, I want to thank you for your service on this jury. To a person, when I've looked over, you've caught me many times looking over at you. You've been paying attention, and that's exactly what I anticipated, but it's refreshing and rewarding for me to see it. So I know that you have paid attention to the evidence in this case, and I appreciate your attention. Your jury service in this case is a very important part of our democratic self-government. You are responsible to uphold the law and our principles of justice. That's what you promised to do at the start of this trial when you took an oath as a juror. You've all devoted a substantial period of time on this case, time away from your personal lives, work, studies, your families, to sit as jurors in this case and to decide the very important matter, an issue now between the Commonwealth and the defendant, Brian Walshe. You've done so in accordance with the finest traditions and the highest aspirations of our system of justice. Again, I thank you for your service and your sacrifice. You must now consider all of the evidence, decide who and what to believe, and decide whether the prosecution has proved beyond jury charge, the jury instructions in the jury room when you deliberate the case. I do my best to make sure that the instructions that I'm giving you while I'm speaking match these written instructions. If there is any difference between what I say aloud and the written instructions, please follow what I say aloud. So let me start with the prosecution's burden of proof, and I'll start with the presumption of innocence. There is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Mr. Walshe is presumed to be innocent of the charge in this case. That means that you must consider Mr. Walshe to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at the trial that Mr. Walshe committed the crime charged. And I will explain what I mean by reasonable doubt in a minute. Mr. Walshe does not have to do anything to convince you he is innocent. He does not have to explain anything to the jury. Mr. Walshe does not have to testify, call or question witnesses, or provide any evidence at all because you must presume he is innocent. Instead, it is up to the Commonwealth to prove the charge against Mr. Walshe beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all of the evidence carefully and fairly, if you have a reasonable doubt about Mr. Walsh's guilt on the charge of murder, then your verdict must be not guilty. You may find Mr. Walshe guilty of the charge of murder only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. So the burden is on the Commonwealth to prove beyond a reasonable doubt that Mr. Walshe is guilty of the charge made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, or everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden is on the prosecutor. If you evaluate all of the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That's what I mean by proof beyond a reasonable doubt. There's one indictment or charge in this case. You must decide whether Mr. Walshe is guilty of that charge. For the charge of murder, there are certain things, we call them elements, that the Commonwealth must prove beyond a reasonable doubt to show Mr. Walshe is guilty. I will explain these legal rules to you now. There are two different degrees of murder. Murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. Commonwealth alleges that the defendant committed murder in the first degree on a theory of deliberate premeditation. To find the defendant guilty on this theory of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every element of this theory beyond a reasonable doubt. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt this theory of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. I'll begin by instructing you now on the elements and the additional requirements for the proof of murder in the first degree with deliberate premeditation, and then I will next instruct you on murder in the second degree. Murder with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following three elements. First, that the defendant caused the death of Anna Walshe. Second, that the defendant intended to kill Anna Walshe. That is, the defendant consciously and purposefully caused Anna Walsh's death. And third, the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. I will now discuss each of those requirements in more detail. The first element is that the defendant caused the death of Anna Walshe. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element that the defendant intended to kill Anna Walshe. That is, the defendant consciously and purposefully intended to cause Anna Walsh's death. The third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. Murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, that the defendant caused the death of Anna Walshe. Second, that the defendant A, intended to kill Anna Walshe, or B, intended to cause grievous bodily harm to Anna Walshe, or C, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Anna Walshe. The defendant's act is the cause of death. The act, in a natural and continuous sequence, results in death, and without which death would not have occurred. As you can see, the second element has three sub-elements, which I'll call prongs. And the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong, the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation.
The second prong is that the defendant intended to cause grievous bodily harm to Anna Walsh. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that he intended to perform the act, you must then determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. Let me give you some supplemental instructions relevant to the charge of murder. The definition of death. Death occurs when the heart has stopped long enough to result in complete and permanent loss of brain function. This complete and permanent loss of brain function occurs when, in the opinion of a licensed physician based on ordinary and acceptable standards of medical practice, there's been a total and irreversible cessation of spontaneous brain functions, and further attempts at resuscitation or continued supportive maintenance would not be successful in restoring such function. Next, the jury's obligation on guilt or innocence. You've been instructed on two theories of homicide in this case: murder in the first degree and murder in the second degree. If the evidence convinces you beyond a reasonable doubt that the defendant is guilty of a criminal offense, you have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of any offense charged, you must find him not guilty. Do either counsel need to see me?
No, Your Honor.
Be happy to see you.
I really enjoyed and appreciated the pace in which she read these. Sometimes judges go through them so fast
Yeah.
that you can't understand them. They just rattle them off, and they treat them with such low importance. I really appreciated the way she's done this. I really, really do. Really like her.
You take a, I know you haven't been sitting there that long, but you're going to go for a stretch now. So I'm going to ask you to stand up. As I said to you before, shake a leg. When you're ready, please be seated. So, jurors, I'm about to conclude my first set of the instructions to you, and we're going to hear the closing arguments of counsel next. This is an important part of the trial because it's the final opportunity that the lawyers have to address you. It's an opportunity for the lawyers to summarize the evidence, to call your attention to certain parts of the evidence that they regard as important, and based on the evidence to try to persuade you to reach a certain result. However, what you're about to hear is not evidence. Lawyers aren't witnesses. All of the evidence in this case has been presented to you through the testimony of the witnesses, the exhibits, stipulations, which you have before you. And as to the exhibits, you'll have an opportunity to examine those in detail and consider them during your deliberations. Our rules are designed to ensure that the parties receive a fair trial, and they therefore prohibit the attorneys from making certain types of arguments in an effort to persuade you to reach a certain result or to favor or discredit either party. For example, the lawyers are not permitted to refer to facts that are not in evidence in this case. If, based on your memory and understanding of the evidence, a lawyer does this, you should disregard that comment. The attorneys are not permitted to express their personal beliefs in the credibility or lack of credibility of any witness who testified in this case. That determination is entirely for you to make. If a lawyer makes such a comment, you should disregard that comment. This case must be decided based solely on the basis of the admissible evidence and the law that I'm teaching to you. Attorneys are not permitted to persuade you for or against either party by appealing to human passions or prejudices. If a lawyer makes such a comment, you should disregard that comment. If you become conscious of any passion or prejudice as you consider the evidence and engage in your deliberations, you must put these feelings aside and not permit them to influence your thinking. With that, we'll turn to the closing arguments. As is the custom, we'll hear first from the defense. Attorney Tipler.
What could happen?
Hello, y'all. Is alive. Uh-oh, I'm going to get everybody else on up. All right, guys, I wanted to pop in real quick and say good morning and hello. I'm getting ready, but just want to set up a few things. I love the chat, and I want y'all to give your opinions back and forth. Remember to keep it nice and polite. You remember to say, in my humble opinion, I feel, or I think. Okay? So, if y'all notice, Joe Schmo is in the house. He's going to be our guest host later this afternoon because all three of us are going to be unavailable. We didn't want to end the live. So Joe Schmo's going to be the guest host in a little bit. Just so you know, he is now a mod, so he can take care of business. So everybody, welcome Joe Schmo. Thank you so much for being here. I want to thank all of y'all for watching today, and I hope y'all enjoyed today. And we're going to get back into the closing arguments. Let's see what shenanigans they pull out of the hat right now. This is the prosecution. They get to go first. They have the burden of proof. Then the defense will go. And then if the prosecution chooses, they can come back and go again. So they're the openers and the closers. So here we go. With waited anticipation, here you go.
Loving father and loving husband. We're making line of pleas before you. Search for the unspeakable on the internet. Expose the woman that you adore. Government.
Do you want a piece of gum?
There's no proof of that. There's no proof that Brian Walshe knew anything about an affair between the woman he loved and William Benson. Money? Second reason that the government suggests, family money. Money that the family had worked together for years and continued to talk about in text messages and the sales of property, trying to protect the assets for the benefit of the whole family and the future of their 3 children. A motive? There's no motive. Refusal to consider prison for a terrible mistake he made. The case that began in 2018. There's no proof of that he was afraid to go to prison. Who wants to go to prison? But prison was always on the table. And it was just something that he had to face up to, and something that he did. So, what would cause a loving husband and a loving father to do the things that you heard about in this case? Could it be something that was sudden, something that was unexpected, something that was unbelievable, something that only a medical examiner would understand, have knowledge of, but not a man like Brian Walshe? Something that is terrifying, something that defies logic when it happens. How do we know that Mr. Walshe was a loving father and a loving husband? We know from much of the testimony of Jim Motlow. We know from simple testimony from Julie Basler from Kindergarten. When asked questions about her experience with Mr. Walshe and the children, that he would show up and he'd be interested and he'd be friendly, and he was always interested in the progress of his children. And how do we know he was a good father? Because Anna Walshe trusted him with their 3 children, 24 hours a day, 7 days a week, for all those times she was up in Washington, D.C. The unthinkable happens. It happens in a variety of ways. And the Commonwealth must prove to you beyond a reasonable doubt that a homicide occurred, that a killing occurred. Nothing proves that beyond a reasonable doubt on the facts and circumstances and the evidence presented to you. There's evidence that he lied to the police. There's evidence that he searched the internet. There's evidence that he disposed of a body. But there is no proof in all of the evidence that you have heard and been presented that he ever once thought about harming the woman he loved. That he ever thought about harming the woman he loved. Did he ever plan to harm? Did he ever intended to harm? So, when we talk about the evidence of the affair, when we talk about evidence of financial concerns, when we talk about evidence of being ready to go to prison, those are the motives that the Commonwealth needs to prove to you to support any notion that a loving husband and a loving father would kill his wife. And the evidence suggests there was no motive at all. And without a motive, without a reason, a reason that is based on facts and circumstances, logic and understanding. Without that, you have a sudden and unexpected event that results in confusion, panic, and fear. All of those things that are so troubling and horrific that you've heard evidence about, they may be argued that they show consciousness of guilt. But people do things, terrible things sometimes, not out of guilt, but out of fear, out of disbelief, out of confusion. Certainly, a loving father and a loving husband would feel guilty about what he did do. Not just about lying to the police, but what he did do in the context of what he did to the woman he loved. In a moment, in hours, and in days of confusion and disbelief and horror. But that feeling of guilt had nothing to do with the killing, because he never killed Anna Walshe. You will hear arguments, but you've seen the evidence that might evoke emotion. Who wouldn't feel emotional in what you've heard, what you've seen? But your obligation, and I don't mean to sound like I'm lecturing you at all. Her Honor will instruct you on the law, and that is not my province, but you cannot base your verdict on sympathy for Anna Walshe. You can't base your verdict on anger to what Mr. Walshe did. You can't base your verdict on passion, based on the evidence that you've heard that is upsetting and terrifying and at times disgusting. But that's not what you can do as jurors in this case. At the beginning of this case, when you were sworn as jurors, you might not recall it, but the clerk of this court read you some words. To this indictment, the defendant pleads not guilty. He places himself before this country which you are, the obligation that you have accepted in this case is unlike perhaps any obligation that you've ever accepted in your life. Perhaps. That's for you to judge. But your obligation requires that without passion and without anger and without sympathy, that you assess the facts as troubling as they are, and at times as horrific as they are, and make your verdict rest on the evidence, and nothing less and nothing more. Unbelievable, facts that don't make sense at times, something that is incongruent. An example of that is the end of Mr. Jim Mutlow's testimony, where for almost an hour, he talked beautifully about the love between these two people. That he talked glowingly about Mr. Walshe. And then toward the end of his examination, he wanted to say something about now he was thinking there might have been some kind of problem. And reflect upon the evidence that he gave of a phone call he had with Mr. Walshe on the 4th, when the conversation was confusing to Mr. Mutlow, confusing where he kept asking what could have happened that would result in Anna Walshe leaving. The lie that Mr. Walshe was telling people out of fear that no one was going to believe him about what happened, so he lied. But consider the way that Mr. Mutlow had a terrible time trying to understand that. And why? Because he knew both of them. Because what he was thinking, why would Anna Walshe leave? They love each other. I know them both. It makes no sense. And that is what happens when something happens that is totally confusing. You just can't believe it. And you seek answers. You yearn for answers that make sense of something. And when something sudden and unexpected happens, something tragic, your ability to come to terms with it, when it's such a dynamic, such a tragedy, you change. You change. The evidence of the searches, the dark, troubling evidence of the searches. They began at 4:52 a.m. on January 1st of 2023. And the first one is, how do you dispose of a body? It causes chills. It causes disgust. Look at all of those searches. Think of how they evolved. Consider how they go from one subject to another in rapid fashion. Searches conducted by a man that is in disbelief, in confusion. 5 hours spending with his wife on New Year's Eve, enjoying life, talking about the future. And then the sudden and unexpected tragedy happens, and it doesn't make sense. If Mr. Walshe began to make those searches with murder in his heart as a result of murder, then why isn't the first search how to dispose of a body after murder? Because that's the search that occurred 6 hours later. And when you see that word murder, no one would not react to that word. And certainly as jurors in this matter, you're expected to react in a way to that. What does that mean? Does that mean that he in fact murdered his wife? But think about it in context. In this case, on these facts, context matters. And so the first time the word murder is used in these horrific searches is 6 hours after they began. And I tried to ask Trooper Garino, one of the forensic specialists, as he called himself, associated with the Mass State Police. I tried to ask him, well, it's only logical, isn't it, that if you don't get results, you change the wording. We all know that from our own common experience. And you look at those searches that came and went during this time, and the results had to do with funeral parlors and cemeteries and things like that. But Mr. Walshe, given the tragedy that occurred to his wife, and given the time that had passed and his fear and disbelief, he couldn't call a funeral parlor. We need to try to understand, what can I do? Then the searches become darker. They become more upsetting. Now the thought is dismemberment. And there's searches like that. You've heard about them. You'll read about them. And then you see searches that cover days. And there's searches about cleaning. And there's searches about how to clean up. You'll read them. And even though they don't talk about murder, they are equally upsetting because you're thinking, as jurors in this case, he's thinking about cleaning up the basement. He's thinking about how you clean a concrete floor. Context. 1,034 pages of digital data, 3,667 records taken from his MacBook. Not one record, not one page refers to any plan. Not one record, not one page refers to any intent to kill. Nothing. So keep it in context when you review. I suggest to you respectfully, you're the jurors. What is the evidence of premeditation? There's evidence of a knife. There's evidence of a knife that is seen in a kitchen cabinet. Could I please have exhibit 201? And next exhibit 202. And finally exhibit 203. The knife. It was above a refrigerator. It was in plain view. Had no visual red blood stain. And yet the government wants you to think about this knife. So think about it. Don't ignore it. Do not refuse to consider it. Of course you will, but think about it. In a cabinet above a refrigerator. And they first test it with some screening test. It doesn't prove that it has even blood on it. And they take it, and they should. And then, what happens is everybody loses interest in the knife. Everybody, the Mass State Police, the crime lab. There's no further testing of this knife. And ask yourself, if that knife is to be considered a weapon used, then why is it in that cabinet? You have heard evidence of bags and bags being thrown in dumpsters over a period of days. The government wants you to think that Mr. Walshe killed his wife and perhaps used this knife. Then why was it sitting in a cabinet days later in open view for the police? What logic is that? And there is no proof that it had one piece of biological evidence on it tied to any killing or any harm. And they simply lost interest in it. You can take it down now. Digital data, talked about that briefly, but there is nothing in that data, all of that data. And we're talking about text messages. We're talking about backbook searches. We're talking about the life that's embodied in computers that this day and age we know apparently keep track of everything we do and to some extent everything we think about. Because that's how the government is using that data. They ask you to look at certain things and indicate and try to argue that, oh, this is what he was thinking. So look at it and judge for yourself. What's in this data that demonstrates premeditation or intent to kill or intent to harm? You have heard and seen much physical evidence. You've seen pictures of gray slippers with blood on them. You've seen pictures of all kinds of physical evidence. And if the argument is made by the government, something about a dark gray slipper with blood on it indicates that a murder happened because, listen to the argument, of course you will. But a theory, an opinion, does not make it true. And to suggest something like, the evidence shows that Mr. Walshe went and bought a Tyvek suit, and maybe there's just not enough blood on the Tyvek suit to satisfy the Commonwealth, and so they suggest that some killing happened, and that's why there's so much blood on that slipper and those slippers and all that other evidence. But ask yourself, what do I know about that evidence now from what we heard? Every piece of evidence was put into a bag, but then was put into a compactor eventually, and was pressed together and then found. And you will see all of this evidence of when they pulled it out of dumpsters and unloaded the bags, and they first put it on damp ground without any paper below it, without any tarp below it. And you heard from no less than 3 witnesses. Mr. Gould from the Mass State Police Crime Lab, Mr. Sheehan from the Mass State Police Crime Lab, and Ms. Celine from the DNA unit. They all consistently said cross-contamination or transfer. They used different terms, but they all agreed. So the evidence, the physical aspect of the evidence, the thing you see in the photographs, the thing you see now, if you open up one of the bags and take things out, is not representative, or may not be representative, of how it looked before. And you must consider that. So when the government makes an argument based on the state of the physical evidence as it appears now, ask yourself, maybe that makes sense, but maybe there's another way of thinking about it. And why is that important to your deliberations? Because you are allowed to rely on what's called circumstantial evidence. You're allowed to rely on inferences. And Her Honor will instruct you on that. I will not. But whatever reason and basis you have for making your choice and determining your decision must be reasonable. And if you, as jurors, talking amongst yourselves, find that some of your fellow jurors say, well, I think maybe it means this, and I believe this, and your other jurors, fellow jurors, say, I think this, and I believe this, you'll all consider it. But if you don't agree, then you have to ask yourself, is that inference reasonable? Is that circumstantial evidence built upon inference? Is that reasonable? And can I use that? And should I use that to try to reach a verdict under a standard of reasonable doubt or moral certainty? What is the evidence that something violent happened in this house? I went through every room as best I could with Mr. Sheehan. There was nothing found in the upstairs bedroom. There was nothing found in the sinks and basins, showers, of multiple bathrooms. Nothing found, meaning biological evidence that might indicate something violent occurred. There was nothing found in the kitchen other than a knife that they lost interest in. There was nothing found in the living room that had padding around the fireplace to protect the children from falling. There was nothing in that bedroom where Anna Walshe, Brian Walshe, as adults, enjoyed their life together and had spent their life together, perhaps every night, before she moved to DC to take that job. How do we know that? We know that because the photographs show there was nothing there. Even what was characterized as red-brown stains on curtains in the bedroom turned out not to be blood at all. We know that because trained examiners for the Mass State Police examined probably every square inch of that house. We know that because we saw photographs in her testimony about floor that was dug up based on their experience and training. That biological evidence, like blood, can fall between the cracks of flooring and reside on the subfloor. And so they tore the floor up, and you saw those photographs, and you'll have them. And nothing was found. Nothing at all. I asked Mr. Sheehan about blood spatter, and he forthrightly and honestly said, I'm not a blood spatter expert, but he explained it sufficiently to you. Someone wielding a knife or a weapon and causes blood to let out of a body, and you look for blood that has spattered with directionality. Nothing. Nothing in the bedroom, nothing in the living room, nothing in the bathrooms. No evidence that blood drained down the drains. Could I have Exhibit 217, please? That test that I asked Mr. Sheehan about, the Serotek Hem test, that checks for hemoglobin, for blood. That test, he agreed, can detect blood at the sensitivity of 20 nanograms per milliliter. 20 nanograms. A nanogram, as he agreed, 1/1000th of a gram. Think of how minuscule that is. And they used that all over the house. And so the government elicited questions and answers from many of their state police, the 10 or 20. They didn't call everybody. That's up to them. But apparently there was no need to, because 10 people or more, as Mr. Sheehan had described to you, he was estimating. He was trying to be as honest as he could and credible, and he was. 10 people pouring over that house all day on January 8th. 10 more people or more pouring over that house on January 9th with their tools and their experience, and they don't find anything except multiple bloodstains where? In the basement. In the basement. On the concrete floor. Ask yourself, when you heard testimony that Mr. Walshe attempted to clean, and so therefore they couldn't find evidence in the other parts of the house because he cleaned it. Well, ask yourself, wait a minute. Is that logical to suggest that he cleaned the bedroom up so well nobody could find a thing? He cleaned the living room up where the rug may have been, and they couldn't find anything. Well, then you see those searches where he searches specifically for how to clean concrete. So you might infer, and it might be a reasonable inference, that he attempted to clean that concrete floor. And yet, what was found on the concrete floor? Multiple red-brown stains that turned out to be blood, and in some instances, we can all agree, based on the testimony of Ms. Celine, the profile, those blood drops, matched the profile of Anna Walshe. So to suggest that Mr. Walsh did everything he could to clean the basement concrete floor with hydrogen peroxide and mops and cleaning fluids, only to have blood found on the floor, defies a reasonable inference that he was able to clean any part of that house sufficiently to avoid detection. And why is that important? Because nothing violent happened in that house. And that's why there is no biological or blood evidence anywhere in that house. The act of trying to hide the body of his wife and the blood evidence that is seen on that carpet. That's what happened. There's no blood in the living room. The inference might be that the carpet was taken downstairs. Because you can look at those pictures. You can look at the physical pieces of carpet, and you should. But there is no evidence of any killing that happened. And there's no evidence that anything was done before Mrs. Walsh died. And there's no evidence of premeditation or anything. There is evidence of lying and disposing of the body. You can take that one. So now we look at the evidence, and I'm just going to characterize it. Some of the evidence that the Commonwealth has presented to you, and there is no question, but their obligation is to present to you evidence. But I just ask you to think about, in some cases, how that evidence was presented to you. And I'm going to use a phrase that may or may not be entirely accurate, but it's cherry picking. It's looking at thousands of points of data and asking you to think about it, but not telling you why you should think about it. And what am I talking about specifically? And I'll give you some examples. We already talked about the hole in the ceiling, but let's talk about it a minute. They kept talking to you about that hole in the bedroom ceiling as if it was of some significance. And yet you recall the testimony of Mr. Sheehan. I didn't see anything significant about it. It looked like somebody might have fallen through the ceiling. And there's nothing significant about the pieces that Mr. Walsh had stored in the cabinet in that same bedroom. I asked Mr. Sheehan about that. I didn't see anything significant about that. Yet you kept being given that evidence. And then as the evidence developed, for some reason, there's Mr. Murphy. And it came out in evidence that Mr. Murphy had in fact contacted Mr. Walsh because there was a promotion going on. It wasn't that Mr. Walsh said, hey, come and fix this hole, this suspicious hole. No, he was contacted. And he didn't respond right away, but then he did. And for some reason, they keep insisting that that hole is of some significance, but they don't tell you why. They just give it to you. They do the same thing with the searches. Remember when Trooper Keefe was sitting right here and he's asked to look through those thousands of, 250 pages of the search history from the iPhone Mini 13, the phone that belonged to Mr. Walsh, and he's asked to look at it. He says, do you see searches there to go to the MGM? Yes, I do. Nothing else. No explanation why that is significant, why it's important to try to determine if a man committed premeditated murder. You're just throwing back pieces of evidence. Why? Why were you given? Why was Trooper Keefe asked to tell you about a song, a partial song title? And when you go over that evidence. Look through there if you choose to, and I will encourage you to do that. And you see song after song and movie title after movie title. Why is it that the government throws that at you and says, think about this? For what reason? And then they present to you through Trooper Garino something about a porn movie. I'll just take this opportunity right now to apologize to each and every one of you for some of the questions I asked. But it just didn't make sense that you would take that type of evidence and suggest that it has anything to do with determining whether someone committed deliberate, premeditated murder because there's a word in the title of a movie. And that's what I'm talking about, the quality of some of the evidence here thrown at you as if it means something, that it's significant, and yet here you are being asked to determine if someone, Mr. Walshe, committed premeditated murder with a specific intent to kill the woman he loved. When we talk about premeditated murder, we talk about planning, you have to ask yourself, did I hear evidence of the conduct of a man who premeditated, a man that had thought about a killing, a man that had planned? I mean, think about what you heard. And we're not going to repeat all those things I've already said, but I want you to focus on one other piece of evidence. I asked Detective Schmidt, when you went down to the basement on January 4th, you saw some bags down in the basement. Yes, I did. What did you think was in those bags? I thought they were pieces of rug. My goodness. What does that tell you about the thinking process and the sloppiness and the lack of any planning or careful thought that you would expect out of someone who had planned a murder? And then he lets a police officer walk down in the basement, and the police officer, based on his training and experience, uses, I think he said, his boot, and he felt it, and he said, felt like pieces of rug to me. Rug that is in evidence. It has blood. Think about all of that when you're thinking about it. Did this man, Mr. Walshe, did he plan anything? No. Did he intend to kill anybody? No. Did he kill Anna Walshe? No. The evidence does not support a finding of premeditated murder with specific intent to kill based on the evidence, not based on sympathy, based on the evidence. What's some other evidence that is troubling? Mr. Walshe is talking to the police, and he says, I messenger. When asked about, and we was trying to explain it, things will come up on my phone that I thought were for me, but then it turns out they were for Anna. And so the government seizes upon that evidence and suggests that there's evidence that Mr. Walshe had seen text messages between Anna Walshe and William Fastow. And those text messages between Anna Walshe and William Fastow, some text messages are placed into evidence, and I'm sure you'll look at them. And why would the government want you to believe that Mr. Walshe saw those text messages? Because some of the entries in those text messages are very upsetting. They may very well enrage a husband to read about what was going on in those text messages. So you'll look at them. But ask yourself, as you look at them, and perhaps as you think, I could see that might upset, that might put somebody in a rage. Problem is, there is absolutely no evidence Mr. Walsh ever saw any text message because he was trying to say iMessenger. And now you know from the testimony of Trooper Keith, there's no such thing as iMessenger. We're talking about Facebook Messenger. But the important thing is, there is no evidence in all of the digital data that you have before you, in all the digital data that they examined, that Mr. Walsh ever saw anything going on between his wife and William Fastow. And when you look at those text messages, and you might have some question about it, and if the government stands up and says, well, he saw those because he told them that he was seeing iMessenger, which doesn't exist, then ask yourself, why is it that on New Year's Eve, Anna Walsh is taking all these photographs? It's festive. It's a lovely situation. And she says, in the presence of Brian Walsh, as she and Jim Mutlow were taking photographs, hey, why don't we send a photograph to Will Fastow? And was there any evidence that he reacted, Mr. Walsh? No. And when asked by Attorney Porges, well, so what happened next? And Mr. Mutlow really took efforts to remember, and then he said, oh yeah, that happened before the young boy woke up and came downstairs, and that was around 10:30. So if you just think about that, then the festive and jovial celebration continued for another 2 hours. There is no evidence that he reacted. Mr. Walsh reacted to them sending a photo. Why? Because he knew his wife had a crush on Will Fastow, and it didn't even make him jealous. And how do we know that? Because she told her friend, Alyssa Kirby. And Alyssa Kirby was asked, and she said, you know, Anna told me that he didn't get jealous. He's not the jealous type. In fact, I wish he was more jealous. Please consider that in the context of this notion that the motive for a killing that did not occur, but the Commonwealth's theory of a motive is anger over an affair. There's no evidence of that. Dr. Atkinson told you. Dr. Atkinson described to you the phenomenon of sudden unexpected death. It happens. And just because it's rare, and just because the government will undoubtedly argue that that is nonsense, listen to their argument. But Dr. Atkinson made it clear it happens. It happens in young and old, male and female. It happens unexpectedly. In fact, it happens with people who have never manifested any problem before. It happens in athletes. And how do we know that it's not absurd, even though it might be rare? How do we know it is an important aspect of what happens to people? Because the laws of this state mandate that the office, the chief medical examiner, get information from doctors, police officers, nurses, when there is a sudden death, when someone is otherwise healthy. They're mandated to investigate that. So there is a statute that Dr. Atkinson told you a little bit about on cross-examination. So ask yourself, is it as unlikely? Is it bizarre? Because Anna Walsh worked out. Yes, she had been sick before. She had been with Alyssa Kirby in the days leading up to this, and Alyssa Kirby wound up having the flu. But that's not what really is at issue here. Sudden and unexpected death may occur because someone is ill. All we know is that it happens. And the fact that someone doesn't believe it could happen doesn't mean that it doesn't. Importantly, though, think about the shock of it happening. Think about the effect it would have on anyone. A lay person that has no idea it could happen. You're down celebrating with your wife and your friend, and then the tragedy happens. And you panic because you can't believe it. You don't understand it. And you don't think anybody's going to believe you. Context. I walked Trooper Keith through all of that information, something that he had not done yet. And so what did you hear? We went methodically. Sometimes, I'm sure for some of you, it was a little painful. It took a little while. But we went through hour by hour, day by day, that basically was the life and the experience that Anna Walshe and her husband, Brian Walshe, were going through in just the days leading up to January 1st of 2023. And what do you see? And you'll have that evidence. You won't have it compiled in the way that I presented it to you, because Trooper Keith never saw fit to assemble it in a way where you could really see what was going on. But what do you see, and what did you learn from the evidence? Two people communicating by phone and by text, talking about sales of property, talking about investments, talking about the future, talking about reinvesting, talking about buying new property in DC, talking about all of that, and it's all in the text. Joking when Anna Walshe was ill and stayed home and told her husband that in the text. And then they joke about it. I'll get you a plunger. And she responds, it's right there on the text. Joking back and forth in the days leading up to New Year's Eve. I'll tell you what, I'll buy the plunger. You buy me a Porsche. And then you see him shopping for a Porsche for the woman that he loved. How does it go from, I'm going to find you the Porsche you want, that speaks once again to the financial issues that were non-existent? How does it go from that to someone who is purportedly premeditating and intending to kill his wife? And those texts lead right up until she arrives by plane in Cohasset to celebrate. So, context. Once again, divorce? About 11 minutes of talking about divorce and searching about divorce in 7 days of phone calls. And how did that divorce search come up? It came up in the context of protecting the family assets because they just sold the house in Revere that Jim Mutlow told you about. And they're trying to protect it. And the thought is to roll it over in a 1053C. And Mr. Mutlow explained that to you. Planning for the future. That is the relationship between Brian Walshe and Anna Walshe in the days leading up to January 1st. So now we have come to just the evidence that, once again, just explains their relationship. Not supposition. Not trying to make up what they said to each other. You have that in their text. You have that. Then we get to New Year's Eve. We get to a festive event, jovial, laughter, love, described in various terms, various ways, not for 30 minutes, not for 1 hour, but for 5 or 6 hours. Laughter, talking about the future. Jim Mutlow described it for you. Brian Walshe cooking, standing across from the island, feeding both of them, talking, laughing. You see in the testimony that, yes, there was an affair. He didn't know it. He loved his wife. He treated his wife like the wife.
I disagree with that. He knew it.
Children, until the sudden, unexpected event happened. Imagine you are so in love. You support your wife to get a job in DC. You're going to take care of the kids because One, you love your children, but you want to take care of them. You want to share property and protect the assets, so everything goes into her name to protect it, because he has this federal case. So let's protect our financials for the future. And then you hear the testimony of Alyssa Kirby. Yes, she was upset. There's no doubt Anna Walshe was upset. What exactly she was upset about? Maybe things weren't going really well in the affair she was having. Or maybe she was, in fact, stressed out. Who wouldn't be? They were living apart. She wasn't seeing her children. Now, maybe, it's up to her.
Her husband was convicted of fraud. He's a criminal. That stressed her out.
Anna Walshe was a wonderful person and a wonderful mother. And that's why he loved her so much. But she had another life, and she went to Dublin, and that's another piece of evidence. They want to suggest to you he knows something about Dublin. Where is the evidence of that? None. And you hear Alyssa Kirby choked up with tears, sobbing on the stand, but nonetheless recalling a conversation she had on 12/29, 3 days before January 1st. What does Anna tell her? Well, I don't know if I love them as much as I used to. Those are her words. I'm paraphrasing, but that was the gist of it. But I want him to take responsibility. Why? Not so she could kick him out, not so she could leave him, so they could reunite as a family. That was what Anna Walshe was talking about. That's what she was thinking, even though she was stressed, even though she was upset. And things like that happen in families, but families make it through. And that's what she was expressing. That's what she was expressing to her best friend, Alyssa Kirby. Could I have exhibit 169, please? We are now at the end of the New Year's Eve party, and they sign the champagne bottle. And we were talking about the feelings and the emotions and the state of mind of Anna Walshe and Brian Walshe, and looking towards the future. And this is on January 1st. This is on the day that the tragedy happened. Can you find it? I'm sorry, 169. Oh, I apologize. My fault. I'm sorry. Exhibit 257. And that's the champagne box that was signed. And what are the words? What a year. And yet we are still here and together. Let's make 2023 the best one yet. We are the authors of our lives. Courage, love, perseverance, compassion. Those are the words of Anna Walshe talking to her husband. Look what she says. What a year, and yet we are still here. What does that tell you? Yes, they had been through a lot. She missed her children. What mother wouldn't? But they were working toward the future. And one final thing about the state of mind of Brian Walshe at this period of time. He made reservations for a New Year's Day dinner so he could be alone with his wife. And the evidence of that is in these records. And I'm not going to have it called up. I'll just tell you. Exhibit 79, page 186, record 682. That's the data. He's researching where to take her out. And you'll see a reference to Nightingale, a restaurant that I asked Trooper Keith about. A restaurant that's right on the line of Marblehead and Warren. Exhibit 59, at 12:27, those records indicate that Mr. Walshe credit card used to reserve dinner for $573.76. So him and Anna could spend New Year's Day celebrating. And exhibit 170, a text from Nightshade Restaurant itself acknowledging the reservation. And those were the plans that he made. And the government will suggest that's some kind of evidence of premeditation. Well, it's not any evidence of anything but love. And I'll just tell you, when you look at that evidence, you'll see that that email exchange was deleted. It's right there in the evidence. And then you heard the federal probation officer saying he wouldn't be allowed to go there. He'd have to get permission. So yes, did Mr. Walshe lie to his probation officer for what reason? So he could take his wife out for a New Year's dinner, and that evidence, and the evidence that you saw in that champagne box, is what their life was right at the moment before the tragedy happened. That is the evidence. I'm sorry I talked for so long. I apologize.
You are not sorry.
Mr. Walshe loved Anna Walshe,
Not at all.
the mother of his 3 children. There's no evidence that he deliberately premeditated a murder. There's no evidence that he ever intended to kill Anna Walshe. None whatsoever. Mr. Walshe is not guilty. He's not guilty of murder. Thank you.
Jurors can't, I want you to take a moment to stand up.
We're going to take a quick timeout. Okay. I explained at the beginning that usually the prosecution goes, then the defense, and then the prosecution closes. This prosecution team has decided to yield to the defense to go first so they can use all of their time at the end. I think it's a good strategy in this case.
Yeah, here's the closing argument of the Commonwealth. 88 yes.
We got dense fog today. Y'all, it's so foggy here, we got a weather warning.
You may proceed.
Thank you, Your Honor. Anna Walshe is dead. Anna Walshe is dead because he murdered her. And he intended her death. Anna Walshe is not missing. She never walked out of her class at home on January 1st of 2023 between 6 and 7 a.m. to take an Uber to Logan Airport. She wasn't going to DC for a work emergency. There was no emergency. She didn't say goodbye to her son. That's just a story that the defendant told people. But since January 1st, Anna Walshe has not been seen by her friends or coworkers or by the people who loved her. Anna didn't take an Uber. She didn't take a Lyft. She hasn't used her phone. Her phone's had no contact with the Verizon network since January 2nd, 2023, but it was in the vicinity of 516 Chief Justice Cushing Highway. She hasn't used her bank accounts, her passports, her credit cards, her email. She didn't vanish. The defendant was the only adult at 516 Chief Justice Cushing Highway after Jim Lulu left around 1:30 a.m. on New Year's Day. After he left, Anna was home alone with the defendant and their 3 sons, ages 2, 4, and 6.
This defendant caused Anna's death. And the evidence does show you that. The evidence shows you that Anna didn't die of natural causes, but that Anna died a violent death in her Cohasset home on January 1st. You have the photos of those pieces of rug recovered from the dumpster at the defendant's mother's complex. The rug that had been in the living room. You have the photo of Anna in the living room on top of the rug. The photo shows that there are wood floors in that room. There's blood on that rug. The rug was recovered from the compactor outside of the defendant's mother's apartment and taken to the office of the chief medical examiner for examination. And Dr. Atkinson found a blood clot and a piece of Anna's Gucci necklace embedded in one of the cut up pieces of rug. So look at the piece of metal stamped Gucci. It didn't break on its own. The rest of the necklace is missing. This is the necklace that Will Faxall said that Anna often wore. Look at the slippers from the dumpster. The two pairs of adult slippers. The dark gray slippers have hair and blood clumped to the bottom. And the DNA testing tells you that the slippers had the DNA of Anna Walshe and the DNA of the defendant. Then there's the bathrobe. And there are two bloody white towels. A towel was tested and had Anna's DNA. Why did the defendant throw those items out? Because they had Anna's blood on them. And the evidence shows you this because the defendant was researching cleaning. How to clean blood from what floors? Does dishwasher clean blood? Is it possible to clean DNA off knife? The defendant still had a cut on his thumb on January 9th, 2023. And on January 1st, before he even went to Lowe's to buy any cutting instruments, an initial stop that he made when he left his house was to go to Walgreens to buy antibiotic ointment and Band-Aids. Then he went to Vin and Liquors, where the manager identified the defendant, and the defendant threw a bag into the dumpster. Store is closed. The parking lot is empty. He's not yet gone to Lowe's. On January 2nd of 2023, the defendant went to HomeGoods because he had to buy a new rug for that living room to cover the hardwood floor. He did this days before the forensic scientists got to the house and knew that the rug had been changed. Anna Walshe dying a sudden death from natural causes defies common sense. She was in great shape. The defendant told police that Anna was a sturdy Serbian woman. Listen carefully to his recorded interviews, because those are his words after her death, after he killed her. Mark Salvaggi told you that Anna had the highest health rating from the life insurance company. Anna had to complete an interview, have blood drawn, provide her medical records, and the life insurance company and the underwriters gave her this health rating. Anna was an active person who took care of her health. Ashley Semino, her bar instructor, told you about this exercise class that she took the morning of December 31st, 2022. And Anna was the type of person, she said, who made others want to work harder in their exercise class. Will Fastel told you that Anna was very active and did yoga together. Sergeant Amy Waterman described Anna's home gym in BC. And Dr. Atkinson told you about the different ways a person can die, and that it's extremely rare for a 39-year-old in good health to suddenly die of unknown causes. But without a body, it's not possible for the medical examiner to tell you the exact cause of Anna Walsh's death. No autopsy can be done. The defendant deliberately got rid of Anna Walsh's body. The defendant did not want anyone to find Anna's body and to know how she died. So the defendant bought cutting tools at Lowe's and Home Depot, and he cut up Anna's body, the woman that he claimed to love, and he threw her into dumpsters. He was hiding her body. The defendant intended to kill Anna Walsh. He didn't just want her dead, he needed her dead. This was a marriage in crisis, and it was heading towards a breaking point. It began with the defendant's federal case. And through the defendant's interview and his federal probation officer, you learned that the defendant was on home confinement. He was going to have to pay over $400,000 in restitution, and the case had been pending since 2018. You also learned that the defendant had no assets. He told Jamulu that he only made $50,000 to $60,000 that year, but he had told the police that he had businesses that were not making any money at all yet. Peter Capozzoli told you that the defendant's mother had signed the lease for the Cohasset home, and it was his mother that was paying his rent. Meanwhile, Anna was beginning to thrive. The marriage was beginning to deteriorate. Anna had her dream job. She had risen to become an executive at Tishman Speyer, and she was making close to $300,000 a year. She earned a bonus. And Teresa Marchese said that Anna was a good employee. And the defendant knew this. He bragged of her bonus and salary. She bought a townhouse, and she furnished that townhouse for her family, and she set up bedrooms for each of her 3 boys. But the reality was, the family couldn't join her because the defendant needed the children with him. Being the primary caregiver allowed him to avoid prison. The separation of the defendant and Anna was taking a toll. Anna wanted the children with her, and Anna began a relationship with Will Fastow, which became more serious. The defendant and Anna were growing apart emotionally and physically. Anna struggled not having her children and not being able to be the mother that she wanted to be. This got worse when Anna took the trip to Serbia to take care of her sick mother. Anna and Will Fastow spent the Thanksgiving holiday first in Dublin before Anna went to Serbia. And Anna bought her plane ticket with the credit card that the defendant monitored. And the defendant told police that he monitored their joint Chase Freedom credit card statement. The MacBook history also shows the defendant looking at the Chase account. The defendant knew about Anna's travel because in a recorded interview, he told the police that she had a layover in Frankfurt, and that connection in Frankfurt is on the same credit card statement. And you can see that, it's right in front of you. The defendant was angry about Anna missing Thanksgiving. And he mentioned it repeatedly when he spoke to investigators.
I got angry about Thanksgiving, and then I realized it was just sad that we're not spending a lot of time together. And she was sad about it too, and it was exhausting for both of us. She was away from the boys. I was always dealing with the boys.
On a return from Serbia in December, but she only spent one day in Cohasset. And she was supposed to come home for Christmas morning, but she missed her early flight, and she couldn't get a flight, and then she had to drive up. The defendant told police there was an argument.
I did have an argument with her for the Thanksgiving and the Christmas Eve, so I wasn't going to make the same mistake 3 times.
So what did the defendant do on Christmas Day when his wife wasn't home? He looked up Will Festa on his cell phone. The man his wife had just spent the night with. The defendant was losing Anna. Anna was missing her children and wanted to keep them. Anna quickly returned to DC, and on December 27th, the defendant was looking up the best strategies to divorce for a man and the DC divorce laws. This was not to protect assets. That wasn't the search. The defendant told the police that everything was in Anna's name. The defendant had nothing without Anna and the kids. And on December 29th, Anna spoke with General Wu and told him that she was upset about the travel, upset being separated from the children, upset about the defendant's federal case. It was on and on. It was getting to be too much. On December 29th, Anna went out with Alyssa Curtin. And she broke down. This strong Serbian woman who was supposed to be having a fun night out with her girlfriend, going to dance karaoke, instead broke down. Anna told Alyssa that she had told the defendant that he needed to take responsibility for the federal case, go to prison. She wanted the children with her in DC, and she and the defendant had not been intimate close to a year. In Anna's mind, the marriage was broken. Anna even questioned if she could just take the children because she had already established a separate household. She said that she was falling out of love with the defendant. And at home in Cohasset, what was the defendant doing? He was looking up the Mazda building and the FBI raid on the Crossing building. Looking up something that had happened in the spring of 2022 when Anna first started working for Tishman's Fire. Interestingly, this was when the defendant brought up something he brought up in his interviews when he lied about Anna having to leave early for a work emergency. He was planning the work emergency. The defendant was going to lose Anna, and when he lost Anna, he would probably lose his freedom. Anna would have a house in DC and a nice job, and he would likely go to jail. So the defendant pretended. He lulled Anna into thinking that everything was okay. He joked with her about a Porsche. He didn't want her to realize that he was aware of the relationship with Will or her ability to leave him. He wasn't going to let Anna know that she wasn't safe. On December 31st of 2022, the defendant claimed that he could not find his phone. Why is that important? The mislaid phone allowed the defendant to be unavailable for 2 days. The mislaid phone allowed him to carry out his plan uninterrupted. And the mislaid phone allowed him to show the police when he eventually reports Anna as a missing person and not have the police question why he didn't contact Anna earlier. The evidence shows that the defendant was methodical. Just look at how he shopped at Lowe's with a list. He planned it with precision. So Jem Lulu came over for dinner on New Year's Eve, and the defendant told Jem that his phone was lost and it was free. Anna was texting throughout the night, including with Will Fastow. This is now the third holiday where Anna was concentrating on the other man in her life. When Jem left, Anna was alone. She was with the defendant, the man she was cheating on, the man she was telling to take responsibility for his actions, and the man who had her children. The defendant murdered Anna that morning in their Cohasset home. And this is what the internet history shows. His internet history, written words. He was looking at best way to dispose of a body. Better to throw away crime scene clothes or wash them. Crime scene. Can you be charged with murder without a body? Anna was dead. The defendant killed her, and he began researching how to get her money, how to inherit, how to get away with a crime. And he might have gotten away with it, but he didn't know that his MacBook was syncing with his son's iPad, the same Apple ID. His demeanor changed during the interview on January 8th when the police mentioned the searches on the iPad. Not because the iPad involved his children. He had already involved the children in his lives, but because he knew he was caught. We know he had already involved the 6-year-old when he had the 6-year-old say that he saw his mother when she left the house on the morning of January 1st. The son could not have seen Anna leave the house. The defendant had already killed her. Listen to the recorded interviews. During the January 5th interview, the defendant spoke about what his son supposedly had seen. And the defendant involved the 4-year-old by saying that the 4-year-old hid the defendant's iPhone 13 mini. So, the defendant's phone made a reservation at Nightshade Noodle Bar for New Year's Day, after the defendant told Anna that they were going to have a special party. This is ironic because the defendant was very clear with police on January 7th that he and Anna had no plans for New Year's Day, and the defendant also knew that he would be violating the terms of his federal probation by going to a restaurant on New Year's Day. But let's look closely at Exhibit 170 about the Nightshade Noodle reservation, which was on the defendant's iPhone Mini 13, which the defense just said was deleted. And if you look on page 2, on the bottom of one of the bubbles, you will see that the message was deleted on January 1st at 7:59 and 5 seconds a.m. This happens to be one of the times that the iPhone Mini 13 was unlocked when it was supposed to be missing. The forensics show that the defendant's phone was unlocked 4 times and it was plugged in on January 1st. You heard testimony that the phone had a password of 197512. And in the January 4th recorded interview, you hear the oldest child needed help with his iPad password, which was 121212. The children didn't unlock the defendant's phone. The defendant blamed his misplaced phone on one of his children when he said that the children hid it. But it makes no sense that a 4-year-old somehow unlocked the defendant's phone and deleted that text reminder. Listen to the defendant's recorded interview. The deletion is made when the defendant is supposedly making French toast and playing with the kids. The defendant had access to his phone. Context. The defendant also had access to 2 other phones when his phone was supposedly lost. He had Anna's phone and he had the iPhone SE. And in the recorded interviews, the defendant told police that on New Year's Eve, Anna had an argument with a friend, and as a result, Anna put her phone upstairs in his bedroom.
You said she went and put her phone upstairs after that?
After that, she, let's say it's 10 or 15, and then she, I remember her putting her phone upstairs because then she came back down without it.
Was Thomas came down at one point and hung out with you?
Yes. Yeah, exactly.
Was this before, during, or after Thomas was participating?
Oh yeah, Thomas went to bed at he went to bed, and then he came over at like 9 or 10 or something. I think Anna took a bunch of photos. Jem and I don't have any because she didn't send them to us yet. But I think she sent one to Will Fasto. So that was when that's when the photo was taken about. So it was maybe 10 o'clock or something like that.
You know where upstairs she put her phone at that point?
Mm-hmm. Yeah, on her bedstand.
That's not what Jem said. Jem said that Anna was using her phone all night. Melissa Kirby texted with Anna. The defendant was telling investigators a story about Anna's phone. How else do we know that the defendant intended to kill Anna and had a plan for doing so? Look at his internet history. Look at what he did. The defendant set up an area in his basement where he surrounded it with plastic sheeting or a tie-back suit and dismembered his wife, the love of his life. Hacksaw, the best tool for dismembering a body. Then the defendant got rid of Anna's body. He got rid of her belongings. He got rid of her clothes and bag that he told police that she had, that she supposedly left on January 1st. He threw her in the garbage bags, tossed those garbage bags in different dumpsters, disposing of a body in the trash. Chatham West apartment rental, the Claremont apartment rental. And police confirmed this with the location data from the SE phone and the iPhone 13 mini. The evidence shows that the defendant did this to hide the fact that he murdered Anna. He could not let Anna's body be found because Anna didn't die of natural causes. The defendant murdered Anna, and then he had to hide the evidence of his crime. In his mindset, within his internet history, want to get away with murder, use a special detergent. Can you be charged with murder without a body? Best way to dispose of body parts after murder. When you deliberate, look through the binder of the MacBook internet history. There are no searches of natural causes of death, sudden death, heart attack, aneurysm, stroke, or how to help your children when someone dies unexpectedly or goes missing. The defendant was not sad. Look at his demeanor in the surveillance videos. He's cool and calculating. He's calm. He had a plan. On January 1st, he went to the Lowe's store an hour away, even though there were hardware stores approximately a mile from his house. And when he was in Lowe's on January 1st, he wore a mask and he wore gloves and he had a list of what he was shopping for. He was calm as he helped bag the purchases. A hacksaw, buckets. He used cash. Does this show confusion, panic, or fear? But he doesn't stop there. He went to CVS to buy hydrogen peroxide. And then he went to Stop and Shop to buy ammonia. No wonder the house was so clean. And on Monday, January 2nd, he went to Home Goods for rugs and handles. And then he went to Home Depot, where he had bought buckets with lids this time, baking soda, and a hatchet. And at some point that day, he got a call from his probation officer. And he lied, and he said that he was picking up his children. He was able to calmly speak with her. No panic. He had everything now that he needed to dismember the woman that he supposedly loved. And he started to take her body and to throw it in the dumpsters, because he had to cover up the crime to get rid of the evidence of the murder. This was not a man in crisis. This was a man who on January 4th went to TJ Maxx to buy pants with a store exchange card. He was calm. But Alyssa Kirby texted him on January 4th asking about Anna. And so he called Tishman's Fire a few minutes later and started to pretend to look for her. He called Will Fastel, but he didn't leave a message. He called back later, and then he calmly left a voicemail. No panic. The defendant knew where Anna was. The defendant even texted Anna's sister in Canada and said that she was missing. He was methodical. Look at the text messages. And at 4:30 p.m. on January 4th, the defendant went to Lowe's to buy a trash can. Comfortable. Not compact. The police were coming to the house soon to talk about Anna. And the defendant had the house ready. The police think his wife is in D.C. He had his phone ready, and he sent text messages to Anna, even though he knew she would never see him. Despite everything that he had done, on January 2nd, the defendant wrote a text message to Anna. I still love you. Ha ha. Miss June. The defendant prevented anyone from ever finding Anna's body, and there was no autopsy. Dr. Atkinson told you that the medical examiner can't do an autopsy without a body, and all that remains of Anna are a few hairs, some blood, and a few things that belong to her. Part of a necklace she often wore, her hunter boots, a black jacket, a purse, her COVID card, and a few other items in the dumpster in his mother's apartment complex. The defendant searched his MacBook for a murder conviction without a body. Please do not allow the defendant's self-serving act of dismembering and disposing of Anna's body to let him get away with this murder. At the start of this trial, we asked you to use your common sense. When you do that, when you analyze the evidence as you deliberate and think will see that the evidence shows there is only one verdict. Find the defendant is guilty of the premeditated first-degree murder of Anna Walshe. Thank you.
I will see counsel at the side of the bench. George, you're my guidepost. Do you need a break for the bathroom? Okay. All for one for all. Give you a break for the bathroom. Let us know when you're ready to come back out. I'll be at your disposal.
All rise, please. Jurors, follow me.
Seated. I will give you a quick break as well, but something's been on my mind that I want to discuss now that the closing arguments are over. And that is, I had asked in connection, this relates to the sentencing, at least for the other two counts, and asked the Commonwealth to provide victim impact statements for any immediate family members of Anna Walshe that wish to provide information. And I haven't received that yet. And there might be a good reason for that. I had told you that I was putting off the sentencing until we had a verdict on the charge of murder. But now that it's a Friday and I don't want this to linger over into the next week, has the Commonwealth heard back from the Department of Children and Family Services?
Your Honor, we've been in touch with them. They are working on their impact statement. They were hoping to have the impact statement impounded. And I can, as soon as we're done here with the charge, I will speak to the attorney that I've been dealing with. They've been working very hard on this. They're certainly worried about their privacy interests of the children and the
I think there's a valid privacy interest of the children, and I'm highly likely to impound it, obviously, with the exception of counsel for both sides being able to see it so that they can make appropriate arguments as a result of the victim impact statement.
I think the department will be very happy to hear that. And they also, much of what they have is through a social worker privilege, so they're concerned about that as well. But as soon as we break, I will be happy to have that conversation.
Well, I'm happy to hear that there's forward progress because I guess I assumed, because I hadn't heard anything, that you were still not getting the answers to the questions you were asking.
No, quite the opposite. They've been working very hard on this.
All right, I appreciate that.
Thank you.
Anything anyone needs before I step off the bench briefly? Thank you.
All rise.
Okay, guys, sorry about that. I had some sound issues. I had to reboot my sound. Thank you so very much, everybody. What are your thoughts on the closing? What are your thoughts? There will be no rebuttal because the prosecution has the option of going. Let me do this since court's on break. There we go. Yep, me. Yep. Okay. The prosecution has the right to go first and split their time, and then the defense goes. What is that noise? Diane, what is that ringing? Okay, it's Diane. There was some ringing noise. She's giving me back my ears. Okay, so the defense has a burden of proof, so they can split their closing into two parts. They can do some before and then some after. The prosecution has the burden of proof, so they can go, and then the defense can argue, and then they can come back and do a closing. Or if they choose, they can go after the defense, but they have the right to choose the order in which they go because they have the burden of proof. So this strategy was they decided to let the defense go first, and then they would follow up with their full closing. Interesting strategic move on their part this morning. I actually was not anticipating that. Y'all, something just came up and I want to share this. I'm afraid to share this, but I think we need some levity. So I'm going to share this. You ready? Are you ready? Look at these women on these bulls. And no, this is not AI generated. Yeah, that's what I'm hearing. Okay, I'm hearing her phone over there, or I'm feeling it. That's no problem. I need to tell you guys, there are different universities. Oh my gosh, y'all. That woman can ride a bull. Look at her. Okay, here's Sooners. Oh, you Sooners. She didn't do so well. She all but got knocked out. I had to, it popped up on my feed. It was just something that caught my eye, and I'm like, I had to. I think it's better got the prosecution to lay their closing so that there's no need for rebuttal after the defense closing arguments. I kind of agree with you on that. It's unusual. It doesn't happen often, but I agree. I think that in this situation, if I was the attorneys, I would want to know, I would not want to start. I would let the defense go first, so I knew what I had to argue. I sometimes think that prosecution kind of put themselves behind the ball because they don't let the defense go first, so they'll start their argument. They have no idea what what is going to be argued in the defense, so they just ramble on what they think they need to say, and then the defense goes, and then they have to come back and fix things. That is my humble opinion. I've seen it that way. I actually prefer to listen to the defense. I think if I was an attorney and hear what they were going to say, then I can target my closing according to them. Less work on my plate. Yeah, in my humble opinion, the state proves their case. I can speak for myself. I have no reasonable doubt in my humble opinion. He is guilty. Case one, you can go back and rewatch. But I felt that I appreciate prosecution or any attorney who can just get to the point and obviously not concerned about listening to themselves talk. I hate an attorney that rambles on for hours and hours and hours. What case was it, June? Do you remember that they did the prosecution did two days of closing? Yes, I have seen many rodeos in the Astrodome. I was Miss Daughters Republic of Texas. I went to the San Antonio Rodeo, the Houston, and the Dallas Rodeo with a crown on my head. Oh, that's interesting. Had someone bring me a blind pug doll. Are you keeping it? Huh. Okay. We're going to catch up.
Yes, please. I just so it's on the record, everybody saw the small edit I made to the verdict slip and everyone's fine with it. Is that right? Everyone's not. Thank you.
2 days of closing arguments, and opening arguments was just as bad. 2 days of closing and opening on
All
each.
rise to the court, please. Jurors entering.
Monica Simatilli in California. That's it, Miss June.
Court is back in session. You may be seated.
Welcome back, jurors. Jurors, I'm going to go through the remainder of the instructions, the final stage of this case before you will get the case to deliberate. The intent of the second part of the instructions is to give you some assistance in determining how you go about deciding whether the Commonwealth has proven each element of the indictment is true beyond a reasonable doubt. For the charge, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of the charge. You may not find the defendant guilty on the charge just because you think the defendant did something else that was wrong or improper. Your decision as to the charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip. When all 12 jurors agree on the verdict, the foreperson should check off that verdict and then sign and date the slip.
Here, babe. Here.
In a little while, I'll go over that verdict slip a little bit more. For the charge, if you all agree that the Commonwealth has proved every element of murder beyond a reasonable doubt, then you should find that Mr. Walsh is guilty. On the other hand, if you all agree that the Commonwealth did not prove one or more of the elements of murder beyond a reasonable doubt, then your verdict must be not guilty. Let me talk about your role. Jurors, you have the most important role in this trial because you will decide who and what to believe and whether the Commonwealth has proved Mr. Walsh's guilt beyond a reasonable doubt. You must be completely fair and impartial and unbiased in your work as jurors. Do not let your emotions, any kind of prejudice, or your personal likes or dislikes influence you in any way. Consider the evidence calmly and carefully. Do not be influenced by the nature of the charge or the possible consequences of your verdict. And do not let your personal feelings about any person, criminal charge, or anything else influence your decision. All parties who come before the court stand as equals before the bar of justice. That a case is brought in the name of the Commonwealth does not entitle the prosecutor to any special consideration. Your verdict must be based on the law as I have given it to you, and on the evidence and the facts as you find, and nothing else. By contrast, my job as the judge is to impose sentence if the defendant is found guilty. Therefore, you are not to consider the sentencing consequences of your verdict at all. That's not your responsibility. So please put any issues about sentencing
out of your mind. Let me next talk about evaluating the evidence. You must decide this case based only on the evidence that was presented at trial. You may not decide this case based on anything else. Do not consider anything you have read, heard, or seen outside of this courtroom. Those things are not evidence, and you may not base your verdict on guesswork, speculation, or suspicion. Let me talk to the important topic of the defendant not testifying. As you know, Mr. Walshe did not testify in this case. You may not hold that against him. Mr. Walshe has an absolute right not to testify because, as I've explained, he is presumed to be innocent and does not need to do anything to convince you that he is innocent. It does not matter why Mr. Walshe did not testify. It's not relevant to what you must decide, which is whether the Commonwealth has proved, based on the evidence presented at trial, that Mr. Walshe is guilty beyond a reasonable doubt. The fact that Mr. Walshe did not testify is not evidence. You may not consider it or even discuss it in deciding this case. Let me next talk about witness credibility. During this trial, you've heard from a variety of witnesses. With reference to any and all witnesses who have testified before you, you have wide latitude. As a jury, you can believe every single word that a witness says on the witness stand, or you can disbelieve every single word that a witness says on the witness stand. You may decide to accept parts of a witness's testimony and to reject other parts of his or her testimony. That's for you and you alone to decide. If there are any conflicts in the testimony, it is your function to resolve that conflict and to determine where the truth lies. In evaluating the credibility of witnesses, you may use various tools. You may consider the ability, the opportunity, and the reliability of the witness to see or hear something in the past, and then remember and later testify about it before you in this courtroom. You may consider the conduct of the witness, his or her manner of testifying before you, any inconsistency you may have found in the witness's testimony, any interest the witness may have in the outcome of the proceedings, any bias or prejudice or hostility the witness may have demonstrated while testifying before you, the level of accuracy of the witnesses testifying before you, and the reliability of the testimony as it developed before you. These are some of the tools that you have at your disposal to resolve disputed issues of fact in this case. There's one more point about witnesses that I'd like to specifically address, and that's expert witnesses. This term refers to witnesses who have specialized training or experience in a particular field, generally in cases that are tried in our courts, both civil and criminal. Witnesses may testify to facts that are within their own personal knowledge. That is, things they've personally seen or heard or felt. However, in a variety of cases, this one included, issues arise that are beyond the experience of laypersons. And in those types of cases, we allow a person with specialized training or experience, we call them expert witnesses, to testify not only to the facts, but to their opinions, the reasons for his or her opinions on issues that are within the witness's field of expertise and are relevant and material to the case. Because a particular witness has specialized training and experience in a field, doesn't put that witness on any higher level than any other witness. And you are to treat the expert witnesses just like you would treat any other witness. In other words, as with the other witnesses, it's completely up to you to decide whether you accept the testimony of the expert witnesses, including the opinions that those witnesses gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and to decide what conclusions, if any, you draw from the expert's testimony. You are free to reject the testimony and opinion of such witness in whole or in part if you determine that the witness's opinion is not based on sufficient education and experience, or that the testimony of the witness was motivated by some bias or interest in the case. You must also, as has been explained, keep firmly in mind, jurors, that you alone decide the facts. If you conclude that an expert witness's opinion, not based on the facts as you find those facts to be, then you may reject the testimony and opinion of the expert in whole or in part. You must remember, jurors, that expert witnesses don't decide cases, juries do. In the last analysis, an expert witness is just like any other witness, in a sense that you alone make the judgment about how much credibility and weight give the expert's testimony and what conclusions you draw from that testimony. Let me next talk about graphic photographs. The Commonwealth has introduced certain photographs showing items taken from various trash bags retrieved from 300 Forest Street, Peabody, during the investigation of this case. You will have those photographs with you during your deliberations, as all the evidence will be with you during the deliberations. Some of those photos, as you've seen, are not pleasant. Indeed, some may be described as graphic. I instruct you that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by those photographs. Related to this, sometimes evidence is presented that produces in jurors an emotional response. For example, it is natural and understandable to feel sympathy and empathy when you hear or see testimony that suggests what might have occurred to Anna Walsh's body after her death. But as jurors who have taken an oath to follow the law, I instruct you that you must separate any emotional response or reaction on your part from the informational value and weight of the evidence. You must not be influenced in any way by the nature of some of the testimony and video evidence. You must find the facts in this case based only on the evidence. You can't find facts or base your decision, again, on sympathy, anger, passion, or prejudice, or pity for or against either side in this case. Rather, again, jurors, your verdict must be based solely on the evidence in this case and my instructions on the law. So what is evidence? I told you earlier that repeatedly that you must decide this case based only on the evidence presented at trial. The evidence consists of the testimony of the witnesses, as you recall it, the things that were marked as exhibits, and the stipulations, or I told you those agreements of the parties, which I read into evidence. You will have the exhibits with you in the jury room. Things that were marked for identification aren't exhibits, so don't be looking for those. And you will, because they're not exhibits, and you won't be able to consider them. Other things that are not evidence and you may not consider when deciding this case are as follows. The fact that the defendant had been indicted and charged with a crime, not evidence. Questions that the lawyer asked of a witness are not evidence. Only the answers given are evidence. For example, if a lawyer asked, wasn't it raining outside? And the witness answered no, or said, well, it was cloudy. The question is not evidence that it was raining. If a lawyer asked a question and I sustained an objection and therefore the witness didn't answer it, then neither the question nor the fact that the witness did not answer is evidence. I struck or told you to disregard any part or all of an answer by a witness, then the part of the testimony that I struck, not evidence, you may not consider it. Anything that you may have seen or heard when the court wasn't in session isn't evidence. The opening statements and closing arguments of the lawyers are not evidence. And if your memory of the testimony differs from what the attorneys said in their closing arguments, you should rely on your memory. Any notes that you've taken, they're not evidence, but you may use your notes to refresh your memory of the evidence.
Well, you could be listening to me in the background.
As you know, evidence can come in many forms. It can be
I got all kind of books down here. You can look
testimony about what someone saw or heard or smelled or felt. It could be someone's opinion. and it can be an exhibit. Whether the evidence is direct or circumstantial, sometimes we call that indirect, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all of the evidence in the case. Some evidence proves a fact directly. For example, if a witness testifies that he saw and felt it raining outside,
I
before
gave
he
a
came
lot
into
to my
the
sister.
courthouse, then that's direct evidence.
We see them, I had them, and I got them all back.
Some
But
evidence
those
proves
snap
a
back
fact
there's
indirectly,
$6.
circumstantially.
I know.
For example,
I
let's say a witness testifies that he saw someone come into the courthouse wearing a wet raincoat and shaking water off of an umbrella. That's indirect evidence that, if you believe it, might lead you to conclude that it was raining outside, even though the witness did not see, hear, or feel the rain. This kind of indirect evidence does not directly prove something is true, but it is evidence from which you could logically conclude that it is. We call this drawing an inference. We all draw inferences every day. We take some known information, we apply our intelligence and common sense.
You like this one?
Then we reach a conclusion. But inferences must be based on facts. They can't just be guesses that you make when you're not sure about something.
Now you'll have to go to office.
Sometimes you can draw more than one inference. Also, you may draw an inference even if it is not necessary or inescapable, so long as it's reasonable and warranted by the evidence. You have to decide, jurors, which inferences are reasonable and decide which seems more reasonable to you. It makes no difference whether evidence is direct or indirect. Commonwealth may be able to prove a criminal charge with direct evidence, indirect or circumstantial evidence, or a combination.
Now look at these over here. And then
We next talk about credibility. An important part of your job as jurors is to decide who and what to believe.
This was my very
You may believe everything a witness says, part of it or none of it. Sometimes people do not tell the truth. You must decide whether a witness was being truthful or deliberately lying. If you conclude that a witness lied to you about something, then of course, you should not believe that.
own on it. Charges. Oh.
Sometimes people make an honest mistake. You must also decide whether a witness testified accurately or whether the witness may have gotten something wrong without meaning to do so. A witness may recall seeing or hearing something but actually be mistaken. For example, the witness might not have paid close attention or might have misunderstood what was happening. Or a witness's memory of what happened.
This is my sister's because I didn't have the.
If you conclude that a witness tried to be truthful,
I don't
that
use
some
this
part of
pen
that
here. You want a
person's
pencil?
testimony was inaccurate.
I'm a pen
then
snob.
you should not
Pencil
consider
snob.
inaccurate.
You can't tell by looking at all these.
How do you decide whether you believe the
I'm a
statement by a particular
That's the
witness?
brand.
Well, ask yourself, did the testimony seem reasonable or probable? Did the witness have a good chance to observe what happened? How much attention did the witness pay? Did the witness's memory seem accurate? Was the witness's testimony consistent with other evidence or instead contradicted by other evidence? How did the witness behave and answer questions while on the witness stand? Did the witness have any motive for testifying in a certain way or have any other bias that may have influenced the witness's testimony?
Right now, I'm not.
You should evaluate the testimony of a police officer or someone else who works for a law enforcement agency in the same way as you would evaluate anyone else's testimony. You must not automatically believe or automatically disbelieve a witness just because a person is a police officer. Moving next to the importance or significance of evidence. It's up to you, jurors, to decide how important each part of the evidence is, whether it's testimony by a witness or an exhibit.
What is the verse of the day?
Evidence is direct or indirect. You should give each piece of evidence whatever significance you think it deserves. You're not required to believe something simply because it appears in an exhibit. It's up to you to decide how important any exhibit is. You do not have to treat testimony by a witness as more or less significant than the exhibits. You may find that a witness's testimony is very important. or that an exhibit is more important. That is up to you. Next, I want to talk about the alleged victim's state of mind. You heard evidence of statements Anna Walshe allegedly made to William Fasto, Jem Bootlew, and Alyssa Kirby. Those statements are admissible for the limited purpose of establishing Anna Walsh's state of mind, as may be relevant to the defendant's motive or intent to kill. Those statements cannot be considered as proof of the criminal acts charged or as proof that the defendant had a bad character or a propensity to commit any criminal offense. Let me next talk about motive. First, motive is not an element of the offense of murder, and the Commonwealth is not required to prove or show motive. Evidence of motive can be relevant to the issue of intent. Second, an absence of evidence of motive may tend to raise a reasonable doubt. Third, even a total lack of evidence of motive would not necessarily raise a reasonable doubt as to the guilt of a defendant, so long as there is other reasonable doubt. Let me now move to the area of something called consciousness of guilt. I spoke earlier about inferences and the drawing of inferences from indirect or circumstantial evidence. At this point, I want to talk about a particular type of inference based on a legal doctrine called consciousness of guilt. In the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest and that he may have taken steps to conceal Anna Walsh's body after her death. I want to stress to you that I'm not suggesting that he did so, or that you should find that he did so, but only pointing out that there was evidence to that effect. It's up to you to decide what evidence to accept or reject, and what facts to find from the evidence. I point to that evidence to illustrate the legal point involved. If you find from the evidence that the Commonwealth has proved that the defendant provided false information to the police and or took steps to conceal the body of Anna Walsh after her death, then you are permitted to consider whether such actions indicate feelings of guilt by the defendant, and whether in turn such feelings of guilt might tend to show actual guilt on the charge. You are not required to draw such inferences, and you should exercise great caution and do not do so unless they appear to be reasonable in light of all the circumstances in this case. You should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, or such feelings are sometimes found in innocent people. If you decide that such inferences are reasonable, it's up to you to say how much importance to give them. But remember that such evidence is never enough by itself to convict a person of a crime. You may not find a defendant guilty based upon such evidence alone, but you may consider it along with all of the other evidence in this case. Next, I want to speak to impeachment by the defendant's prior or subsequent bad acts. The only charge the defendant is now facing is the charge of murder. You have heard mention of other acts allegedly done by the defendant, namely, that he was charged in 2018 and sentenced in 2024 in a federal case involving art fraud, and or that he lied to the police and/or that he disposed of the body of Anna Walshe, and/or that he lied to his federal probation officer. You may not take the defendant's prior or subsequent acts as a substitute for proof that he committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. You may consider this evidence solely on the limited purpose of the motive, state of mind, intent, plan, or absence of mistake or accident on the part of the defendant. You may not consider this evidence for any other purpose. Specifically, you may not use it to conclude that if the defendant committed these other bad acts, that he must have also committed murder. It would be extremely unfair to consider this evidence for those purposes. Moving next to your notes. Many of you have taken notes during this trial. Your notes may help you remember the evidence, especially the testimony, but of course they're not an actual transcript or official recording of what was said. So use your notes only to help you remember what you saw and heard in the trial. Whether you took notes or you did not, you must rely on your own memory of what the witnesses told you. After the trial is over and you've returned your unanimous verdict, the court officer will collect your notes and I will order that they be destroyed. During the trial, the lawyers occasionally, as was appropriate, objected to questions posed by the witnesses. They may have asked to strike something or, in essence, erase something you saw or heard. When a lawyer believes that something would violate those rules of evidence we've talked about from the beginning, that's the only way they have to let me know. And so don't hold it any against the lawyers that they made such objections. It's part of their job. I want to next turn to fairness. Each of you has taken an oath and promised to be fair, and I'm sure you want to be fair, but that's not always easy. Part of being fair is being willing to examine your decision-making process to be sure that you base your decisions as jurors only on the evidence and the law. One difficulty comes from our own built-in expectations and assumptions, and they exist even if we're not aware of them. We all have them simply because we're human beings. They affect our actions and decisions without us even realizing it. As a judge, I have the same problem as everyone else. So let me share a few strategies that I found to be useful. These strategies will help you make sure that you decide this case based, again, only on a careful examination of the evidence and on the legal rules that I'm teaching to you. First, slow down. Do not rush to a decision. Take time to consider all of the evidence. Quick decisions are more likely to reflect stereotypes or assumptions about people that we might not even be aware of. Second, as you start to draw conclusions, consider not only the evidence that supports your conclusions, but also think carefully about any evidence that undermines or weakens those conclusions. Third, as you think about the people involved in this case, ask yourself, would my decision be different if the people were different? For example, what if the people involved were from different social or economic groups, or different ages, genders, gender identities, or sexual orientations, or came from a different racial or ethnic background? Fourth, listen to each other. Other jurors may have different points of view. If so, they may help you make sure you're focusing on the facts. Of course, other jurors could be influenced by their own unstated assumptions. So don't hesitate to share your views. You should participate actively, particularly if you think other jurors are overlooking or undervaluing evidence that you think is important. When you explain your thoughts to your fellow jurors, you help everyone focus on the evidence. If you do these things, then you'll play your part in reaching a decision that's as fair as is humanly possible. And that's your obligation as jurors. Now I'm going to move to giving you some instructions about how to conduct your deliberations. Privacy. The first point you need to know is that you must keep your deliberations secret. You should not tell anyone outside of the courtroom not even me, anything about your deliberations. For example, please do not tell me or anyone else the results of any votes that you may have taken before you all agree on a unanimous verdict. You must not tell anyone about how your discussions are going or what other jurors are saying. If you need to communicate with me before you reach a unanimous verdict, you should send me a written note and a form that you all agree on. The court officers have it. It must be signed by your foreperson, and I will discuss your note with the lawyers, and then I will either send you a response in writing, more likely, or bring you into the courtroom, less likely, and respond to you in person. If you do send me a note, do not mention any votes that you have taken or anything else about your deliberations. Do not talk about this case unless all of you are present and no one else is in the room. If one of you needs to leave, even for a moment, the rest of you should stop deliberating until that juror returns. That includes the bathroom breaks, because I know that's right inside your spot. If we break for the day without you reaching a unanimous verdict, you must not communicate with the other jurors about this case until the next day, only after we gather in the courtroom and I ask you to resume your deliberations. As you work to decide this case and until I accept your verdict, you must not communicate with anyone else about the case except each other. And you must not do any kind of research about this case. You may not do so in any way, including with electronic devices, a cell phone or a tablet. This also will apply to the alternate jurors. We talked about those alternate jurors. The law permits only 12 jurors to participate in deciding a criminal case. There are 16 of you here. So in a few moments, our clerk is going to randomly select 4 of you to be what we call alternate jurors. The other 12 of you will work together to decide this case. We chose 16 of you originally in the case, just in case one or more of you got sick or needed or had some other unexpected emergency. If you are chosen as an alternate, your continuing service is still very important, and you must comply with all of the rules that I placed on you. The alternate jurors will stay in another room, and you can't have your own private deliberation. You can't discuss the case with each other or with anyone else for obvious reasons. If we lose a deliberating juror in the group of 12 because of some personal emergency or sickness, then I will send one of the alternates into the jury room. If this happens, the deliberating jury will have to restart its discussions from the beginning. One of you is going to serve as the foreperson of this jury, and we will discuss who that foreperson is going to be in a moment. Foreperson will make sure that each of you has the chance to speak and that the other jurors listen to you respectfully. But the foreperson's opinion about the case is no more important than the opinion of all of the other jurors. Once you agree on a verdict, the foreperson will fill out the verdict slip and will report your verdict in court. I want to next talk about making decisions as a group. When you work together as a jury, you will be making decisions as a group. This kind of decision-making is very valuable. Why do I say that? When a jury hears and sees evidence, each juror acts as a safeguard for the others. For example, someone else may recall evidence that you missed, and each of you will have insights that will help the other jurors make sense of the evidence and reach a verdict. No member of the jury is more or less qualified than any other juror to decide who and what to believe. You've all heard the same evidence, listened to the same witnesses, and looked at the same exhibits. And you have all taken the same oath, promising that you will, well and truly, try the issues between the Commonwealth and the defendant according to the evidence and the law. So, you are all equally qualified to reach a verdict. I have a few more suggestions that might help you work better. Taylor. First, you should discuss and analyze the evidence before you take any votes about a verdict. Voting first could keep you from discussing the issues and hearing other people's perspectives before making up your own mind. Second, I encourage you to discuss not only the evidence you think supports your view of the case, but also what evidence you think might lead you to make a different decision. Third, as jurors, and as the other jurors talk about the evidence that they found important, listen. In order for this process to work fairly, each of you should hear every other juror's insights and ideas. Please be open to them, since they might influence your own thinking. Fourth, don't be shy. As in any group, some of you may feel more comfortable than others sharing your thoughts, but you must have the benefit of everyone's input to help you reach a just verdict. For example, you may be the only one that remembers a particular piece of evidence or has a particular point of view. The more points of view that you all hear, the more effective your deliberations will be. Fifth, don't be afraid to change your mind if the discussion persuades you that you should. But you should not accept a decision just because other jurors think it's the right one. In the end, you should vote based on your own assessment of the evidence, regardless of how other jurors have voted. Ultimately, jurors, each of you must decide this case for yourselves. One last pause to consult with the attorneys. So I talked to you about a four-person, and I talked to you about what we call reducing the jury. That is, reducing you down from 16 to 12. I'm appointing juror number 138 in seat number 6 as the foreperson of this jury. Our clerk is now going to randomly select 4 of you from among all the jurors except the foreperson to serve as alternate jurors. So what's physically happening is juror number in seat number 6, juror number 138's number is coming out of the thank you, Madam Clerk.
Your Honor, numbers 1 through 16, with the exception of number 6. Your Honor, our first alternate is the juror in seat number 12.
Grab me the notebook and the Solomon.
Our next juror, our alternate is the juror in seat number 5. 5. Juror in seat 15. And our last alternate, Your Honor, is juror in seat number 11.
One last substantive thing that I want to go over with you jurors before I really get into finally the concluding remarks. And that is, I said to you earlier in this second part of the charge that I would go over the verdict slip. There is a verdict slip, and I know that you can't, unless you have stellar vision, you can't see it from where you are, but you can get the layout of it. I'll read it to you. The verdict slip reads, count 001, on or about January 1st, 2023. And it puts the charge, murder in the first degree with deliberate premeditation. That is the charge. We, the jury, find the defendant, and there are three options. Not guilty, guilty as charged, murder in the first degree, guilty of murder in the second degree. And there's a place to sign it and date it. And again, the foreperson in pen, not pencil. This time, Madam Clerk, I'm going to ask you to swear in the court officers.
Raise your right hand. Please do solemnly swear or affirm that you will take charge of this jury, keep them in some secluded places where they can be. You shall not speak to them or suffer anyone else to speak to them except by order, the court will ask that they be so.
I will.
So now the deliberating jurors, the 12 of you, are going to go and start with private discussions. Have confidence in what you are about to do. By serving on this jury, you carry out a long and proud tradition of citizens of the Commonwealth of Massachusetts serving on jury trials and deciding criminal cases. If you are honest, thoughtful, and fair, you will be able to reach a fair and just verdict, dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in the courtroom during this trial. All we expect from you jurors is that you decide this case with integrity and principle. And with that, I'll ask you and let you go back to the deliberation room to begin your work. Thank you very much.
Court, all right, please. Just take your notebooks with you and follow me.
Ladies and gentlemen, we are now going into verdict watch. Finally. That said, I will have to say that we were supposed to be in a 3-week trial and we only did 10 days and no defense was put forth. This was much quicker than we anticipated.
So I will, as I said to you at the side of the bench, there's some small edits necessary in fact. You may see some small edits that I made to the instruction, and I'll make those now, take the draft off, make sure the numbers are all right for the index that goes down with them. Anything else that the parties need to bring to my attention before I do that?
We received materials to secure those items, and we're going to work
Oh,
on
can I
that.
see that? Are they secured yet, or you're going to?
We're going to secure them. I haven't had the opportunity yet.
All right, let Madam Clerk know when that's done, because I do want to take a look at those before they go in, and of course, our court staff as well, court officers, want to take a look at those to make sure that they're comfortable with what's going on.
And we thought we'd cut up pieces of parchment paper for the jurors if they need to examine anything that they can place on the table.
Do you have a roll, they can do it themselves?
We have a roll. We can give them scissors if you want.
Well.
I think that's why I put that out there.
All right.
Thank you.
I think you're pretty familiar that I have a 10-minute rule, which means at all times, Madam Clerk should be able to return to the court within 10 minutes. All right. I won't take it further between the hours of 1 and 2 on any day. Give the opportunity to tend to your other work.
Thank you, Ron.
All rise.
Okay, everybody, as you all see, we are on Verdict Watch, and I've done two polls. The first poll was which was the better closing,
On
and
this.
the totals are the Commonwealth was 86%, and the defense was 14%. We have another poll going right now, and how long the jury will be out, and 0 to 4 hours, 5 to 10 hours, or 10 hours plus. So let us know. And I'm going to say I have to leave now. So you all have a good day. And Ada, it's all yours.
Hey, Miss June, hold on, Joe. Miss June, I have Joe on the phone. We're going to get him on. When do you think you can hop on, Joe?
Give me.
Okay, we're going to wait 5 minutes, y'all. Joe Schmo is going to hop in. We're going to use his feed for the E.M. Mitcham trial, and we're going to start that during the verdict watch. Is that good with you, June? So we don't have to switch feeds.
Yeah, that's great.
See you in a minute, Joe.
All right, see ya.
Okay, go ahead, June.
That's what. Yeah, that's wonderful. I was just saying, the totals on the poll, the fact that we got another poll up, and I just wanted to say, I'll see you all when I get back. But yeah, that's great, and you have a wonderful time going up to San Angelo and your graduation, because I probably won't see you or talk to you until after the ceremony. And go Navy!
No. I'll talk to you later tonight. Go Coast Guard! Oh, I know she's going to be streamed. Yeah, this is how much my mod loves her Navy. The Navy Army game is the same exact time as my graduation. And on my Discord, she is not going to stream my graduation live. She's going to stream the Navy Army football game. And then after that game, stream my graduation. Go figure. That's okay. She's a fabulous mod. She can do it anytime she wants. So Joe Schmo is going to hop in the house, and he's going to share his feed. He's going to be monitoring the live. I've got a 2.5, 3 hour drive ahead of me. I've got graduation events I have to go to this evening and afternoon, and thus he's going to take over until my mods return. So y'all be nice to Mr. Joe Schmo. He's my brother from another mother and father. So be nice to Mr. Joe Schmo when he gets in here. I thank everybody. Thank you so much. Let me give you an update on my dad. Let me get y'all removed. Let me give y'all an update on Dad. He had a blockage in his small intestine that was so blocked that fecal had gone it stretched his stomach to the maximum. He backed up that bad. It was kind of creeping up on the esophagus. And it was so horrible. They had to put a tube in and suction all that out. And they did not want to do surgery. He's going to be 91 years old on December 28th. So what they did was trying to let nature take its course as best as possible. And it did. And he had movement last night. Hallelujah. So it looks like we have avoided surgery. That is a brutal surgery for anybody, much less a 91-year-old man. So we have some improvement. Now his strength is really weak. He's very weak. So I just ask for prayers for continued recovering and return of strength. So thank you all so very much. I want to say congratulations to all those who are graduating college this time of year. We don't seem to get as much acknowledgement or recognition for the December graduates as you do for the May. So, all of those who have people graduating this time of the year, congratulations. You did a great job. And I just bless you on your next part of your journey. I will be having a lot of pictures taken, hopefully videos of some of the traditional events that I'll be doing. So I'll share everything when I get back. I'll create a little video. I am still waiting for Joe Schmo to pop in. Oh, congratulations, Ari. I don't know. I just noticed that the fall graduates, you don't see as much about that. It's almost like unless you're graduating or have a graduate, it's off the radar, and that's okay. Thank you so very much, y'all. I've had 2 sisters die in a year, and a brother-in-law die. Sister Tracy died, brother-in-law died. Everybody's dying. Nobody else will die this year or next year. Hey, Joe. I'm going to add him in here. Hey, Joe, can you say hi?
I can say hi. Should I say hi?
Oh, there you are. Just making sure you're live. Joe, thank you so much for doing this. I'll go ahead and share your screen for the Ian Mitcham trial so we can get you
All
going.
right. Here we
Because
go.
I've got less than 30 minutes to get packed up and on the road. Okay, I'll let you add the stage. I'll let you take over. You guys be blessed. Have a wonderful, wonderful weekend. I will definitely I will be monitoring this from the car. So you'll see my avatar up and I'll be monitoring. So anyway, Joe, can you add to stage or do I have to?
You have to do that. I can't do that.
Okay, so we're going to add to stage. Oh, I got to take that down. Now see if you can add to stage.
Nope. There you go.
Okay. Now can you play?
Yep. Here we go.
Okay. All right. Just pause it for a sec. And we're going to do a sound check and everything in a minute. But I'm going to say is June, and then we'll be back in a few hours. So this should get you through. I don't know how long this video is. Do you?
5 hours, 5.5 hours.
Okay, great. So this will get you through. I am going to leave my jury's deliberation clock up in the background here, and I should be able to hop in on my iPad if we get a verdict before my mods come back.
I think we probably will. If I'm on that jury,
or you can share, or you can stop this and we'll figure it out. But I'll be monitoring everything.
Yeah. What are you using for your source for that trial?
Well, trial? We got Long Crime or Court TV. I prefer Court TV.
Yeah, I do too. They never copyright strike people for using their stuff that I know of.
No, but the others do. Okay, I got a gong. That means he needs to cover the red room word. What do you mean? No, we're fine. We're fine. June, we're okay. I'm going to put up the Ian Mitcham. I don't think I have that, so I'll do this. Yeah, it's not going to cover it, June. Nothing we can do. Oh, she's worried about the red room word.
It's part of the court process, though. I don't think you'll get in trouble for it. I really don't.
That we won't get in trouble for, but if we say it too many times, sometimes the demonetization happens.
Yes, right. That makes sense.
So I have in my background the verdict watch running from Court TV. So if I need to, I can switch over to that. Oh my gosh, y'all, we're going to switch. Oh my gosh, I want you to see this guy. Look at those glasses. This guy has all these weird colored glasses. I love him.
He does. He's a character.
Quirky as hell. All right. All right, we're gonna switch over to you.
He's a
Oh,
character. I've seen him before in other channels. He is a
He,
character. You ready for a
he
sound
is.
check?
Yep.
All right, we're going to hit play and tell me how the sound level works.
467 and
It's okay. Make it as loud as you can.
through
All right.
495.
It's low.
Confirming any objection.
It's really low.
It's ordered admitted.
Yeah, I'm hearing it okay, but that's as loud as you can get it. That's as loud as you can
Yeah,
get it.
that's max.
Turn it
That's
up on
max
their
volume.
end.
Evidence.
And I'm not going to show 459 at this point, but I'm just going to ask so it doesn't seem like I'm skipping anything.
I am, June. Give me a minute.
Perhaps this witness can just let me know what 459 is. May I approach, Judge?
You may. You may, and you have continuing permission.
Could you just take a look at that and let me know what you're looking at?
This is Allison Feldman's body.
Is it at the home that you mean?
Yes, it is.
I'll take that one from you.
I honestly can't hear it in my.
To 467.
Okay.
Just as a reminder, when you
There we go. I bumped my volume up. So I'm going to turn my personal volume down.
Are those
So I'm not louder than they are.
letter markers?
And I'll just let it roll.
And some of these photos.
I'm okay with your volume, so when you have to talk.
As well.
And please feel free to comment and do whatever. You got the live from here. I'm turning it over.
I got it for
I'm
you.
off.
Can you
I'll
remind
see
me
you in a little
what's
bit.
your role at this
I got you,
point
boo.
in the investigation on that early?
And thank you so much.
So that first day, I was tasked with doing the documentation of the scene. So I'm there basically walking room to room, documenting what I see, how things are as saw them that night. We're not touching anything. We're not moving anything really. This picture does show that we at some point took a cutting, but like I said, the letters were lab based. So that's the lab personnel asking us to do stuff and document it.
And so what I'm at here in 467?
So this is a shot of the living room, and it is showing the couch, and then it is showing evidence marker R, which was a red stain on the couch, which has now been cut out of the couch.
So now I'm going to go to 469 at this point. What is that?
So this is after Allison has been placed in the body bag. This is called the medical examiner seal. They seal the body bag for a chain of custody.
So this is just a photograph of what would be the seal with the medical examiner information?
Yes, it gives you, so we document that the seal with the seal number.
That's 469. Now we're kind of moving to different area of the home, but do you recognize this picture, 470?
Yes, it is the security box, the screen. I believe it was like a little tablet.
And as we move through some of these additional photographs of this tablet, just to remind ourselves, this is the first night you're there is the evening of the 18th into the early morning hours of the 19th?
Correct.
And so this is some information that you are present for, although maybe someone else is taking the actual picture of this tablet?
Yes.
Okay. Was it your job to then kind of look at the information that was coming from this tablet and analyze it as it related to other facts potentially known at that point, or were you more of the documentation and collection role?
I was at this point purely documentation.
Okay. So if I'm moving through these pictures, and I might ask you a little bit about what this information coming from this tablet is, but my question to you is, you weren't tasked with kind of compiling an understanding of what the information meant as it related to the investigation?
No, I was not.
Okay. That might be a better question for a different witness?
Yes.
Okay. That was 470, so I'm moving now to 471. So is this that same tablet?
Yes, it is.
And now, what are we looking at?
So on this tablet, when you look into the history, it is showing you all of the conditions of the doors throughout the house that have
Okay, so real quick, Twana, the court volume is really low, so you will have to turn up your personal speaker volume until you can hear it. It took me, so I was sitting at like 47% volume and I had to turn it up. Let's see, what am I at? I'm like 75% now. So I hear it fine, but I turned down my personal microphone volume so I don't blow you out if I talk about this case while it's going on. So just turn up your personal speaker volume and you should be able to catch it. But thank you for the feedback. Here we go again.
monitors on them.
And are you the best person to tell us which of these descriptions corresponds to which door?
I can't explain where they are,
Okay,
yes.
so help me understand.
So the master bathroom door is located in her master bathroom on the east wall, I believe. It's actually in the master bathroom.
Where does that lead to?
Goes to the backyard. The front door is the front door of the house, leads to the front yard. The garage door is, I believe, the door that is in the laundry room that leads out to the side yard and the garage, but there also was
Join the live.
like an electric door on the garage too.
And what about, well, I'll go to the,
This
what
is
about
a
front door?
reminder.
That might be obvious. You might
Join
have
the
said that
live.
already.
Yeah, the front door was in the front of the house that led to the front yard.
Okay. We have like an overall diagram that I'm gonna get to, but that we've seen of the house, like a drawing of the house that would also kind of orient us a little bit. But as you're looking at this tablet, is this in, well, tell me about the time on the right-hand side.
So these times are showing actually our entry and exits from those doors because this is on the 19th at that time that we're there.
Okay, so we're looking at, February 19th at 1:32 a.m. This is a time frame where you are present with other detectives and crime scene personnel working in the home?
Yes.
Okay. And this kind of, does this go sort of backwards in time as
Yes.
it logs? Okay.
Yes, it does.
So now I'm going to move to 472. At this point, again, we're going to have more questions on this later for a different witness, but I just want to kind of point out, are these some sort of the same doors you had described before?
Yes.
And again, going to the earliest time, February 18th, 2015 at 11:09 p.m. At that point, are police already present?
Yes, we're still there.
Okay. Did you see either on exhibit 471, going back one, looking at the door specifically that are referenced, and 472, do you see any references on either of those exhibits to the Arcadia or sliding glass door?
No.
Okay. So now we're going to go to 473. Now here again, I'm going to ask you just, you talked about what the doors are, but I want to slow down a little bit on the right side, the timing. So now we're getting as early as February 18th at 9 o'clock. Is that still when police are present?
Yes.
Okay, I'll move a few more. 470, that was 473, Judge. Now I'm getting to 474. Can you see that? It's a little blurry. I don't know if it's going to get better. Can you see that okay?
Yes.
Okay. So now I'm going to ask, keep moving through the house again. We're still on the 18th, or as this one just goes as early as 7:42.
Correct.
And again on here, do you see in 474 or take a look at that one for me first before I flip back and forth, or 473, do you see again any reference to the Arcadia or sliding glass door at that point?
No.
Okay. Now we're moving, continuing on here, 475. Again, we're still on The 18th as early as 4:37.
Correct.
Okay, and again, you're taking a picture of these sort of every screen or every time log that you can.
Yes.
Okay. Again, have the master bath and the garage door,
Correct.
at least on this one. Okay. Now we're getting to 476. Again, I'm going to move through this one a little bit fast, but again, we have the doors that you've mentioned already, correct?
Correct.
And again, we have from this one as early as February 18th at 4:06 p.m.
Correct.
Okay. Now we're at 477. And what do we have here? All front door?
Correct.
Okay, and again, February 18th. Can you just tell me a little, what's the time frame of this February 18th opening and closing of the front door?
So this, I believe, is getting towards near the start of the call. So this would have been when her was showing up and then officers were starting to show up.
Okay. And maybe if I back up to 476, the one just prior. Here we have February 18th at 4:06 p.m. Front door open.
Mm-hmm.
Is that accurate? Okay.
Yeah.
And then I'm going to have to back up quite a bit to find what I'm looking for here. But so now I'm jumping all the way back to 473, jumping back in time. We have 218 at 10:50, front door closed.
Yes.
And just for purposes of the record, I'll note at 474, there's no reference to front door, correct?
Correct.
Okay, and at 475, no reference to front door?
Correct.
Open or close, okay. And then we're back to what we were looking at, 476, front door open, 4:06 p.m. So now I'm going to go to the next one. I know I kind of moved through those a little fast. We will talk about them again later in more depth. 477. Can you tell me a little bit, sort of the same thing, front door open and closed? That's when we look just like that, sorry. Moving to the next one. Hopefully I'm not making you seasick here. 478. So I'm gonna leave this one for a second. What do we have here?
So that is showing the front door opening and closing from the earliest time is 1 o'clock in the morning to 4:03 in the PM on the 18th.
So here I want to just draw your attention to the very bottom two entries at this point. So here we're talking about front door. Again, which door of the house is that?
The one at the front that leads out to the front yard.
Self-explanatory. Okay. And what is it? Open or closed?
It's closed at 1:04.
And so this is on the 18th of February at 1:04 a.m.
Correct.
And when is it next opened?
At 3:59 PM later that day.
Okay. And again, you didn't kind of put together analysis of other aspects of the case, but you are familiar with this tablet and looking at it the night you were there?
Yes.
Okay. So now I'm going to go through a few more. This is 479. Now we have some of this additional front door activity, right?
Correct.
Can you tell me a little bit about it? And I just, we've got a handful more of these, and because we're moving backwards in time, I'm going to kind of slow down, okay? So I want to just take note of the general time frame that we're talking about. So what's the earliest time on 479?
12:12 a.m. on the 18th.
And what's the latest time?
1:04 a.m. on that 18th.
And that's essentially a duplicate of the bottom entry of Exhibit 478. Are we looking at your kind of, is that right?
Yes, I believe each photo had like the last one.
You can kind of orient as you're scrolling down here.
Correct.
Okay. So now we're going back to 479. So let's talk about this one. So earliest in time is the door opening at 12:12.
Correct.
And tell me, just walk me through what are the opening and closing time frames on this exhibit?
So it opens at 12:12 at 11 seconds, closes at 12:12 at 24 seconds, opens again at 12:16 and 55 seconds, closes again at 12:17 and 8 seconds, opens at 12:59 and 7 seconds, closes at 12:59 and 14 seconds. Then it opens again at 1:04 and 47 seconds, and then closes again at 1:04 and 59 seconds.
And so we kind of, from a narrative perspective, the bottom two entries, what are the doors opening and closing? Is that correct?
Yes,
Okay. And how many seconds apart is it opening and closing?
13.
And then we have another kind of pair of opening and closing right above that. That I'm the sort of from the bottom, 3 and 4 from the bottom here on Exhibit 479. What are the opening and closing times there?
About 4 minutes difference.
Maybe I'm my fingers probably are
Oh,
not
1
doing,
minute.
not doing it justice here. But so it opens at 12:16:55.
Yeah. And then so
Okay.
like 10, less than 10 seconds.
Okay. So then closes 12. So these two pairs that I've just referenced. They're the door opening and closing in a matter of 10 to 15 seconds difference.
Yes.
Okay. But and they're what probably you were referencing is they're 4 minutes apart from each other.
Yes.
Got it. Okay. So now I'm going to go up, and now between this entry from the bottom at 12:17, is there a gap between that and the next time the front door opens?
Yes.
And what about is that gap? You know, it doesn't have to be exact, but the sort of total minutes or roughly.
Like 40. Looks like what? 40 minutes?
Okay. So from 12:17 of the door closing here, there's a 40-minute gap to it opening again on the 18th at 12:59.
Yes.
And then how long until it closes?
7 seconds.
Okay. And then how long until it opens again between these ends at the top here, these two?
Like 5 minutes.
So 5 minutes. Okay. And then we have the door opening at 1:04. How long until it closes again in that last closure in that early morning hours?
Like 10 seconds.
Okay. And just so we're clear, that 1:04:59 is the last closure in that early morning until almost 4 p.m. Essentially that same day, but much later that same day.
Correct.
Okay. So this one we have again that duplicate we talked about, the 12:11 at the top. I want to now talk to you about some of these other entries. So it's a little too zoomed in. Okay. So we've got a handful more as we move earlier into the night, but let's focus on, just start at the bottom here. This, again, tell me what doors are we looking at?
So on this sheet, you have the front door, which is the front door that leads out front. The back door, I believe this is referencing that sliding glass door.
Okay. And so here we have the first reference, at least from your testimony, of what's been deemed back door.
Correct.
As opposed to, I think, master bath door.
Yes.
Okay. So now we have, tell me about these pattern of opening and closing. And maybe if I go, well, you can skip this one because we're going to get to it in the next exhibit. Might make more sense, the opening and closing of the back door at 10:20. So just start here at the 10:58 and walk me through the doors.
Okay. So the back door is opening on the 17th at 10:58:56. It is closing 1 second later. It's opening again at that same time. It is, and then the garage door is now opening, which is the one from the or the laundry room out. Opening at 11:38:56. It closes at 11:41:33. Then that back door, the slider is closed at 12:06:29. And then front door is opened at 12:12:11.
And just so we're kind of in the understanding of where we are so far, at the point that you're taking photos of this alarm system, the police have arrived at the house. They have, talked to Alex. They have talked to Allison, and a lot of information is still being compiled. Is that fair to say?
Correct.
So I'm not going to ask you, for instance, if you can point me to when, from your testimony, when Allison Feldman's last life activity was as it relates to these doors, because that testimony would probably need to come from other witnesses. Is that fair to say?
Correct.
Okay, so I just want to make sure as we move through, if there are questions like that of you, might be better for someone else.
Correct.
Okay, so we have these pattern of front door, garage door, back
Okay, break time. Everybody stretch. Everybody stretch. This is some dry testimony. But it's from an expert whose testimony is vital to the state's case. So I'm just going to pause for just a second and say, I need to stretch. I heard, was that Ada K back there in the background? All right. We'll start again soon. They're going to keep going into the forensic evidence in this case. So we just need a little stretch before we get a little more forensic evidence. She just said there are some things that I can't testify to that we're going to need to hear from other witnesses. So we can expect that in the near future. All right, moving on.
Openings and closings. And I said to skip this one here because that's 480. And I'm going to go to 481, which again starts with that 10/20/52 time frame, and ask you about this one now. So now we have, can you talk me through this one? And again, just start kind of go chronological order, if that's all right. Just start from the bottom and tell me what's happening with the doors and house at this time frame.
All right, so on the 17th at 9:23, that garage door is being opened. The back sliding door is being closed at 9:47. The back door is then being opened again at 10:05. The back door is getting closed at 10:06. The back door is getting closed again at the same time. That garage door is being closed at 10:14. The back door is reopened at 10:20. And then it is closed again at 10:20:52.
And so again, kind of moving above this one, we have the back door that you said is that sliding Arcadia door.
Yes.
So that had been open for some period of time prior to this, and now it's closing?
Correct.
Presumably, okay. Now we have that back door. This is, can you tell me about this one here, this one that I'm trying to highlight with a pattern of this?
Yeah, it's opening and closing within 10 seconds or so. So just opening and closing.
And now I want to go through these. So we have at 10:06, what happens to the door?
It looks like it's closed twice. I'm assuming that because it was the slider, maybe it bounced back a little bit with the same.
Okay, and these kind of have the same time frame?
Yeah, those are the same exact.
And then moving up here, garage door had been open since, if we go to the bottom, how long about had the garage door been open in court this? Can you see it? Yeah.
About a little over 45 minutes.
Okay, so from, we're looking at 9:23 open to 10:14 closed?
Correct.
And then we're back to the Arcadia door, a quick open and closing up here at 10:20?
Yes.
Okay, 30 seconds or so?
Yes.
Okay, that's 481. We'll move to 482. And now we're getting a little bit further back in time. So as we had talked about that garage door 483. I'm just going to go back, 481. Talked about the garage door being opened in that duplicate time and it's staying open for a while. So I'm going to skip that top one, or ask you to skip that top one so it's not confusing. But take me through the time frame of the doors here.
Okay.
Sorry.
The garage door is being opened on the 17th at 7:18 and 43 seconds. It's closed at 7:19:11. It's reopened again at 7:26:43. Closed at 7:26:51. Then that back slider is opened at 8:41:32. It's closed at 8:42:20. It opened again at 8:42:35.
And so we were looking at the last one, the back door. You mentioned this opens here at 8:42:35.
Yes.
So I'm going to go forwards in time to exhibit 481. So if we're focusing on back door at 8:42, where does it next close here? And I'll direct you to this line.
At 9:47:10.
So going from 481 to 482, does it appear that that back door was open for, say, 40 minutes or so? It's hard to show you both at the same time the way that they're photographed, but is that about accurate?
Yes.
Okay, so I'm sticking with 482 for a second, and I'll move backwards. So what you tell me, is this sort of a pattern of opening and closing on the lower half of this exhibit anyway? Each of these about somewhere in the 20 to 30 seconds opening and closing?
Yes, it is.
Okay. And again, we're to your understanding, the system would log the, the master bath door to the outside. If that had been opening and closing at that time, would that be appearing somewhere in here to your knowledge?
Yes.
Okay. So now we're at 718 garage door, but I'm going to go to exhibit 483 and slow down again. We have that duplicate again.
Yes.
Okay, so this is 483. Maybe I can just move this up because it's frustrating. There we go. So now tell me a little bit about the pattern of the doors here.
All right, so now we're into early on the 17th. At that garage door is being closed at 2:18:34. The back door, which is that sliding door, is open at 2:21:35. It is closed at 5:20 and 10 seconds. Then that garage door is opened at 5:20 and 28 seconds. It's closed at 5:20 and 31 seconds. It's reopened again at 7:16 and 36 seconds, closed at 7:17 and 49 seconds, and then opened again at 7:18:43.
And again, we talked about that in the last exhibit, 482, with that
Oh,
garage door at 7:18. It then closes again 30 seconds later.
Yes.
And I'm not going to go back all over those, but so now do you know, sitting here, well, do you have personal knowledge of when Allison arrived home that evening?
I do not know.
Okay. So we have sort of a little bit of a pattern here, but I just want to mention this back door. That's, again, the Arcadia or sliding door.
Correct.
Does it appear to stay open for a period of time?
Yes.
And what roughly is that period?
Roughly 3 hours.
It's starting about 2:20 to 5:20?
Correct.
Or so? Okay. And then we have this garage door sort of opening and closing pretty close in time, 3 times in a row?
Yes.
Okay. So now we're going to get through sort of earlier in the day as well as we keep moving backward in time. This is 484. For this one I think maybe more important is just to help me understand generally what's happening, but I won't ask you to do much math on this one.
Thank you.
So just what doors are active here?
All right, so on this one, it's that garage door and that back sliding door.
And we can skip this bottom one here so it'll make more sense, I think, in the next exhibit because it's that duplicate. So on this one, do we essentially have a lot of the garage door activity?
Yes.
And that's, again, going out into that carport?
Correct.
Since you were present at the scene, do you recall if Allison's car was parked in that carport?
Yes.
And so we have activity as sort of just opening and closing relatively close in times, several pairs.
Yes.
Okay, starting at 11:39 and then up to the one we had talked about on the last slide, that 2:18 timeframe.
Correct.
Okay, so now we're going back to the back door. This is again earlier in the day on the 17th. This will be the last slide of the doors. So this is exhibit 485. So we're at now 17th, 11:38 a.m.
Correct.
And this actually goes back even into the day before, the 16th?
Correct.
Okay.
So this one just has the back door and which is that slider, and then the front door. So starting on the 16th at 12:04:53, the front door is closed.
So just a quick update, if you're not following the comments in chat, I have Court TV pulled up on the Brian Walshe verdict watch. And then all of a sudden a judge comes in and sits down and I'm like, oh no, do we already have a verdict like 36 minutes in? But no, this is about Sharon Moore, who was the head football coach at the University of Michigan, who is accused of assaulting a staffer and having an affair with a staffer. And it's really, there are a whole bunch of different reports on whether or not he was having like a long-term affair. But it has come out that he went to a P. Diddy party at some point in time, in the last few years. Wherever he got to a P. Diddy party, I don't know, but he followed like OnlyFans models on his Instagram. So he's having a hearing right now. That's the judge that came in. Doesn't have anything to do with Brian Walshe or the Anna Walshe murder trial. Just wanted to update you on that. I almost panicked because I saw the judge come in and I'm like, holy crap, we got a verdict within 36 minutes. That's not the case. All right. Going back to the Ian Mitcham trial. Forensic evidence presentation by the state's witnesses.
Open again at 6:46:36, closed at 6:46:53. That back door is closed at 7:57 and 38. Back door open at 9:55:49. The front door is open at 10:41:22. It's closed at 10:41:37. And then that back door is closed at 11:38:43.
So just kind of focusing on the 17th, does somebody open that back door 9:55 in the morning
Yes.
and then leave it open until 11:38 in the morning?
Yes.
Again, a couple of hours, just shy of a couple hours.
Yes.
And then during that same time period, the front door is opened and closed 10 seconds, 15 seconds apart?
Correct.
Okay. And then this last one of that exhibit is 486. We're just looking at kind of the alarm system, whether it's on, off, or some information about the alarm system.
Correct.
Okay. I'm not gonna dwell on this one too much, but there may be another witness who also will talk about the alarm system in the future. So now we're staying with the house, but I have a few more photos to go through from that night, the 18th, into the early morning of the 19th. So I'm going to ask you about exhibit 487. Can you see a placard in this exhibit? I know there's a little bit of a glare there.
Yeah, it's placard number 5.
Okay. And can you see roughly what that area of the house is? I know it might not be the perfect orientation given how zoomed in it is, but can you tell what we're looking at? Where are we in the house or outside the house?
We are in the backyard by the pool, on the pool deck.
Okay, and then, so that's 487, and I'm gonna go now to 488, sticking with placard 5. What is that?
It is a sunflower seed.
Okay. And were there a handful of sunflower seeds in the backyard?
Yes, there was.
Okay. So I'm gonna go through a few more. That was 488. This is now 489. What are we looking at here?
Placard number 4, which is marking another sunflower seed.
Okay. And we've seen some photos already of the back of Allison's house, but is that the backyard?
Yes, it is.
You see some coolers back there?
Yes.
Okay. Photograph taken at night?
It is, yes.
So we talked about how, well, let me get through placard 4, and then I'll have a follow-up for you. This just that sunflower seed zoomed in?
Yes.
Okay, just 490 for the record. We talked about how the crime lab, and we mentioned the name Vicki Beamer on Monday, how the crime lab would use the ABC placards. Is this, now we've started with numbers at this point, is this some of the stuff that the CSS personnel were looking at and collecting when it comes to now the numbers that we're looking at?
Yes.
Okay, so I'm gonna go now to 491, and we're at placard. What placard is that?
Number 3.
And you see what area of the house this is?
We're still in the backyard next to the pool, on the pool deck.
Probably hard to see what 3 is marking in exhibit 491, but I will go to 492. So I can just see, what is that?
Another sunflower seed.
And that's just placard 3 zoomed in?
Correct.
Okay. Were these seeds ultimately collected?
Yes, they were.
Okay. 493, again, where are we?
In the backyard, next to the pool, near the back fence.
Okay. Can you see like a pedestrian gate to exit into the alley from this vantage point?
Yes, it's in the top right.
And what placards are we looking at? Can you see those?
Numbers 6 and 7.
Okay.
I would like to figure out a way to stream interesting stories live, like this Michigan football coach is having a hearing right now, and that would get clicks and views and would be fairly
Just a zoomed in of the placards we just looked at on the pool deck there?
Correct.
Okay.
enigmatic,
So that takes us through
non-controversial.
that evening that I wanted to ask you about. Now I want to ask you, so you're, can you remind us again what sort of shift it was that you were working back in 2015, the time frame?
I was working 6 at night to 4 in the morning.
And so you arrived, your role in the case on the 18th was that sort of overnight shift?
Correct.
Did you return for your overnight shift on the 19th?
Yes, I did.
So although it's the same day, because you were working into the early morning hours, what time about do you arrive back at the house on later in the day on the 19th?
A little bit before 6 o'clock.
And so tell me now, what's your role that day?
On that day, I again was there to document, and because the day shift had worked throughout the day, there was items that were now marked as evidence. So I went back through, and anything that I had already documented, added the placard numbers to it, added anything that they had found as they were going through the house. After I was done with that, I assisted with packaging and impounding items that we had decided to collect that night.
And who's with you in that process?
That night, CSS Palma was on scene with me. She was photographing, and CSS Alexic was there, as well as our supervisors and the detectives.
And who was your supervisor again?
Mark Carpenter.
And you said the detectives, was Detective Heinzelman present?
I believe so, yes.
Okay. And so you talked about at this time frame on the 19th, some swabbing was done that you were around for?
Correct.
Is that right? Before we get too far into that, I'm just going to ask you if you could kind of give us a little bit of an understanding of the swabs that we've heard so much about. This is 517. Can you just take a look at this for me?
So these are, we would call them Integra swabs. These are the swabs that we would use to collect DNA or buccal swabs. For that process, basically, we're wearing gloves.
And I think she just held something up. I don't think this exhibit has been admitted, so we'll just don't publish that to the jury.
I would move to admit 517. I'm going to ask her to
Okay.
open it up too.
Any objection?
No.
It's ordered admitting 517 into evidence.
And you just held up a few black gloves. Is this sort of a process you would use when you're swabbing?
Correct, yes.
Go ahead, Judge, I'm sorry.
I didn't say anything. I think there's echo. I'm sorry. Let me move my mic.
So go ahead and just, in looking at 517, will you go ahead and just open that up for us so we can kind of see what these swabs look like? We've heard them described.
Yes. All right, so the swabs come prepackaged in their own individual container, keeps them sterile. We would be wearing a mask and gloves for when we would start swabbing, because we want to protect what we're swabbing from ourselves. They open, and the swab consists of the stick part, the swab, and then a plastic container. To swab, we would click the plastic container open, push the swab up, add some water to it if we needed to. If the swab, what we were swabbing was wet, you don't add water to it. Then we would take this and you would swab it on whatever you're gonna swab. So stains, and for that process, you're making sure you're saturating your swab, you're spinning it to make sure it's getting on all the sides, the tip. Once we're done and collected what we need to, you pull that cap back over, close it. To protect it, most of the time we're putting the swab back in its original packaging. And then this package is being placed inside of an evidence envelope, because this has to be transferred back to our office and placed dryer so that the swab is dried. Then it is impounded and placed in the freezer.
And since you mentioned it, tell me about the dryer. What does that look like? What's that process? Where is it at?
So the dryers are located in the CSS processing lab at our District 1 station, which is the station on McKellips. In the CS office, we have a section that's to the lab, not the main lab, but where we can do small processing. The swab dryers are small little dryers that have plastic trays in them where the swab stick goes down into it and it holds it there in place. We would click this open, push it partially down just so that the airflow could swab while it sits in there. It can hold several swabs together, but you're only working with stuff from case at a time. They close, they have a door, you can close, you can lock, you can see a seal, somewhat kind of like, let me see.
Okay, people. I had a technical glitch. And now you can probably hear me better than you could before, because when I first came into StreamYard, I set my microphone to my HyperX, which is the one that's like that's like a boom mic, right? And is like right in front of me. But apparently StreamYard didn't take that change. So I was on a hot mic the whole time. So I'm just going to say, I'm sorry. And yeah, that's my cell phone alert, is the cuckoo cuckoo noise. That's just what I have it set to, and it gets my attention. But then, you know, when you have an alert set on your phone and you get it all the time, sometimes you just ignore it. So I'm glad you pointed it out. And then I went into my audio settings and found out that I was using my laptop microphone instead of my HyperX microphone. So I was live the whole time. I'm so glad I didn't say anything incriminating. I'm just monitoring this forensic evidence. She's a very scientific witness, like very forensically grounded. Like her evidence coming in is very good for the state, but you never know on cross what the defense is going to say. All right, we're going to get back to it. I'm going to start this back up and just say, I'm sorry I had the wrong microphone up and you were hearing my cuckoo cuckoo noise from my cell phone alerts.
Sealed, but they're a little bit different style. And In the meantime, prior to pushing our stuff in there, we're wiping it down with bleach solution, cleaning all the sides, making sure the tray is good to use. And then we're also doing at the end, after we pull all of our evidence out, we're cleaning it again, making sure that it's ready for the next person to use.
Why do you use bleach?
Kills germs and DNA.
And so we skipped one part, but you said you would wet the swab if the thing you were swabbing was not wet. Would you also go over that after you do the wet swab? Would you do another dry swab, or does it on the circumstances?
It depends on the circumstances. Yes, we do a wet and dry swab. Everything that we're swabbing is getting 2 swabs.
But would those two be considered sort of the samples from the same evidence item?
Yes, they would be.
So, okay. So now you, after you swab something, are there times where that stick, the length of that stick, is that pretty much the same for most of the swabs you use? Is it usually that? I don't know.
Yes, it's a standard size.
It's a little bigger than a Q-tip, I guess, is what I'm saying.
Correct.
It's pretty long. Sometimes break the stick if you're swabbing something really hard.
Yes.
And so you open this, you have gloves on, you put it back in. When you put these things into the sort of evidence bag with the little plastic thing on, when you move to another sort of sample, let's say you've done one stain and now you're going somewhere else to process something else. Tell me about what you would do in between that. Does that make sense?
Depending on the situation, if I'm moving from one area to the next, if there's any kind of time in between there, I'm gonna be changing my PPE, so changing gloves. If I'm moving from one thing to the next, doing the same thing, most of the time when I'm swabbing, I'm not touching the swab portion of it at all. So I didn't change my gloves every time I swabbed, because I'm not touching the part that is collecting the evidence.
Gotcha. And you're kind of telling me about what you would observe other crime scene specialists do, and also what your policy would do. Is that fair to say?
Yes.
In this case, did you ultimately, were you present when crime scene specialist Alexic impounded a bunch of items and swabbed a bunch of things around the house?
Yes, I.
And again, just so we're clear, we're still on the evening of the 19th after roughly 5:36 p.m. when your shift starts and you back to the house?
Correct.
Okay. So I'm gonna just ask you about a whole bunch of things that were processed at that time frame. And if you need to refer to any reports or anything, that's fine. And I'm probably going to ask some leading questions, so just so you know. But ultimately, was this house processed by different crime scene specialists over the course of the 4 days?
Yes, it was.
So we've heard that you were there that first night, and we're talking now about what I'll call the second evening of the 19th. And do you go back one more day on the 20th?
Yes, I do.
Are you there on the last day, the 21st?
I am not.
Okay, so sticking with the 19th for a moment, we'll talk about first collection of items. Were you present for the collection of this pool tile that we've seen at Exhibit 100 by crime scene specialist Alexic, PM 14? Sorry, I kind of tricked you. I went back to it. Might take a minute. Were you present for this? Is it recognized this?
Yes.
Okay. And was this impounded?
Yes, it was.
Was there a Castlemeyer test done on this?
I don't believe it was done on that. I believe it was done on the pool ledge where that came from.
And to avoid going back to that picture right this moment, we're at edge of the pool where there's a missing tile. Is that
correct?
Is that what you're talking about?
Yes.
And what was the result of, or what is the Castlemeyer test?
So Castlemeyer is a presumptive blood test. We use it if you see a stain that you don't know if it could be sauce or blood or some other kind of red substance. You can use it to determine if it's blood or not. It doesn't confirm whose it is, but it does tell you if it is blood or not.
And are there some areas of the house that you might have observed what was consistent with blood that there was not a need to cast them?
Yes.
Okay. We've seen a bunch of pictures of the home, but just to be clear, not every single swab in that house was Castle wired and did need to be.
Correct.
Okay. So going back to the collection, was the master bedroom door handle collected?
Yes.
Was the porch light switch collected?
Yes.
Were the guest bathroom handles, at least U, E, and F, collected?
Yes.
Is that we saw U of A in the yard? Was that collected?
Yes, it was.
We've already seen this square tan rug. Was that collected at this time?
I believe so, yes.
The white metal earring in the pool that we've seen, is that collected?
Yes.
Okay. We early on with crime specialist Palma, we saw some pictures of some Swiffer items. Were some Swiffer boxes collected?
Yes.
A Swiffer mop?
Yes.
Okay. I'm not going to go into back to every picture that we saw, but fair to say what your role was documenting and kind of being present with crime scene specialist Alexic when these items were ultimately decided, okay, we're going to tease now and we're going to take them away from the house.
Correct.
And as I move through these, what does that process look like when you collect an item? We heard what you do with a swab, but what do you do with an item? If you take a Swiffer mop, what happens with that?
So that would, because it's larger in size, that would have been placed in multiple bags. So we could transport it back to the office and then repackage it to make it more secure.
And once you get back to the office, what do you do with it?
It, depending on the shift, I don't recall if we held stuff in temporary lockers or if we worked on impounds right away.
I'm just going to interrupt here just for a little bit of a break, just for some commentary. But this is a line of questioning that both prosecutors and defense attorneys take with expert witnesses, where they go down the trail of chain of custody. And they say, okay, when did you receive this evidence? What did you do with it? Where did you take it? When did you transfer it to somebody else? Where did you transfer it at? That was kind of like Lori Daybell kind of went down that path, like with the expert witnesses in her trial. It didn't really benefit her a whole lot, because she never did like do anything with whatever the expert witnesses said they did with the evidence. Like, she didn't produce any evidence that the chain of custody was tainted. But it's a common line of questioning with the expert witnesses, the chain of custody thing.
Hey, Joe, you're right on that. I always say that if you're going to go down a tight chain of custody with a witness, if there's no issue with that chain of custody, then you shouldn't bring up chain of custody. I think the only time they should be bringing up chain of custody and focusing on it is if there's an issue with that chain of custody, in my humble opinion, because it creates a doubt when you go that deep into the chain of custody. I mean, do you agree with that?
Oh, I do. In my humble opinion as well. I think that if you bring up chain of custody and then the expert witness says, I did everything correctly, then that's kind of a little negative mark in your argument. But unless you're the state, and if you question them on chain of custody and you're the state, then you're like, okay, we've proven that chain of custody was maintained, and so that benefits us.
Right. But as a defense, you should not bring up chain of custody unless you have proof, or you can get them to admit that there was an issue with that chain of custody. Otherwise, I wouldn't bring it up. I'd keep my mouth shut.
Right.
All you're doing,
You gotta bring,
is setting yourself up for failure.
Yep, you got to bring up reasonable doubt. You got to bring up something that casts reasonable doubt in the minds of the jury.
Yep,
Absolutely.
Exactly. All right, guys, we're headed out. I'm listening. Thank you so much, Joe. Dear.
You bet. I'm happy to be here. Happy I got your back.
But again, we would have responded to our processing lab, and that's where we would have packaged everything and then deposited it into property and evidence.
And let me walk you through both of those. So in one vein, you might take it to a locker.
Yes, we had temporary lockers in our office. So if it was late and we needed to hold stuff over for the next, the next shift when you came in, you would place your items in there, be able to lock it down, and only you had access to it. They have keys. You would take the key with you and secure it, and then you would come back and retrieve your items and finish the processing or the packaging of it.
So let's walk through the sort of the processing. If you either do it right away or if you get it out of the locker and do it, what does that physically look like?
As far as processing, I don't think we did any processing of items. So ours was merely getting stuff ready for packaging. So making sure it's securely packaged for whatever the next step was. So packaged properly in either a box or a bag. Paper, we use paper for everything so that things don't get moldy and that type of thing. And then we would take it to property. So it either would go in a property locker or it would go in the refrigerator or freezer, depending on what type of evidence it is.
And what does that mean to take it to impound? Like, where does it go from there?
So property is located directly next to the crime scene office at our District 1 station. So there is a little intake door that is accessed by police people. And in there they have a window. Obviously at night they're not there. So we would be placing everything in lockers that are along the line or along the wall. Again, they are kind of the same as the ones in the CSS office, but different as they only have like a push button or twist lock. You don't have, once you put it in there, you don't have access to it anymore. Property then, whenever they come in to collect the item, comes on the other side of the wall and they have access to all of the lockers, and they pull out the evidence and log it and place it where it needs to go.
And that's ultimately where evidence would be stored at that point until it's needed for whether it goes to the lab or comes to court or something else.
Yes.
And again, not to belabor the point, but who sort of has access? That property, is that a police facility?
Yes, it is.
Can anybody just go into the property building and browse for items?
No.
So it's secure, just like the place you were talking about at the lab where you process things, only police personnel are out.
Correct. Yeah. The property area is even more secure. We're not, even as crime scene people or detectives or officers, we're not permitted to go into the property part of it. So we're just allowed in that little intake room. That's as far as we get to go with our evidence.
So after it's been impounded, is it, we've talked about how you have an item, it has a photo marker. Do you also tend to impound things and provide your badge number and an item number often on the actual item?
Yes.
Once it gets impounded, does it also get assigned a barcode that tracks the item?
Yes, at that time they were using the iLead system, so it got an iLeads number, inventory number also.
Okay. Now I'm going to go back. We went down a tangent there, but on the 19th, did you also collect a soap bottle from the kitchen, PM 20?
Yes.
A sunflower seed, PM 21?
Yes.
The black floor mirror we've heard talked about, PM 23?
Correct.
Some red material on the pillar, PM 24?
Yes.
Some water bottles, PM 25 that we've seen on the tables?
Yes.
Excuse me. A jug, a mason jar jug, PM 26.
Yes.
Does that sound right? And again, these are ultimately, lots of these items are collected. Is it your role to determine what is of evidentiary value or not as the case moves forward? Or at this point that we're talking about, are you focused on let's collect what we can? Is that a bad question?
Yeah, we're not deciding, we're not giving things a value at that point. We're taking things that we think can be processed for evidence later. So as a crime scene person, as a detective, we're working together to kind of decide, what we're taking or not, but we're not assigning a value to it.
And then also, was that blue jean jacket taken?
Yes.
Now I'm going to move. We're sticking on to the 19th in the evening hours of the 19th, but I'm going to move to swabs that were done.
Okay.
Okay. So we went through a whole bunch of things that were taken, and we've kind of jumbled it chronologically. But while you're there that night, before you take things away from the home and take them to the evidence and take them to the impound, are some things within the home swabbed?
Yes, they are.
And we talked about how swabs are done, but I'm just going to ask you about some of the swabs that you were around for. Was the vehicle passenger door handle both the interior and exterior swabbed?
Yes, it was.
Was that area that we talked about that was Castlemeyer, that pool edge, was that swabbed?
Yes.
And that's PM14 we saw a picture of previously, but the area that we talked about was that edge of the pool?
Yes.
Okay. Was the 2 water bottles that we just talked about, were those swabbed?
Yes, they were.
The kitchen faucet?
Yes.
The guest bathroom handles A, B, C, and D?
Yes.
Okay. The laundry room door handle, interior and exterior side?
Yes.
Laundry room handle A?
Yes.
Laundry room handle B?
Yes.
Okay. And we've seen the laundry room handles labeled A, B, and I think we had a few, A, B, C, and then there were 2 smaller ones. But I want to focus you for a second. Laundry room handle B is swabbed. This is the evening of the 19th.
Yes.
And was it crime scene specialist Alexic that was doing the physical swabbing?
Yes, she was.
Okay. And so at the point, we'll get through a bunch of other swabs that were taken, but I'm breaking here for a second. Laundry room handle B swab. At the point that that's taken, that is, you follow the same procedure where you do the thing and you put it in the envelope?
Yes.
And then it goes into an evidence bag?
Goes into a smaller evidence envelope.
Is that like a brown looking envelope thing?
Yes.
Okay. And so is each handle swab, do you do that for each handle individually? Does that make sense?
Yes, each area would be packaged separately.
So after you swab laundry room handle B, the 2 swabs go in a bag, and then is that sealed? Or what do you do?
It wouldn't be sealed on scene because when we transport it back, it has to be placed in the dryer.
Gotcha. So the swabs are put back, the little cap is put on, they're put back in the envelope? Or the packaging?
Correct.
Then they put in the envelope?
Yes.
And then once you get back, you take the swabs out and put them in the dryer?
Yes.
You unpack it, you uncap them to dry?
Yes, slightly.
Okay. Do you take precautions when you're putting them into the dryer not to sort of be touching the swab heads?
Yes. Yeah, you're wearing the same PPE that you are when you are collecting. So you're wearing gloves, you're wearing a mask.
So now continuing through the swabs that were done, the laundry room handle C, D, E, or we'll start with C, one of the cabinet handles, was that swabbed?
Yes.
D, the front of the washing machine, essentially, was that swabbed?
Yes.
E, front of the dryer?
Yes.
Okay. And again, I'm just kind of leading you for purposes of getting through these. In the master bedroom, was the dresser handles A, C?
Yes.
D, E, F?
Yes.
G?
Yes.
Okay. H?
Yes.
Keep going. I'm just gonna, give me a second. I'm just gonna say a whole bunch, but I'm gonna try to go slow for the court reporter. So in the master bedroom was handles I, J, K, L, M. Are those swabbed?
Yes, they were.
Handles N and O swabbed?
Yes.
Okay. And again, this is the night of the 19th that all this is?
Yes.
Okay. So now I'm going to move us to the following day, February 20th. So now we're at Friday, okay? Do you go back to the house that day?
Yes.
Well, what time do you leave the house the night before? Do you remember? Is it kind of a regular shift for you?
Yeah, I believe we left the house around 10 o'clock that night.
So not quite the 2 a.m. of the night before?
No, because detectives and the other CSS had been working all day. So we did what we needed to, got to a closing point, and then we left the scene.
Okay, and that's when you take everything back to the lab that you talked about?
Yes.
Okay. So then you go back on the 20th. Around when do you go back on the 20th?
A little bit before 6 o'clock.
Again, when your shifts?
Yes.
And I neglected to ask you this the prior day, but are you coming straight from the office to the Allison Feldman's home?
Yes, I am.
The same thing on the 19th?
Yes.
Kind of, were you under the impression when you went home the night before, okay, I'm going to go back to the scene tomorrow, that's my assignment for the day?
Yes.
Okay. So now on the 20th, can you tell us about what happens, what you're involved in that day?
So on the 20th, again, I caught up with any kind of documentation that I needed to. By that point, we kind of had everything already marked, so I already had it all documented. At this point, I assisted more with processing and collecting items of evidence.
Okay. On the 20th, is this when the Blue Star is done that we've heard about?
Yes.
Okay. And we'll get to what that is with another witness, but are you present for that whole process?
Yes, I am.
Okay. You mentioned there was some more processing of the scene itself on the 20th. I'll call it processing, but some more swabs taken?
Yes.
And did you follow the same procedures and policies that we've talked about so far when these swabs were taken?
Yes, I did.
Okay. So now I'm going to go through a bunch of the swabs that you took or that were taken on the 20th, okay?
Okay.
So were the laundry room light switch, was that swabbed?
Yes.
Was the switch on the kitchen also swabbed? The one that's sort of just east of the laundry room door?
Yes.
Okay, trying to orient myself. Was the kitchen light switch, two switches that were on the southeast corner of that same kitchen, were those also swabbed?
Yes.
Were kitchen light switches on the southwest corner of the kitchen swabbed, two of them?
Yes.
Was the light switch, we'll call it sort of in that dining room in the northeast corner of the room by the sliding door, was that swabbed?
Yes.
Was the dining room light switch that's found on that west pillar swabbed?
Yes.
Was the light switch located, we'll call it in the foyer area, was that the remaining light switch, two of them there, was that swabbed?
Yes.
Was that a collection of 3 switches, one of which had already been removed? Does that sound familiar? Or no?
Correct.
Okay. So the 2 remaining switches, we've seen a picture of a light switch with one thing, but the two remaining were swabbed at this point?
Correct.
And now talking again about the 20th.
Yes.
Okay. Was this hall light switch swabbed in the southeast corner of the hall?
Yes.
Was the hall light switch swabbed that's in the center, sort of more of the north side of the hall?
Yes.
Was the bedroom light switch in the west bedroom swabbed?
Yes.
Was the light switch in the office swabbed?
Yes, it was.
Was the light switch, what we'll call the bedroom, swabbed?
Yes.
Was the light switch, first of all, one by the door in the guest bathroom swabbed?
Yes.
Was the light switch located closer to the toilet in the guest room swabbed?
Yes, it was.
Was the master bedroom light switch swabbed?
Yes.
I'll start the one by where you enter the master bedroom. That one was swabbed?
Yes.
Was there another light switch, sort of, I'm trying to orient myself here, located on the north wall of that bedroom, but just east of the entryway?
Okay. So at what point he just said, I'm trying to orient myself here. And he's just asking her questions verbally, and he's not like presenting exhibits that you could present to help explain the orientation. And he just said, I'm trying to get oriented here. So at what point is that a liability for the prosecutor to not present exhibits to help explain to the jury exactly what he's asking of this expert witness? Like, there's drawings, there's maps, there's like photographs, what you could present while you're asking her this question, instead of just saying mid-interrogation, I'm trying to get oriented myself. So if you're trying to get oriented and you've been studying this case for months, hundreds and hundreds, maybe thousands of hours, and you know all of the evidence, you know all of the photographs, you know all of the maps, why are you questioning this expert witness and saying, I'm trying to get oriented? I actually want to go back and rewind just like 30 seconds so y'all can hear that, because that is like a negative for the state's case to me, to say to your expert witness, I'm trying to get oriented here. So, all right, let's back up like 30 seconds. We're at 1 hour in. We're going to go back to, let's go back to 58. Let's go back to 58.
That were taken on the 20th, okay?
Okay.
So were the laundry room light switch, was that swabbed?
Yes.
Was the switch on the kitchen also swabbed? The one that's sort of just east of the laundry room door?
Yes.
Okay, trying to orient myself. Was the kitchen light switch, two switches that were on the southeast corner of that same kitchen, were those also swabbed?
Yes.
Were kitchen light switches on the southwest corner of the kitchen swabbed, two of them?
Yes.
Was the light switch, we'll call it sort of in that dining room in the northeast corner of the room by the sliding door, was that swabbed?
Yes.
Was the dining room light switch that's found on that west pillar swabbed?
Yes.
Was the light switch located, we'll call it in the foyer area, was that the remaining light switch, two of them there, was that swabbed?
Yes.
Was that a collection of 3 switches, one of which had already been removed? Does that sound familiar? Or
correct.
No? Okay. So the 2 remaining switches, we've seen a picture of a light switch with one thing, but the two remaining were swabbed at this point?
Correct.
And now talking again about the 20th.
Yes.
Okay. Was this hall light switch swabbed in the southeast corner of the hall?
Yes.
Was the hall light switch swabbed that's in the center, sort of more of the north side of the hall?
Yes.
Was the bedroom light switch in the west bedroom swabbed?
Yes.
Was the light switch in the office swabbed?
Yes, it was.
Was the light switch, what we'll call the bedroom, swabbed?
Yes.
Okay, can he not just say were all of the light switches swabbed? Because it sounds like all of the light switches were swabbed, which would be standard protocol for CSI. He has to ask about each of them individually. Not sure what the point of that is, except to bore the jury.
Was the light switch, first of all, one by the door in the guest bathroom swabbed?
Yes.
Was the light switch located closer to the toilet in the guest room swabbed?
Yes, it was.
Was the master bedroom light switch swabbed?
Yes.
I'll start the one by the where you enter the master bedroom. That one was swabbed?
Yes.
Was there another light switch, sort of? I'm trying to orient myself here. Located on the north wall.
There he goes. I'm trying to orient myself here. You don't need to if you just say, did you swab all of the light switches for DNA? Like, that's one question and one answer.
You know, Joe, I have to say that, hey, Joe, I have to say, I think sometimes lawyers make things a whole lot more difficult than they need to be. They try to make things more smarter than they need to be. Keep it simple, stupid. Go directly to the point. Did you swab all of the light switches? Yes or no? Did you swab all of the door handles? Yes or no? You don't need to create all this mess around it. Direct and straight to the point. Yes, no questions go better with juries than this guy's doing, in my humble opinion.
Yeah, I completely agree. Like he's making it way more complicated than it needs to be. And there's no, like, I don't think there's any type of legal advantage to him doing that. Like going through every single individual light switch and saying, did you swab this one? Did you swab that one? Did you swab this one? Did you swab that one? Like what legal advantage and what advantage with the jury does that provide? It's actually, in my humble opinion, a detriment because it bores them. It bores the crap out of them. They're like, okay, yeah, we get it. We get it. We get it. They swabbed all the light switches. Just ask that in the beginning and not like every single one. And then in the middle of it, say, I'm trying to orient myself. That's another detriment to the prosecution. Like, why do you have to orient yourself? Just happy person. Yeah. Yeah.
Well, my thing is that you should be organized. You should know your questions. You already know who's going to be there. You've already done a deposition, at least one, if not multiple. You know what you're going to ask. And if you have evidence that the CSI took a photo of 12 light switches, then I understand going through each and every individual one. Did you swab this? What were the results? A. B. Did you swab it? What was the results? I get that. But make it short, sweet, clear, path. Dot, 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 dot. Connect the dots and move on. And for you to have to reorient yourself in the middle of questioning, this is poor planning. Good planning prevents piss poor, what is that? Performance, that's right.
Yeah, and it doesn't necessarily lend itself towards guilty or not guilty verdict, but it does like irritate the jury. And eventually that can affect their verdict, but they are giving up their lives to sit in a courtroom and they get some kind of compensation, like the ones in Lori Daybell's trials got up to $300 a day if they were missing work and they could provide proof of their income before the trial started. They would get up to $300 a day, which isn't nothing, but isn't a whole lot. I mean, divide 300 by 8, that's $25 an hour. I mean, that's decent. So, but they're giving up their lives, like their normal life. They're irritating their employers, or if they're self-employed, they're irritating their clients to come in here and listen to you ask individually how many light switches were swabbed. Just say, did you swab all of the light switches you knew about in the house?
Well, I agree with you on one hand. I'm gonna play devil's advocate on this side. They have to once again chain of custody and chain of evidence. And if you sit there and say, did you swab all of them, and then they don't bring in anything else and they say yes and they move on, okay, you're fine. But if they swabbed all of them and now if they swabbed all of them and then have test results for all of them, because people don't realize just because they take all this evidence does not mean that all this evidence will get sent off to be processed, because each department has a limit to the number of items per submission that can be sent at any given time. So like in Bexar County, you might only be able to send in 12 swabs to be tested at that time. And if you did not send them all off for testing, you need to clarify. We tested 12 of them. 7 of the 12 were sent off, and they were A, B, E, G, D, whatever. And those are the ones that you want to go to and say what the results were. Is it significant for the ones who did not get sent off for testing? And if he's trying to
did they not ever get sent off for testing, or did they just not get sent off for testing at the same time?
Sometimes they don't ever get sent off because there's a cap of how many items per case that can be sent in. Because what happens is that these labs are already overwhelmed. And if you send off 400 swabs, there's no way they're going to get all that done in time for trial. It overwhelms them. And I mean, we've heard about it in other cases where they said we have a limited number that we could send off. We sent off these were priority. We sent off the swabbing of the weapon, the swabbing of the hands for gunshot residue, and of course it depends on what they're sending. Blood and that kind of stuff goes to a different lab than the gunshot residue. So all of that depends on which lab it's sent to. But I just want to make it clear that just because they swab 45 different things does not mean that all 45 of those are going to be sent off for testing. Just saying. So for me, I want to know how many swabs were taken. We had 13 light switches we swabbed. Okay, how many were sent off for testing? They may have sent off all, or they may not have. Okay, out of those sent off, what were the results? Let's go through it. Swab A, B, and C, D, and clear it up and move on.
You just made my point for me, because you asked the question that could be answered in 20 seconds or less, instead of continuing to ask for 5, 10, 15 minutes. Did you swab this? Did you swab that? Did you swab this? Did you swab that? Just ask, how many did you swab? How many were sent off for testing? And how many results did you get back?
Like, and if so, what were those results for those specific ones?
Yeah, exactly.
You know, I've had some people encouraging me to go to law school. I don't think I'm going to, not that I can't. But I would really be, I couldn't keep my mouth shut in the courtroom, because it's easy to sit here and watch lawyers lawyer. It's much difficult to be in the process of doing it. But sometimes I wonder, that's why they call practicing law. That's why I like practicing medicine. I wonder, though, that you know, not all educations are equal. And I'm finding that I get frustrated with a lot of the lawyers who really don't have skills that they need to run a trial. Like the thing with, oh my God, what was that? Cardi B, her attorney. He took on that case, and he was a brand new lawyer, and very seldom was ever in court, and it was very clear. But I think if you're at a level, at this level, at the level he is, and these lawyers are, I personally believe and humbly believe that they need to have a little better skills. I'm seeing them flounder in areas that should be simple, clean, get right through it, move on.
Right. And so when you're in our shoes, okay, you and me, and we're reporting on these trials, and we have some knowledge of the law, but we're not experts, we're not attorneys, we haven't been to law school, we haven't passed the bar, but we have some knowledge of the law, and you see people screwing up. When I was in Lori Vallow-Daybell's trials, like one of them, I don't remember which one it was, but there was a point in time when I was like, Lori actually made a good, valid legal argument, and I felt like Trina Kay, who was the prosecutor, overstepped her legal bounds as a prosecutor.
I think I remember that.
And I was like, Lori, you need to object to that. Like, you need to object to that, and she didn't. It was like.
But Lori's not an attorney. Lori's not an attorney.
She's not, right. No. But she did, on December 6th of 2024, she did proclaim her legal expertise because she's been to already a couple of trials.
Being to a couple of trials and actually trying a couple of trials are two different things. Well,
yes, right.
Let's get back to this, but you're right. And that's one thing that I like to watch is sometimes I get real quiet. I'm not really listening to the testimony. I'm listening to the questions, not what the answers are. And a good lawyer can solicit yes and no questions, keep it precise and clean until he needs an expansion on those answers. And these people who are in CSI and lab people and all these kind of what I call professional witnesses, because it's a part of their profession, they know, if they've been on the stand a couple of times, how the procedures go. And they can make and break your case. They really can. And your questioning is what's guiding this whole entire thing. And so you've got to be on your game. And it's a lot of pressure. But for him to verbally say things like, I got to reorient myself, or I'm a little bit off my kilter, or I've heard some of them say I'm a little lost, give me a minute. And, you know, It doesn't build confidence as a juror watching these lawyers because you're like, okay, if you're struggling with keeping these facts straight, are you keeping everything straight? How can I trust what you're putting forth as evidence is clean evidence? I like clean evidence, clean testimony. All right, I'm going to get off.
Okay. All right, we're going to continue.
Of that bedroom, but just east of the entryway, the door is swabbed.
Yes.
We'll just say 2 light switches in the master bedroom were swabbed.
Yes.
That's there, right there. Okay. Was there also one located closer to that backyard door? Was there a light switch there that was swabbed?
Yes, there was.
Was there also a light switch located closer to the toilet in the master bathroom was swabbed?
Yes.
Okay. Was the washing machine swabbed along the machine itself? Do you recall that?
I believe that was done later.
Okay.
The handles or the knobs, yes. The machine, I think, was done later.
Okay. The guest bathroom toilet and lid, was that swabbed?
Yes.
And the handle of it?
Yes.
Guest bathroom seat and bowl of the toilet?
Yes.
And we talked already about this backyard, but let's go back to the backyard area. Was the sliding glass door bottom stoop area, was that swabbed?
Yes.
Okay. Was the were some of these swabs in conjunction with the individuals doing the blue star, indicating this part hasn't been swabbed, but notice some blue star? Can you go ahead and give us a swab here?
Yes.
Okay. And was that one of the areas that sliding glass door stoop was that was followed up because of the blue star?
Correct.
Okay. That northwest corner of the dining room, sort of the edge of the walkway there, was that swabbed as a result of potential blue star reactions?
Yes.
Was the west entry wall of the light switch swabbed as a potential blue star reaction?
Yes.
And we're going to get into blue star, and we'll see photos of the house with the blue star next week. So I went through a lot of these swabs and maybe moved pretty fast, but suffice it to say that even your role in the case, or in your observations of crime scene specialist Alexic, well, if you can just answer this, I don't know, I'll ask you to do math again, but can you, how many swabs are we talking here, just roughly, in the 2 days that you were there and observing these things taken?
Hundreds.
So there was a lot of swabs taken in this house.
Yes.
Is what I'm getting at. Okay. Now, before I'm almost done with my questions of you, but before we leave, we talked about the blue star. With also some areas on the couch on this day, on the 20th, that reacted to the blue star.
Yes, there was.
And what did you guys do with those areas as a result of that?
So when the blue star reacted, obviously that is photographed. During that time, I circled those areas so that we could see them with the lights back on. And then I took cuttings of the couch of those areas. So instead of just swabbing, I took the actual couch pieces.
So you're involved in selecting how many areas?
There's 4.
And those couch piece things were just cut out?
Yes.
And we saw a couch piece cutting earlier from photographs on the early morning of the 19th, labeled R. Is that a different couch piece cutting than what I'm asking you about now?
Yes, it is.
Okay. How did you, what were these couch pieces designated? Were they 1, 2, 3, 4?
I believe so, yes.
Okay. And what do you do once you cut pieces of couch?
So they were collected in packaging, taken back to the office, and because the blue star is a liquid, they were now wet. So I placed them in our drying cabinet and let them dry.
And were these couch areas, were they kind of labeled in some way, like 1, 2, 3, 4 on the cutting or on the couch, so that you could distinguish once you took the pieces away from the couch which one it was. Does that make sense?
Yes, they were.
Okay. Who else was with you on this evening, on the 20th?
Detectives were all on scene. Supervisor Carpenter was there. Also, CSS Jacobs was there. He was doing the photography for the Blue Star.
Was Stephanie Haas there on the 20th? Do you recall?
I believe so. I think she was also doing photography.
And who is she?
She was a crime scene specialist during that time with us.
Okay. Had you ever had contact with Ian Mitcham at any point in life?
No.
I'm going to ask you now just the kind of one other thing that you did as you were asked to do while you were still tasked as part of this case. Can you tell me about to show up somewhere on the 24th of February of 2015?
Yes, I was.
And tell me a little bit about that.
I was requested by a detective to respond to an address located near Allison's house in reference to a pair of underwear and a water bottle being found in the vicinity. Someone had picked it up and placed the water bottle in the back of her husband's truck and had actually collected the pair of underwear in a bag.
So did you, were those items ultimately collected by Scottsdale police?
Yes, I collected them.
And did you also, were you asked as a CSS to take some photos of that area when you collected it?
Yes, I documented the scene, the truck, where they were located.
You said it was close. Does the address 3042 North 86th Street sound right?
Yes.
And is that potentially within a few blocks of Allison's home?
It is, yes.
And that's on the 24th of February 2015. Why did the police go there? You might have mentioned this, but this is now about almost a week or so, 6 days. Why did
speculation?
Overruled if she knows.
Do you know why police would have been why were you asked to go to that home?
Because detectives had been requested out there since the lady had found those items of evidence and had heard about the case.
Just so we're understanding sort of the process that happens when you take swabs back and they go in this drying rack. You said you're wearing your regular PPE. What is that?
Gloves and a mask.
And when you're putting them in this rack, we had mentioned they're coming out of the package and that little cap is on them or off them at that point they come out of the package?
When they come out of the package, the cap is still on.
So you have to pop that little cap.
Yes.
Do you take care when you're putting each swab in the drying rack that swabs are not touching each other?
Yes, you don't overload. The swab dryer can hold, I think, close to 30, 40 swabs, but you're not overloading them. So you're putting them in areas and then you're notating where they are. They also, the caps are never coming off. They're just being moved down a little bit so that you make sure that the swab is getting air. And they also are having tags placed on them that have the case number, the date, the person who collected them, what the swab is, and if it's wet or dry.
And is this this drying rack thing, is this a thing that's unique to the Scottsdale lab, or is this sort of this, if you know from your certifications and training, is this sort of a standard thing that is utilized in crime scene processing?
In my experience so far, Scottsdale has been the only one who has specific swab dryers for this process.
So this is a really interesting line of questioning about the dryer, because I think we saw this in one of the Lori Daybell's hearings, which wasn't in Scottsdale. So the first trial for Lori was in Chandler, and the second was in Gilbert. Or was it reversed? Gosh darn it, I get them switched up all the time. But drying things out is a thing with police departments. Like, they get things that are wet and then they put them in a dryer. So that's what she's talking about now. She said Scottsdale is the only one that does it, and I don't think that's true.
Joe, it may be in their area, Scottsdale in that area. But you know, but also in the Karen Reed. Remember that Karen Reed, they opened up the clothing and that was put in a bag and left in the back of a vehicle that was mildewing and getting all, it was wet and mildewy.
Yes.
And they opened it up in the police department and let it just sit there when they could have taken it to the crime lab. They have very specific machines that dry these out in a manner that does not lose evidence.
Doesn't degrade the
And it doesn't, it doesn't degrade it, and it doesn't lose the evidence, because mold will, believe it or not, contaminate what evidence that's on the material. So it is a huge deal for them to make sure that these items are dried appropriately. But I will say, in Texas, I know all the big cities like San Antonio, Houston, and Dallas have these abilities. I don't think a lot of these smaller communities like mine do, so they have to send these items in a cop car, you know, down the highway for 2 hours to Austin or an hour to San Antonio from where I live, and let their crime labs do the drying for them.
Right.
It's vitally important to do it correctly.
Yes, it is. That's exactly my point in my London Valdez case, because the OSBI, the Oklahoma State Bureau of Investigation, got involved after her body was found. And according to my interview with Scott Hedrick, they were involved in the search before that. I don't know if that's true or not, but they also crossed state lines into Texas, so why wasn't the FBI involved? Like, these smaller communities have resources to reach out to the other larger resources, to the OSBI, to the FBI, and help us find this lost teenager.
Okay, I get that to a point, but I'll be honest that a lot of times there are agencies that don't get involved because there's a protocol on how they get involved. And just like when you had the flood with Katrina, and the mayor, then governor as well, of Louisiana, you had the president and FEMA and everybody, all these other states, everybody throwing demands to make the request, just fill out the request, just send us the written request for assistance. They refused to do it, and they had all the means to do what they needed to do, and they didn't do it, and it turned into chaos. A lot of damage was done to like the dome, and a lot of people got hurt, and some people died. There was a lot of bad things that happened. So there are procedures. So even though someone may cross state lines, depending on what it is, how long it is, and what's going on, the state has to request it.
I get that. My sister works for FEMA, and I have learned a lot about FEMA in the last 10 years since she's worked for them. They cannot come in until somebody requests them to come in and help. A local agency, a state agency, but
that's right.
But I'm not sure about how the FBI works. Like, if there is
this is my understanding.
Hold on. Let me say what my thought is, and then you can answer me, because you probably have an answer for my question.
No, there's a delay. I apologize.
If there is an act committed that is criminal that crosses state lines, which would be the conveyance of a minor across state lines,
right,
and back, and she is a runaway, she has been declared a runaway, can the FBI automatically get involved, or do they have to be requested to be involved?
It really depends. I'm sorry, there is a delay. I am traveling, so my apologies. Okay, so if the state is in charge of the case and it goes across state lines and comes back like that did, the state and the FBI just can't come in on their own. They have to get in an agreement with the state. Now, they can go to the state and say, we want to take this over, and the state will say, sure, go for it. Or the state will say, no, we want this. If they say, no, we want this, then they don't come in. But there's some crimes that they do automatically trump. Some crimes they don't automatically trump. There's a lot of fine hairs within the laws. So when you have somebody, for example, who commits a cyber crime from Texas to Tennessee, Texas and or Tennessee can handle the case. However, if that crime goes to the point where it's against children, then the FBI can try to put charges and get involved. Now, sometimes state crimes hold longer sentences and penalties than federal crimes. So a lot of times they will, in my humble opinion and personal knowledge here, they will back off and say, okay, we'll let this remain a state crime because they actually can get more time and penalty for it. Okay? But now, if the crime becomes more, like if you do the crime once across state lines, doesn't mean that the feds are necessarily going to get involved. Now, do you commit that crime 50 times across state lines? That elevates it. Yeah, you betcha they're going to get involved. It just depends on the crime itself, the severity, the frequency, and what the laws are between when and where and how they get involved. Now, if the federal agency finds the crime first, so now you committed a state, say you were purchasing illegal goods across state lines, right? Say the feds were watching the person you were purchasing from, and they catch you purchasing illegally across state lines. That is their case because they caught it. They caught the case. They can't, but if the state catches it, they got the case. And then they can work together and agree who gets to prosecute. That is my humble understanding of it from personal experience. I myself wasn't found guilty, but a family member.
Yeah, and it makes a difference if it's like a financial crime versus a crime against a person. And that to me is disturbing, because if somebody steals from you $99,000, $999, anything less than $10,000, the FBI won't get involved. Like literally, somebody can steal from you $90,000 today, and the FBI won't get involved. But if it's $100,000 or above, the FBI will get involved. So
can get involved, not always. They can choose.
Right. Yes. Yeah. Correct. Yeah. They always can. Like, do they think they have enough evidence to prosecute? Do they not? But
well, and not only that,
they won't even investigate if it's not $100,000 or more, though. Like they won't even touch it.
Right, and the thing is also who else is involved in this crime? Do you have one person that's on the federal level and 10 people on the state level? Then they're going to probably let the state handle it. If you've got 8 people on the state level and 8 people on the federal level and 1 or 2 on the state level, then the feds will probably handle it. There's a lot of contingencies. That's the word I was looking for, contingencies. We're going to take a quick potty break in about 10 minutes. So, yeah, she was getting ready to doze off, and I'm like, don't go to sleep yet. But well, you know, it's so hard.
That factors in to the London Valdez case, though, because you have Jose Menyares, who is the one who picked her up from her grandmother's house on June 5th, and introduced her to Braden Brown. And he had just been released from prison by the judge 2 months earlier. So he's on probation.
He's on parole.
Yes. And he got a 7-year sentence that was deferred. Like, who gets a 7-year sentence deferred? Who does that unless they are in cahoots with the government on some level? Like, are they a narc? Are they a snitch?
Well,
Whatever,
yes and
whatever they
no.
are. Yeah, I don't know. I don't have the answers
I
to that.
agree with you. I don't like that sentencing, but also understand certain jurisdictions, certain states also, some states have higher rate of overages in their prisons, and they're so overly populated that depending on what the crime is, depending on the risk factors, depending on a lot of things, I know somebody here in Kerrville that got a 10-year deferred, and
Oh, wow.
yeah, and it was because of the type of crime it was, and also for the fact that they did not want, they're really trying to not overcrowd the prisons because it's so bad right now across the United States. Prison overcrowded because they're not building enough prisons for the number of inmates that we have, and in fact they've shut them down.
But they let this guy out on a deferred
Yep.
sentence. He picked up a 16-year-old from
Yep,
her
I'd agree.
grandmother's house, kept her out for 2 days, and she ended up dead. So let's
Out
talk
alive.
about that.
Well, I don't disagree with you on that at all. I mean, there's a lot of people out on probation, parole, and or supervised release that are reoffenders. And the thing is that the system's very broken. But we can go on and on and on forever. But when you're tying it back into this case, everything hinges whether it's state or federal. There's just a lot of contingencies before, it's never the same for every case.
Yeah.
You can have two identical cases and the state will take it or the feds will take the other one. And it just depends on jurisdictional areas. It depends on the memorandum of understandings. It depends on the law, how the laws are written, who has the authority rights. And sometimes they just say, do you know what? Our plate is full. State can handle it. We've got too much on our plate in this jurisdiction. State, you go ahead and have this. You got our support.
Yeah, and that's kind of where I'm kind of scared about the London Valdez case, because he ended up.
You need to stop and go bathroom. Go ahead.
The DA ended up charging him with second-degree murder, but now he has to prosecute second-degree murder. He has to sell it to a jury. So
yep,
it's scary for me. It's scary for the family. It's scary for anybody who has a vested interest in this. Like,
yep. Unfortunately, the system is flawed, and even in this case here, the Ian Mitchell trial, I'm seeing holes. And like the Walshe trial, oh my gosh, you want to talk about uncomfortable for me in the fact that he was found guilty of fraud. I mean, he pled guilty to fraud, and it is a money crime. Okay, it's a white collar crime, but he unalived his wife while he was on house arrest, and he lied and manipulated house arrest. In my humble opinion, I don't think he was well monitored. They did not have a GPS on him. They just had the ankle monitor that when you left home would alert that you were no longer on property. And my ex had one of those, and he had to tell them that and then he had a receiver at work and one at home, and he had so much time to get from point A to point B, and he couldn't go in certain areas. He had to drive a specific route. But here he's lying and saying he's going to pick up his daughter when he was going out to eat or doing whatever. So, in my humble opinion, you pled guilty. You're waiting for sentencing. You need to be in jail. No release. Even with an ankle monitor. Once you plead guilty or found guilty, you're a ward of the court. You are now a ward of the state. Sentencing is just a formality, and to me, the moment guilty comes out of the judge's mouth, you are no longer a free person. You're a ward of the state. You need to be in the state custody. Had he been in state custody and not at home, his wife would be alive today.
Yeah. Nothing good happens. Nothing good happens when they get let out.
No. And not very many people will plead guilty and then end up sitting at home arrest with an ankle monitor before sentencing. That was very unusual. I don't
Yeah.
know if I've heard anybody else in that situation. Now, I have known people who made a guilty plea through their lawyers, and the judge said they had to turn themselves in on a certain date and time, usually a couple of days, maybe a week at the most, depending on what's going on. And the documentation and everything is filled out, depending if it's like they plead on the weekend, then they may not go to jail the next Wednesday. But other than you pleading out and you surrendering yourself over for a date of entry, which I've heard in some minor crimes, I've never heard of them putting somebody on ankle monitoring and having them be monitored at home while they're waiting to go to prison.
Yeah, no. All right,
He
I'm
could
gonna
have
hit
wounded.
play.
What did you say? What? Wait. I want to read this comment. I can't read it while I'm driving. Can you read Ari's comment that I just popped up, please?
Ari.
At the very end, he could have worded it.
Oh,
It's on the screen.
were all of the light switches in every room of the house swapped? That way the question is specific as it can be without asking about each individual light switch.
Yeah, that's what we asked, and that's what we agreed on. And then if she said no, then which ones were swapped and what were their results? Plain and simple, clean and clear.
Yep.
Yeah, no. But anyway, every jurisdiction does things differently as well. So once again, we're not lawyers. We're giving our own humble opinions.
Yep.
But I am a criminal justice graduate tomorrow.
Yay! Congratulations. That's so awesome.
Yeah, I'm going. My interpreter's in the car. Poor baby. She flew in from North Carolina at 10:30 in Austin last night. We didn't leave there till 11:30 by the time we got her to the car.
Oh my gosh.
We drove over 2.5 hours home. We got home like at 1:30, got to bed at 2:30. Then she had to be up and ready to work at 6 a.m. my time because she's interpreting for student classes today.
Yeah. It's these life moments that are so precious, though. So thank you to her.
In my past, I didn't think that this was going to be such a big deal for me, but as I look back on my life, the fact that people have told me all through my life, you're not that smart. You may be street smart, but you're not book smart. And that, college is not for you. Even my ex-husband said, you can't learn a Mac computer. PC, but I don't think you're capable of learning how to use a Mac. Well, when he went to prison, that was the first thing I did. Got me a Mac, and I use it better than I do the PC. But being able not only to graduate, but to get 71, I figured it out officially, 71 hours of education from August of 2024 to December of 2025, and be 1/10 of a point away from summa cum laude, which is the highest you can go. I'm a magna cum laude. I never tried to even achieve for that. And a lot of organizations that have supported me through this journey have given me a bunch of honor cords. I didn't even know about those. And I'm at the point right now, I'm 54-year-old dyslexic deaf woman. If I can do it, there's no reason why anybody else can't do it. It's just a matter of putting it in your mind to do it.
100%. You are such an inspiration.
Not yet. Let me get my master's and PhD, then we'll talk about it. All right, get back to court.
All right. I'm going to hit the play button.
Other places just have you lay the swabs out in a dryer or in a designated area so that they get airflow and have a chance to dry.
So Scottsdale has a unique specialized racks just dry swabs like
yes.
So could you approach?
So, Joe, they were talking about drawing swabs. That's a small container. That's something every lab should have. Those are swabs. It's not like a full bedspread. Joe, can you mute that, please? I'm sorry, I don't want to get dinged on their music.
What the heck was that? Oh my gosh.
Oh, I hate all the court TV starts putting music up now, and and many times I get copyright struck because of it.
Oh my gosh. That caught me off guard.
So let's talk about the drive. Another question. Can you read that to me, please? From Ari.
For those not sent for testing, why were they not sent and got tested?
Okay, so for example, if you have a house and it's very evident that the crime happened in the living room, kitchen, dining room area, right? And the second floor looks pristine. Nothing on the second floor is touched. Everything looks pristine. They may go ahead and swab every single one of them. And those that were upstairs, they just kind of put on the shelf just in case. That later there's evidence that shows that maybe something did happen upstairs. It's just to cover their anatomy. But they're going to focus hard on the switches that were in the downstairs area, that where the red room actually happened, for example. But it's just to cover your anatomy. And, you know, when they go through and do all this, sometimes they don't realize anything was upstairs. It's too clean and pristine. But they go ahead and swab it anyway. And then say a year later, they get a witness or they find out that, hey, it started upstairs and went downstairs. And then the person who said that they went back upstairs to get their shoes and left, well, they could have left some DNA. So then they can go back years later and test to see if there's any DNA on those swabs. Does that make sense? It may not be the best example, but it's a lot of it is CYA and just in cases. But
right.
it's just outside the focal point of their investigative field within the area of the investigation, and they are doing it just in case. It's like when I was a photographer, I've done a couple. I used to work for a private investigator, and a couple of times I did photograph scenes, crime scenes, and I would spend a ton of film. That was before it was digital. And nowadays, I would shoot probably 10 photos per item more than what's needed. Always overshoot because you never know what you're going to get. In my humblest of opinion, that's why.
Are we back on track with the video?
I don't know. Let's see.
Let's see.
Now I got the hiccups.
It's a crapshoot. It's a crapshoot.
I just got an image I didn't want in my head. How are we on the verdict watch? Where are we at on that? Do we have something going on? Looks like they have a court feed. Am I wrong?
I don't see it on court TV.
Well, what do I have something up in the back. I'm going to take you down for a second.
Yeah.
I'm going to put me up. Oh, that's something else. Okay. I just couldn't, it's so small, I couldn't tell you what it was. All right. Do we know how many hours or minutes it's been?
I have no idea.
Court TV usually has a time clock or like...
Yes, 2 hours, 9 minutes, and 7 seconds.
So it's 2:35 there. How many of the viewers think, and
you can put it in chat, and I want to hear your opinion, Joe. How many of you think we're going to get a verdict today, and how many think we're going to get it Monday?
2:35. That's Eastern time too.
Yep.
Gosh.
Can't. It's in mass. I mean.
I'm gonna waffle on that because I don't know and I haven't seen the jurors, and it makes a difference when you can see the jurors and you can see their affect. You can see how they respond to the court instructions. You can see how they respond to the jury instructions. You can see how they respond to the closing arguments. And I had no idea that in Lori Vallow Daybell's second trial, we would deliberate for about 15 minutes and come back with
we all knew it was going to be less than an hour. That's where we were. Okay, I'm going to say my opinion is potentially today, but if I was a betting woman, I would say Monday. Although Friday, a lot of times they will, if they're close to coming to a verdict, a lot of times they'll push harder to get to it on a Friday so they don't have to go back.
All the questions for this witness. May this witness be excused subject
Very
to
true.
And you may step down now. Thank you.
But I think it may be as long as Monday. I hope I'm wrong.
Sure, absolutely. And ladies and gentlemen, just a reminder, you may recall I talked to you about this in the preliminary instructions, but sometimes you might submit questions and I may not ask the questions. Don't feel bad about that. There may be legal reasons, or this may not be the appropriate witness to ask those questions to. So that's the reason why sometimes we don't ask the questions that are submitted. So with that, let's take a quick 5-minute break. We will return shortly, and please remember that admonition.
Okay, everybody take a 5-minute break.
All right, I want to talk about that question for Honey. Honey was, yeah, you might want to mute that before that music comes on, please. If they come back with a question about the forms, then will it be today? If they come in about a question about the forms, I think it's most likely today, but I have seen it where they came back with a question about the form and they still deliberated another day and a half. So I think that is that's a crapshoot as well. It really is. But I find more often than not, if they come back about a question about the form, then it's usually within a few hours there's a verdict, in my humblest experience. Next year, I hope and plan, I don't know about you, Joe, but I actually hope and plan to try to get out of my office a little bit, depending on what I'm doing for a living, because y'all, it's going to change. I got to get a full-time job. YouTube isn't paying the bills, so I'll be changing my formatting. I'm still going to be here. We're still going to do it. Just I'll be doing a lot more at night and then playing it in the morning. But I really hope to get my butt actually in courtroom in my county and maybe even San Antonio a lot more, so I can get more live court experience.
It is amazing. It is an amazing experience. Like you can't substitute sitting behind your laptop, behind your keyboard. And jury selection is one of the most amazing experiences, but also the actual trial and watching the jury members and watching the witnesses, watching the families and the victims and the ones sitting behind the defense. Like, there's no substitute for in-person viewing of that. It's amazing.
Yeah, well, I did not, someone asked me recently and I didn't answer, but I will today. They asked if I sat in my husband's trial. No, even though I was his wife, I was a witness and I had every right to sit in. His attorney told me that it would be more believable if the jury did not see me in the courtroom and would believe my testimony more if I was outside of the courtroom. Because if you're a spouse and you're sitting in, which you have a legal right to do, and then you get up and testify, and I was the last witness they called,
they tend to not always believe you as much because there's always that doubt of whether you altered your testimony to help your husband. So I agreed to sit outside. Now, hindsight 2020, I shouldn't have, because they threw me under the bus, trying to create reasonable doubt in his case. And I didn't know it when I went on the stand, and that was a whole nother debacle. But so I did not sit in on his trial. I think hindsight I would have. I wouldn't care what they thought. I wouldn't even agree to testify. I'd make them subpoena me. And also, if you ever find yourself in a position of being a witness for a family member, get a lawyer to represent your best interest. That's all I'm going to say about that. But I really, really, really would like to sit in on some trials starting from jury selection all the way through. I think it'd be a good experience, but we'll see. Depending on what job I end up getting, I may be doing that anyway as a part of my job.
Nice.
Well, you know, a lot of people get this degree going to be police officers or military or other, you know, things like that, but I can't do that. I'm too old. Excuse me, I'm way too old for that. So I wouldn't mind being victim's advocate. I wouldn't mind being, there was a juvenile probation job opening that happened, but they could not even accept my application until I got my diploma, and they had to fill the spot before I graduated. So next time, maybe. But I'm also looking at potentially doing adult protective services, and until I can get my master's.
Victim's advocate is so hard, because I've found out through the Lori Daybell case and through my London Valdez case, there are lots of victims and they don't always get along. Like, they have their own personal.
Your victim advocate have their own personal agenda and wounds that they're dealing with, and they think that becoming a victim's advocate will help them.
No, just helping the families who are victims, because you have multiple family members that are victims.
Oh, okay? I got you.
You have, like in the case of London Valdez, you have Mom, you have Aunt Rochelle, you have Grandma Liz Taylor, and they're all victims, but they don't always get along 100%.
Oh, yeah.
Like, they have some personal conflict, and when you have a family member that dies, that just like exacerbates that to a whole level you can't even understand. Like, they're in so much trauma that they want to take those relationships and the discord, and they can exacerbate the discord.
Well, so I don't disagree, but understand that as a chaplain, as an emergency services chaplain, as a lay minister, I deal with that all the time. I will show up on a car accident scene where someone's eventually deceases. I'm in the hospital with 30 of their family members, and half of them aren't getting along. And it's my responsibility to keep the peace and order and to get all of them through the next 48 hours or more. And I have to deal with all those different dynamics and personalities and woundedness. And that experience I already have.
It's just so rough because
it is.
You want to identify with this family member that's a victim, and you want to identify with this family member that's a victim, but those two family members don't get along. So all of a sudden you're in a triangulation type of moment, and it's
that's when you have to remove yourself from that triangle and say, look, I can't identify with either one of you. I can empathize. I'm not going to be sympathetic. I can't. I can be empathetic. And you have to emotionally remove yourself. And that's one thing as a first responder. For as long as I've been a first responder, I've been a first responder since 2008. In one fashion or another, in dealing with in the 15, almost 18 years, but I think between 15 and 18 years, I was a Red Cross, and I was dispatched to every major hurricane between Katrina and Harvey, and dealing with a lot of trauma and dramatics, and I've learned how to healthfully separate myself from the event. And then, of course, you do have people that you go and talk to and decompress and deal with the hard cases with, but that's what cops have to do. That's what firefighters have to do. It's what a lot of them get PTSD, and a lot of them end up having troubles in life, and that's partially because they don't have the support system. Either they choose not to have it or they just don't have it to help them walk through the trauma they've experienced. Let's talk about the Kerrville flood for a second. There's so many people that are still very, very traumatized 6 months later that just driving by certain locations, they start crying, and learning to have that skill to work with them, but also knowing that you too need to get your own help. And you need to keep yourself owned spiritually, physically, emotionally, psychologically, all of it healthy. And when you work in areas such as adult protective services, child protective services, or anything in the legal for any field that you experience trauma, or families of people that experience trauma, physicians, nurses, it's vital that you get that help. So if I do go into that position, I already have a system set up because I've been doing it for so long. My problem is my problem is going to be I have a hard time working with people who are comfortable in their mess and choose not to get out of that mess. I dealt with it a lot with the Red Cross, where their homes were messy and horrible to begin with because they didn't take care of them, and they just didn't and they don't want to get out of their mess. They're willing to go right back into it. And you want better for people, and you know they can do better, but they don't want better. You can't want it enough for them. That's where I struggle, is when people are okay with what's going on, and it's not okay. I wonder what happened to you that created such a wound that you're not willing to see that what you're going through is not healthy. You prefer to live in your mess than to clean it up. That's where I struggle.
I don't want to live in a mess. I want to help victims. That's where I'm at, and it's a
hard line. And in order to do that, you're going to have to keep yourself out of it. Is be there and support and be kind and all of that, but emotionally you cannot pick up sides at all. Here's one thing that I learned, and people know my channel, and this is my channel, so I'll say whatever I want. I respect everybody's beliefs or non-beliefs, but I am a Christian. I'm a chaplain. Of course I'm a Christian. And I believe that God allows things to happen for the betterment of us, no matter what it is. We may not see it at the time, but as I told somebody the other day, if you knew my full testimony, you would be shocked. And everything I've gone through has put me in a position right now where I can be empathetic and help people and understand their struggles. And I fully understand what woundedness looks like, and I can fully identify it, and I can help those that are wounded walk through it, but those that are walking through it with them who don't understand the woundedness, I would not otherwise have the ability to do in my own life. And so sometimes people got to walk through some really tough roads, because guess what? There's somebody in their path up ahead in the future that is going to need them. And if they didn't walk through that, they wouldn't be able to be there for them. That's the way I have to look at it.
The subtle nuances are what I struggle to navigate the most, because I've dealt with some things.
Yeah.
But I've had the best of intentions the entire way, from beginning to end. I've had the best of intentions, but that doesn't matter to most people.
Well, the way I see this on all of those kind of things is roads are paved with best intentions. We all do the best
we all have walked through something similar, maybe not the exact same thing at one point in our life, but you know, all we have to do and all we can do is walk with our own integrity, our own best intentions, and know that our truth is our truth. And if people refuse to accept it, people refuse to believe it, people refuse to honor it, then that's on them. Keep moving. In the end, when you die, your integrity is about the only thing you take with you. And doesn't matter. Same with these verdicts and these courts and these hearings and these people. You know, I keep looking at them thinking there's a lot of what ifs. There was like with the Walshe Trial, and what if he was in jail and waiting sentencing and not home on house arrest? And there's just a whole lot of what ifs, and we can't go down that road. All we can do is say, okay, this is the path we're on now, no matter what choices were made, either by us or for us. This is what we're dealing with. Now, how can I make this crooked path in front of me straight? Where do I need to step next to make this straight? And that's the way I have to face it. And oh my gosh, Ian Mitcham murdered who? I'm pulling a brain cramp. Who did Ian Mitcham murder, Joe?
Court TV is doing something else.
Well, yeah, they're gonna bounce around until the verdict comes back. They always do.
Okay, so I'm going to Ian Mitcham murder.
Yeah, that's what you got on right now up on the screen. Who did he Redrum?
Oh, his wife.
Right. You know.
So do you want me to hit play and play it some more?
Yeah, I was going to finish this thought though.
Yes.
The thing is that there's a lot of trauma that's created not only for the family of the victim, the wife's family, but his family as well. And that's one thing I said yesterday, or tried to say yesterday, is that there are more than one victim in that courtroom. The parents of Ian Mitchell, the family members of Ian Mitchell, unless they were abusing him as a child and created the monster he became, there's a lot of victims and there's a lot of woundedness, and I think as a victims advocate, we need a lot more of them. And there's not enough of us out there. Go ahead.
All right. You want me to hit play?
Play.
Here we go.
And I'll have you take a seat up here in the witness box. Thank you. And you may proceed.
Thank you. Good afternoon. Could you please introduce yourself to the jury?
Yes. My name is Stephanie Hans. The last name is Hontz, and I was a crime scene specialist for Scottsdale Police Department.
I think we're going to need you to pull that microphone
Oh,
a little
I'm
bit
sorry.
closer to you.
Sorry. Is that
Especially
better?
if you're turning that way. Yes.
Okay.
You want to make sure everyone can hear you.
Okay.
So you mentioned that you used to be a crime scene specialist with the Scottsdale Police Department. Are you currently working?
I am not.
Okay. Stay at home mom?
Yes, I am.
All right. But you mentioned that you previously worked for Scottsdale Police Department.
Yes. In December of 2008, I started with the department in the property and evidence section. And in September of 2009, I transferred over to the crime scene section.
Can you tell us about your educational background?
Yes, I have an associate's degree in forensic science through Scottsdale Community College, and I have a certificate in crime scene processing, as well as a 16-week on-the-job training when I was hired with Scottsdale Police Department. And I received a crime scene analyst certification through the International Association of Identification when I was with the department.
And then what time did you leave Scottsdale Police Department?
I left in February of 2021.
So from 2009 to 2021, you were working as a crime scene specialist.
Correct.
You obviously know why you are here today. Back on February 18th of 2015, were you asked to respond to 8526 East Monterey Way in Scottsdale at approximately 9:20 p.m.?
Yes, I was.
And were you responding to assist with the processing of a crime scene?
Yes, I was.
Prior to your arrival at this address, were you aware of the type of scene you were going to?
I was aware of the type of scene, but I wasn't given any information about it.
Do you recall where you were? Do you recall where you were when you received the call?
Yes, I was at home when I received the call to come into work.
When you received the call before you went out to 8526 East Monterey Way, did you stop somewhere before you actually went to the scene?
Yes, our procedures were to go to the station to get dressed, to get our equipment in a vehicle before we went to the scene.
So you were at home, you then go to the office to get all the things that you're going to need to do your job, and then at that point you go out to 8526 East Monterey.
Correct.
Now, once you got to that location, prior to entering the home, did you put on any protective equipment?
Yes, I put on gloves, booties, and a mask.
And just so we know we're talking about the same thing, I'm going to show you what's already been admitted as Exhibit 45. Oh. Do you recognize the home in that photograph?
Yes, I do.
And is that the home that you responded to back on February 18th of 2015?
Yes, it is.
While you were at home, is it fair to say you went out a couple different days?
Yes, I was there a couple days.
And we'll cover those different things. Did you have time to spend time in the front of the home, inside the home, and as well in the backyard?
Yes, I was.
I'm showing you what's been already admitted as Exhibit 53. Do you recognize what's depicted in that photograph?
Yes, I do.
Is that the backyard of the same residence?
Yes, it is.
So you get to You get to 8526 East Monterey, and I think you arrived around 9:20 p.m. Does that sound about right?
Yes, it does.
So when you get there, what is the very first thing that you do?
Upon my arrival, I contacted CSS McKenna and asked what I could do to help her with the scene.
Now, is CSS McKenna now known as CSS or former CSS for Scottsdale Davis?
Yes.
Okay, just so the jury is clear. And we just heard her testify. So that's who you spoke to when you arrived?
Correct.
Other than your boss, Mark Carpenter, who we've heard about, was she kind of the lead crime scene specialist that everybody was kind of checking in with?
Yes, and specifically that night.
So you spoke to CSS McKenna, and then what did you do at that point?
She advised me I would be in charge of doing the Faro scanner throughout the interior house.
Before we get to the Faro scanning, when you arrived at the home, did you notice anything particular about the smell?
There was a strong chemical smell throughout the home.
In response to that smell, did you have to use any additional masks or equipment in order to kind of deal with that?
We put on masks when we went inside the home because of the chemical smell.
So you mentioned that you were asked to do the Faro scanning. We heard a little bit from crime scene specialist Palma, who kind of talked a little bit about it because she mentioned there were targets on the wall for Faro scanning, but beyond that, we really didn't get a description of really what it is and its purpose. Could you let the jury know about that?
Yes, the Faro scanner was used on the scene to document every room, which those scans could be used as diagrams for later on or to do measuring points between two items. And the targets on the wall were, for that specific Faro scanner, you had to have 3 targets in one scan to be able to connect the rooms together, which was the purpose of this targets on the wall.
Now you go inside and you're going to do the Faro scanning. Is this done prior to anyone touching and moving anything?
Yes, overall photos could be done before the Faro scanner was done, but the scanner is used to document the scene as is before anything is moved or touched.
So basically, when people go to the scene, we've heard that it is your focus as CSS is to make sure that things are done when the scene is as it is or in its pristine condition. So are the first 2 steps of doing that, taking overall photos, and then if there's a decision to do Faro scanning, do those occur basically as the first 2 steps?
Yes, they are.
You mentioned that you did the Faro scanning of the interior of the residence. Was somebody responsible for doing the Faro scanning of the exterior of the residence?
Yes, somebody else took care of the exterior residence because light is needed for the scans to be clear. And since it was dark, it was nighttime, they were done during the day for the exterior scans.
So is it the same type of procedure for outside, meaning that overalls would have been done of the outside, Faro scanning would have been done of the outside before anything outside was touched or processed?
Yes, it would have.
Do you recall who actually did the outside Faro scanning?
I believe CSS Jacobs did the exterior.
When you're moving about the house and doing the Faro scanning, or anything else for that matter, are you creating notes and documenting every step of what you're doing?
Yes, when whoever is in charge of doing the Faro scanner makes a diagram of the house, the layout of the house, and you mark where you're putting the targets and where you are doing each scan.
Other than doing the Faro scanning on the evening of February 18th, 2015, did you have any other involvement at the scene that night?
No, I did not.
And then upon your completion of the Faro scanning, did you then author a lab report memorializing what you had done?
Yes, I did.
Now, I established with you a little bit earlier that you responded to this location on a few different occasions to help process the scene. Fair?
Yes, I did.
Was the next time you were asked to respond on February 20th of 2015?
Yes, it was.
Same question I'm going to ask you. Before you went in and had any involvement with the scene, did you put on protective equipment?
Yes, that day it was booties, a protective suit, and gloves.
When you arrived on the scene that particular day, did you then, like you had done on February 18th, check in with somebody to get some direction as to what you were going to be doing that day?
Yes, I did.
And who was that?
It was CSS Carpenter.
Were you asked to do multiple things while you were working on February 20th?
Yes, I was.
Okay, I'm going to start with what you were first asked to do. Did that involve doing some work in the alley?
Yes, it did.
Tell us about that.
I was asked by CSS Carpenter to go in the alley to document some patterns that were in the dirt that they wanted documented as shoe imprints.
When you arrived to do the collection in the alley, did you notice anything about whether the scene was secured with tape? What was going on in the alley?
Yes, the alley was secured with police tape to block it off.
So the only people who were allowed to enter and or exit, to your understanding, were those employed by Scottsdale Police Department?
Correct.
And sorry, Ms. Otis, I can see a little bit of your notes also. I just want to make sure. Sorry. Thank you.
We're it's a little squishy up here. Thank you, Judge. Now, is the only thing that you were asked to do when you went into the alley, did that just involve you taking photographs?
Yes, it did.
No collection of anything?
No collection.
I believe that the defense is stipulating to the following photos, which are 406, 407, 408, 409, 410, 411, 412, 413, 414, and 415.
And just confirming no objections.
No objection.
It's ordered admitting exhibits 406 through 415 evidence.
Ms. Hans, I'm going to put on what's been marked or admitted at this point too as Exhibit 406. We've heard about these placards. Can you just tell us a little bit about the date and the time?
Yes, the date and the time are for when we arrive on scene, and right before we start our photographs, we document the case number, the time and date that we are there.
So when you have at a particular scene are taking numerous sets of photographs of various things, are we able to tell from your placards the order in which you've done that based on the date and timestamps?
Yes, it is.
So based on when you arrived on February 20th, we can tell from the timestamp that this was the first task that you had that day?
Yes, it was.
I'm putting Exhibit 407 on. You're speaking of, I looked when you were asked possible impressions.
Yeah.
What can you tell us about the double A and double B? And I'll have a closer picture, but what can you tell us about those placards?
Those placards are meant to mark where the impressions were, so we know from a faraway distance what we're looking at, so we can get closer but identify where they were to start.
I'm now putting 408. Is that a more zoomed in version of those two placards?
Yes, it is.
And I believe here's an even more zoomed in photo in 409.
Yes, it is.
And can you explain what the purpose is of the different vantage points?
The purpose of the faraway, medium, and close-up is just to give us an idea of where we are and what we're looking at. So we have orientation of everything, but also different lighting of impression to get better detail.
And the double A and the AB placards, are you able to tell from this particular photo what they're denoting?
Those are just marking that there were two separate areas that we were documenting for shoe impressions.
I'm now going to show you Exhibit 410. Is that a different part of that same alley?
Yes, it is.
And can you explain what we're looking at in this photo in terms of direction?
In terms of direction, we're looking further down in the alleyway and just along the edge of the back wall to the residence.
So there appear to be in the middle of the photo 410, two additional placards. Those other impressions that were noted that you were asked to photograph?
Yes.
Or I guess I should say possible impressions. In Exhibit 411, are those close up, or I should say more zoomed in photographs of those two placards?
Yes, they are.
Now, in looking at Exhibit 409, the double A and the AB, I think to probably everybody in this room except we may not see anything. So I'm going to now put up Exhibit 412, and I'm going to ask you about this. First of all, can you, that might have made it worse. Can you see that little white piece of paper in the upper corner of the photograph?
Yes, Anne.
What is that?
That is a marker that we use on in our photographs, I should say. And that is so we know what the item is, the case number, what the placard number is, and the directionality. We can show which way is north or up.
Okay, and if you can see on that little white piece of paper, I asked you about placards AA and then A and B. Do you see what this is representing in this particular photo?
Yes, that is PMAA.
Okay. And you have that ruler around a particular area, and it looks like from this photo, you can kind of see something in the center. Is that what you are capturing?
Yes, it was.
I'm now going to put photo 413 up there. What is the difference between 412 and 413?
The difference is the item number. This is showing PMAB.
So that is the second impression that you were asked to document in that area by that, what is that thing called? It was like a
utility cover?
Yes.
Yes, it was. This was
Okay.
the second one.
Now I put up again in Exhibit 411, A, C, and AD. After you placed the placards, did you then employ the same procedure by bringing out the ruler and doing a different type of capture of those possible impressions?
Yes, I did.
I'm going to show you Exhibit 414. Which one of the impressions are we looking at in this photo?
This is PMAC.
And then in 415, it looks like the AD is also captured in this, but is this the same type of capture of the impression?
Yes, it is.
Now, after you completed your work in the alley, did that essentially complete your work in the alley?
Yes, it did.
You weren't asked to photograph anything but those two areas that we just saw?
Correct.
After the work in the alley, were you then asked to photograph a vehicle that was parked in the driveway 8526 East Monterey Way?
Yes, I was.
What type of vehicle was that?
I would have to refer to the notes.
Sure. I believe your report is up there. If that will help refresh your recollection. Okay. May I just try to assist the witness?
You may.
For ease of time here?
Do we know what page you're on? What was it? Do we know the bottom? 507.
Joe, I need to let you know for some reason my battery is real low, so if I drop, it's because I lost power. It's charging, but not as fast as it needs to.
Yeah, that is. Thank you.
And remind me the exhibit number that this is.
Can you look on the cover?
30. Oh, 30.
Exhibit 30, and I believe she's referencing between 524 and 530.
It's 30. Yes.
Thank you.
Okay. And to answer the question, based on my report, I was photographing a 2009 BMW 335i that was a door vehicle.
Okay. Now, I'm going to put up, I believe the defense is also willing to stipulate to exhibit 300, 301, and 302.
And is that correct?
That is correct.
It's ordered admitting exhibit 300 through 302 into evidence.
I put up what's been admitted as Exhibit 300, and we're seeing this photo again. If you look at the time, does that denote that this would have been kind of your second task on February 20th, 2015?
Yes, it did.
So this looks to be about 2:35 p.m.
Correct.
when you began these photos? Exhibit 301, do you recognize that?
Yes, I do.
And what do you recognize that to be?
That was the vehicle in the driveway of the residence that I photographed.
I want to ask you, when you photographed the vehicle, did you photograph both the interior and the exterior?
Yes, I did.
And we saw in that photo that the vehicle was still confined within the crime scene tape. Was that how it appeared when you were asked to photograph?
Yes, it was.
Did you have to get into the car to actually photograph the exterior or the interior, or were you able to do that without disturbing anything in the car?
I was able to do it without getting in or disturbing the vehicle.
On this particular day, were you asked to do anything other than simply photograph the car?
No, I was not.
There's a few things in your report that I believe you mentioned seeing the car. And I just want to cover a couple of those things with you. I'm showing Exhibit 302. Do you recall that?
Yes, I do.
And what do you remember that to be?
Referring back to my report, that there was dry cleaning on the rear seat and water bottles in a what appeared to be a tan sweater.
And then I'm going to show you what's already been admitted into evidence as Exhibit 62. Did you also notice that and photograph that?
Yes, I did.
And what is depicted in that photo?
It is a drink container from Paradise Bakery that has contents in the bottom of it.
And again, you weren't asked to collect anything from the vehicle, is that fair?
Correct, just document.
So you do the work in the alley, then you were asked to take photos of the car, and then finally, on the same day, were you then asked to take additional photos and then collect additional swabs from within the house?
Yes, I was.
Now we heard, as I mentioned earlier, from CSS Bree Davis, and she mentioned, she told us about the swabbing process and the use of, she referred to them as Integra swabs. Do you typically, as you utilize swabs, refer to them at whatever time frame you're using them by the name of the brand?
Yes, as the brand changes, you may change the way that you identify the swab, but they are all the same.
So if you've referred to them or someone's referred to them as Integra swabs or Capture swabs, we're talking about essentially the same type of swab. It just might be a different brand name at the time that you're using.
Yes.
Did they typically all appear the same way?
Yes, they did.
We heard about the swabbing process, so I don't want to go through that whole process with you. The only thing that I want to ask you is, as a crime scene specialist group, do you try to remain consistent in the way that you swab items, surfaces, stains?
Yes, and that is part of the 16-week on the job training, that everybody does things in the same fashion, so the work is consistent across the board.
Now, when we heard from CSS Davis earlier, she mentioned, I think it came out on cross-examination or maybe even direct examination as well, that sometimes, despite your best efforts, when you're utilizing swabs, the sticks break.
Correct.
What didn't get asked, and I would like to know the answer and have the jury know the answer as well, is when that type of situation happens where you're swabbing something and the stick breaks, what do you guys do?
If a stick breaks, it breaks. The swab off the top of the swab is closed in a secured area. So we just put the other half of the stick separate from it, and you send that all to the lab. But if it breaks, it doesn't affect the swab or what you have swabbed it on. If you start swabbing and it breaks pretty soon, you impound that swab as well as the second one to make sure you got the entire surface you needed.
So sometimes if a stick breaks, you may not need to do another swab. You're just fine utilizing what you had done with the first swab.
Correct.
And then there may be times where you just want to make sure you were able to collect, absent the breaking of the swab, what you were intending to collect, so you may utilize another swab.
Correct.
And regardless, if anything breaks along the way, you're not just throwing it, you're packaging it with the rest of the evidence.
Correct.
Okay. Okay. And if you feel the need to have to refer to your report, as I know moving forward on this particular day, there were a lot of photographs taken as well as swabs collected. So just let us know if you need to do that for purposes of a record. After you completed your photography with the BMW, I believe you moved to the living room floor area to take some photos and collect some swabs in that sunken living room area. Do you
Yes.
recall that? I believe the defense is also stipulating to the admission of exhibits 306 to 303 to 314.
Any objection?
Oh, Your Honor.
It's ordered admitting 303 through 314 into evidence.
So I'm going to go ahead and put exhibit 306, and the jury's familiar with this photo. I think they've seen something like it before. Can you explain what your role was here as the photographer, kind of what you're asked to do?
Yes, I was asked to assist lab personnel with documenting where they were planning on needing swabs from. So this was an overview of the living room floor with areas marked of what swabs they were wanting documented and swabbed.
So if I'm understanding you correctly, some other crime scene person came in there, placed the cones, placed the little placards that we're seeing, and prepared the area for you then to go in and do the swabbing and then photography.
Yes, they were crime lab personnel.
And I know it's kind of hard to see. Essentially, are we looking at what later became documented as L5A, L5B, and then 789? I guess it's actually L5A, L5B, all the way through L18.
Yes.
Okay. What does that mean?
The L numbers were what the lab was using to indicate what they had marked for their own documentation purposes. And the different areas that needed swabbed and were documented.
So would you agree that 306 captures most of the area in its entirety?
Yes, it does.
And then as we move into exhibit 307, is that kind of zooming in on more specific areas that you were asked to swab?
Yes, it was.
And we're seeing in this photograph, and here's probably a better example, in exhibit, there's little white stickers. In this particular photo, it's below what's labeled L11. What do those markings denote?
Those are similar to what is in the footwear photographs that were in the alley. This is for lab personnel to know what sample it is, which way is up or north.
Hey, Joe, can you stop the stream? Hey, Joe, stop the stream.
Exhibit 309. And essentially, you then document from a distance and then a little bit more zoomed in.
There's no sound. Hey, Joe? Are you there? We have something going on in court and I can't hear it. Can y'all hear it?
I think there was one witness who used that term, butcher paper, as opposed to bench paper.
Hey, Joe, are you there?
And I don't think it was the witness that was associated with that. But this is just the old-fashioned terminology that people often use to describe that paper. I think I used it at the side of the bench one time, not in front of the jury, but just with you. But I think that is a more neutral character.
Oh, my son.
I'm here. What do we have going on in court?
Hold on.
2 minutes.
Okay, Joe, my son is going to go see why we don't have volume. He's going to my computer. There's something going on in court. I don't know if you can get this stream up on your end and then I'll pop it in. Because there's some questions going on. Uh-oh, it went away. You'll have to put it up again.
I'm coming back. Here we go. All right.
Okay, go ahead and begin when you get it. So it'll be on Court TV feed?
I had the court TV feed.
Or the Brian Walshe?
I did. Hold on. Hold on.
Oh, we're good. We're good. Yeah, guys, I don't know what happened to the sound on my feed, but my son's working on it. Okay, I'm going to put mine back up till you get yours.
Ian Mitcham and Brian Walshe trials. So they're just showing the Ian Mitcham stuff, not the Brian Walshe stuff.
You may have to back it up.
All right.
Because my feed shows that they're in the middle of a question sidebar.
Walshe trial. Okay, there's Court TV. Boom. All right. Go to StreamYard. There we go.
Okay, did you back it up?
Yeah.
Okay, I'll let you do all the embiggening and backing it up. And I hate now they put the comments up that you have to click off the comments every single time you
Right.
embiggen. Ooh, nice arrow string.
Yeah,
Them things are expensive.
very.
That is weird. There we go.
That particular photo that is.
Wonderful.
from
Thank you,
that-
Joe.
That description.
Just X out of those dang comments.
I mean,
I just don't like it, but.
I know you don't like it, but I'm trying to distinguish between, I think there was one witness who used that term butcher paper as opposed to bench paper. And I don't think it was the witness that was associated with that. This is just the old-fashioned terminology that people often use to describe that paper. I think I used it at the side of the bench one time, not in front of the jury, but just with you. But I think that is a more neutral characterization that would be appropriate and more in line with what the witnesses actually testified to. But as to those, the other language in 189, it seems to me that that's what the witness testified to, right?
You don't have a case?
I had one. I took it off for some reason. And then I
Let's all
lost
take
it.
a moment to
After
look
that, it
through
went
the
off.
list right now and see if there's anything. I'm going to do that right now. The
glad
answer to
it's
their
been on
question
this
is
and not
97,
this.
by the way. Let me just take the time to look through these, and you do the same.
That's, other than that, that's the only. Who's 189? Blood clots and.
I love it when the jury gets to ask questions, but I don't love it when their questions are muted.
I was going to say the same thing, Joe. I was like, yeah, I want to know what the question is. Why can't we hear it? But it's about numbering or something like that. I think that they may be close to a verdict. I hope. Who was it that asked me if they get a question about the document or the paperwork or forms? Do I think they'll come out with a quick verdict? And I think that if this is where we are, we may have a verdict today.
The jurors, and I will give them the name of or the number of the photo, which is I'll answer it as exhibit number 97. And
oh, they're asking about an exhibit
list to assist you.
Thank you, Your Honor.
So they're asking about an exhibit. That's even more interesting. So they may not be close to being done. At least we know they are going through the exhibits and not walking back and saying, everybody guilty, guilty. Okay, let's have lunch and then we're done.
No, I appreciate
they left a lot of
the jury very much. Yeah, I know. I appreciate when they like go through everything in detail. That's got to be so hard to do.
Yep.
But I would do it 100%. I would be like, you got to prove it to me beyond a reasonable doubt.
You know, on this case, I am at beyond a reasonable doubt, even without a body. I think that nails it for me is his searches, his Google searches, and some of the texts.
Well, the DNA evidence on the saw that was used to
That too.
dismember her, I think that like seals it for me. It's like,
And the fact that it was at Mama's apartment complex that it was found.
yeah. All right, so we're back to the clock now.
All right, you can go back to the other feed if you want to. Thank you so very much.
Which one was that? I don't even remember which one we were on.
Ian Mitcham.
Okay.
Tell me you know where you were. It should pop up
No.
where you were. It should pop up where you were.
Darn it.
Yeah, I
Everybody's
knew he abandoned us and everything popped.
Yeah. Yep.
I am so sleepy, y'all. I gotta be honest. It's so hard to stay awake right now. But I'm real close. We've got a 3 o'clock rehearsal to go through, a 6 o'clock graduate
It's not
celebration
really,
thing.
It's not really a rehearsal.
Well, it's
She
for
just-
us.
Well, she just wants to know where we're going to sit. She wants to
Yep.
put us someplace.
Come here, StreamYard. Come here, StreamYard. Come back to me. Come back to me. Where'd you go?
Well, you're obviously still on it. I can hear you.
Hold on.
I've got 4 monitors now, and I told Diane I need 1 more. I actually have it. I got to figure out how to mount it.
All right. All right. Is this it? Is this where we were?
I don't know. Let's see. Let me get it up there. I think so, yes. Go ahead and embiggen it and play. You're good to go. No, is that the beginning? I can't see the bar. It should be. Let's see. Yeah, it is. It's right where we left off.
All right. Good deal.
Thank you, hon.
Wait, what?
At the very end, he could have worded it.
Oh, were
on the
all of the light switches in every room of the house swapped?
Joe, that's my live. You got to put up.
Without asking about.
Go to channel 12.
All right.
Yeah, that's what we asked.
Hold on, everybody. Like, take a step back. Take a step back.
Channel 12. Ian, just
Good
Google Ian Mitcham,
Lord.
channel 12. Mitham. Mitcham.
Try sharing that.
There we go. Perfecto.
Take some photos and collect some swabs in that sunken living room area.
Yes.
I believe the defense is also stipulating to the admission of exhibits 306 to 303 to 314.
Any objection?
Oh, Your Honor.
It's ordered admitting 303 through 314 into evidence.
So I'm going to go ahead and put exhibit 306, and the jury's familiar with this photo. I think they've seen something like it before. Can you explain what your role was here as the photographer, kind of what you're asked to do?
Yes, I was asked to assist lab personnel with documenting where they were planning on needing swabs from. So this was an overview of the living room floor with areas marked of what swabs they were wanting documented and swabbed.
So if I'm understanding you correctly, some other crime scene person came in there, placed the cones, placed the little placards that we're seeing, and prepared the area for you then to go in and do the swabbing and then photography.
Yes, they were crime lab personnel.
And I know it's kind of hard to see. Essentially, are we looking at what later became documented as L5A, L5B, and then 7, 8, 9? I guess it's actually L5A, L5B, all the way through L18.
Yes.
Okay. What does that mean?
The L numbers were what the lab was using to indicate what they had marked for their own documentation purposes. And the different areas that needed swabbed and were documented.
So would you agree that 306 captures most of the area in its entirety?
Yes, it does.
And then as we move into Exhibit 307, is that kind of zooming in on more specific areas that you were asked to swab?
Yes, it was.
And we're seeing in this photograph, and here's probably a better example in exhibit, there's little white stickers. In this particular photo, it's below what's labeled L11. What do those markings denote?
Those are similar to what is in the footwear photographs that were in the alley. This is for lab personnel to know what sample it is, which way is up or north.
Hey, Joe, can you stop the stream? Hey, Joe, stop the stream.
Exhibit 309.
Boom. Done. There we go. Are you there? Hello? Hello? I stopped the stream on L16 and we're paused.
Hey, Joe, why am I hearing myself? You got me up again twice, Joe.
Do I really? There's no
Yes,
way.
you
No,
do.
No,
That's both. I see myself and you twice. And I heard myself say, Joe, stop the stream. Joe, go to youtube.com and Google Ian Mitcham, day 7. Channel 12, not 10.
All right, hold on.
June is back. So you want June to take over?
You said, yeah, let's do that. This would actually be a good time for a transition if I've got the wrong stream.
June, are you ready to? Yeah, it would be. Hey, June, are you ready to take over? We got to give her a second, though. She just said, I'm back.
Yeah.
I mean, so we got to give her a minute.
Yeah. Right.
So we'll give her a minute to hop in. Joe, you're going to come on my New Year's Eve live, right?
New Year's Eve. When is that? When does that occur?
December 31st, 2025.
What? That's crazy talk. December 31st is New Year's Eve.
You're going to come on my live? I'm doing a marathon.
Oh, I can't do marathons. 26 miles is a lot.
Well, no, I'm not going to do that kind of marathon. We're going to start when it is in Britain, New Year's in Britain, and we're going to go till it is New Year's in Hawaii. Whatever time frame that is. About an 18-hour day.
Where are you, Angela?
I see Miss June. She's in chat.
Angela Turtle Mom is too.
Yeah. Okay. So, June, when you get the feed up and ready, we'll let you take over.
I mean, you can just go ahead and take over. But I'm going to be having a very long New Year's Eve live, and I'm going to have my friends hop on. Try to play some fun games. Try to maybe do some trivia. You know, I put it out there. If I can get to 4,000 subs by December 31st, which is not going to happen, I was going to get a Highlander cow tattooed on my wrist. And also it was going to be designed by my people. You know, I was having a design contest, but that didn't work. I'd have to get 490 subs in a few days. I don't see it happening. So when does your next video come out, Joe?
Probably, okay, so what is today? Today's Thursday the 12th. Oh no, today's Friday the 12th. Holy shit. So Braden Brown's next hearing is Wednesday the 17th. So I have to get all 3 of my videos out before that. So it's got to go like Sunday, Monday, Tuesday.
I would say so.
Yep.
Are they done?
No. And part of the reason is because I found out that the OSBI, the Oklahoma State Bureau of Investigation, is watching my videos. So I have to be careful about what I release. Like I can't.
Why are they watching your videos?
Because I've done as much research into this case as they have. That's why they're watching.
Wow.
They want to know what the family knows. And they haven't done as much investigating as I have. And they don't have the communications that I have with the family. And so they're watching what I'm producing. But I have to be careful because I can't, the jury pool, I can't mess up the case. Like he's been charged with
I would tell the family in the best interest of justice for your daughter, I can't do any more until it's over. Once it's over, we can do all you want, but I'm not going to jeopardize your case. The case. Not going to do.
And I have 3 videos to put out, and I don't want to jeopardize the case. So we're still talking. I'm still talking with family, and
okay, guys, I don't want to.
Where did you go? Where did you go?
Joe, I appreciate you so very much. Thank you for having our backs. I'll let you in June finish, but face with y'all later. I got a charge.
All right.
And essentially, you then document from a distance and then a little bit more zoomed in.
Yay.
There's no sound.
It's really low volume.
Hey, Joe?
Yes, I'm here.
Are you there?
I'm here. Can you hear me?
We have something going on in court and I can't hear it. Can y'all hear it?
I think there was one witness who used that term, what's your paper, as opposed to bench.
Hey, Joe, are you there?
I'm here. Can you hear me?
This is just the old-fashioned.
Somebody tell me if you can hear me.
That paper, I think I used it at the second bench one time, not in front of the jury, but just with you. But I think that is a more neutral character.
My son.
Oh gosh, what happened? I'm here. What do we have going on in court?
We're supposed to.
Oh, good grief. That's what happens when you leave Joe Schmo in charge of things. Like, it all gets totally messed up. You just can't leave me in charge of stuff. Oh, my word. This is not working out. What's going on in court?
We're supposed to.
Come on. Come on, Angela. Come on, help me out here.
Oh,
Bail me out. Good grief. That's what happens when you leave. Grief. That's what happens when you leave. Grief. That's what happens when you leave.
Joe, this is June.
Hey, June, this is a mess. This is a
Okay.
hot mess. What happens when you leave?
Well, I can get you straightened out here in a moment. Joe, this is June.
Hey, June, this is a mess. This is a
Okay.
hot mess. What happens when you leave?
Well, I can get you straightened out here in a moment. Joe, this is June.
Hey, June, this is a mess. This is a hot mess. What happens when you leave?
Well, I can get you straightened out here in a moment. Joe, this is June. Okay. Joe, can you go? Don't put it on screen yet. No. Joe. How do you do?
Oh, let's try this again. Shall we try this again? What?
Joe, are you hearing me?
Yes, I hear you. Can you hear me?
Yes. Okay. Tell me on the Ian Mitchell stream what your timestamp is on the bar.
Um, 1:17:52.
17. Let me get into your spot. 11752.
Yes.
Oh, come on, get in there. Okay. I'm putting mine on pause at 11753, which is just a picture of them. Okay. Go ahead and try popping yours up now because we're not getting any echo. Now we're getting an echo. I don't know what's going on.
I'm hearing echo.
Okay, that has to be on yours end. Do you have it running twice somewhere?
No.
Okay, well, Ari doesn't hear an echo, so maybe it's just something hung up in the system. Okay, go ahead and pop it up on the stream, on the screen.
Let me find it first because I got to get back to it. I exited out of everything because it was so crazy. I was just like, I need to exit out of everything.
Okay, go ahead and exit out and come back in.
Feldman murder trial resumes 3 days ago, 1 day ago.
Here, let me send you the. Did you find the case?
3 weeks
Yeah,
ago.
and
I
that has
see
to
it
be
from
on
3
your.
weeks ago. What's his name? Ian Mitcham, right?
Here. Yeah, go to private chat, and I put the link in there.
Are we Ian Feldman? Are we Allison Feldman?
Okay.
Is that what we're on?
Okay. All right, okay, Joe, go to
Yes.
private chat. I put the link in there.
Okay. Hold on.
Good.
Private chat. There we go.
Yeah, I'm hearing you,
Oh,
Joe. Are you sure you don't have two StreamYard chat? I wonder if this has something to do with Ada being on. I don't know. Because I'm not showing anything down here at all. Okay, his name is Ian Mitchell, and the case.
yes. And the
case
Allison
has,
Feldman case. Yes.
right.
All right. I got it. I got your private chat. Here we go. Got to go to StreamYard. Why does this have to be so hard? Like, why does StreamYard have to be so difficult?
Because it's StreamYard and they can be.
Right. That's how they make their money, right?
Okay.
All right. Here we go. We're getting ready. And good grief.
Are you coming back from break yet?
Yeah, here we go. Present, share screen, Allison Feldman case, day 7, YouTube. We're back. We are back. As soon as I hit play. Hold on. I got to put that into a different window so I can press play. StreamYard, Arizona versus Ian Mitcham trial. Boom. But I don't think Ada K is sharing that. So Ada, you have to share this for me to be able to share it. Like, I don't have sharing rights.
Okay, so Ada. Okay, so
I have the video up. I have the.
Okay, hold on.
There we go. Okay, ready to go.
I had
Let's
the share.
rock and roll.
Okay, is this where we were at?
I
Okay,
think we're further than that. Let's go. I'm going to go like 3 hours down the road.
I think that feed is coming from Ada's,
Yeah,
so we'll just have to ignore it.
right.
Okay, hold it.
Hold up.
Pause.
All right. Okay, paused. Were we past this?
No, hold on.
Okay.
Please.
We're holding on. Everybody's holding on. Everybody hold on. Hold on loosely. That's a song by 38 Special. Hold on loosely. And we can't play it because we will get copyright stricken.
For what? Oh,
38 Special, hold on loosely.
Oh, okay. Come on. Don't be playing games with me.
Ready to go?
I had the show.
Rock and roll.
Okay, is this where we were at?
I think we're further than that. Let's go. I'm going to go like 3.
The verdict clock has stopped. And I don't know if it's for the end of the day. Joe, can you pull up? Is it
Yeah,
okay?
Let me go to Court TV.
Yeah, and go to the very end of today's on him.
Like 3 hours down the road.
Not testifying in this case. Now, a reminder, we had already prior to the
We're still
trial,
delivering what Court
go
TV
to
says.
the end. I don't know which.
misleading the police and also unlawful.
Okay, maybe they were showing something. I just happened to catch it. All right, we'll go back to the others. Leave this one up, and then go back to the other one. And if they come back, I will give you the time that their verdict watch clock has.
Okay, paused.
So go on back to the Ian Mitcham trial. You should be able to switch, right? Or do I need to re-add you?
I don't have control of it. I don't.
Okay,
Yeah,
hang
I
on.
don't have control of that. That's Ada K that has control of that, or you. That's a song by 38 Special.
Okay, and then now this is my first time doing this, Joe. So, all right,
We're all figuring it out. We'll all get it figured out.
okay. You got the switch back now.
Ready? Yep. Here we go. Yep. Here we go. All right. Press play. And if somebody in chat thinks that we went too far back, then we can fast forward.
Okay.
We can bloop further along.
Okay, go ahead and start.
Did I not start yet?
No, I'm staring at it. No.
I'm showing that we're 3 hours in and continuing through this.
Okay, hang on. Let me make sure that I'm okay. You're showing.
Oh gosh darn.
No, my StreamYard doesn't even show it. Let me reboot my StreamYard.
Right. I'm seeing that too. That's crazy. That's crazy, Doc. All right. There we go. All right. I had 2 of them open. Here we go. Now we're going.
Any objection? It's ordered admitting 459, 467, and 469 through 490 into evidence.
And I'm not going to show 459 at this point, but I'm just going to ask, so it doesn't seem like I'm skipping anything, Judge, if perhaps this witness can just let me know what 459 is. May I approach, Judge?
You may. You may, and you have continuing question.
Could you just take a look at that and let me know what you're looking at?
This is Allison Feldman's body.
at the home?
Yes, it is.
I'll take that one from you. Okay, so I'm going to move into 467. And just as a reminder, when you are present that first evening, some of the markers that we're using are those.
Okay, folks,
letter
that was my technical error. I forgot to mute one of my
and
screens,
some of these
so that was on
photos
me.
on Monday and perhaps today as well, I moved through a little bit faster. Is it fair to say, Ms. Davis, that can you remind me what's your role at this point in the investigation on that early evening into the morning hours?
So that first day, I was tasked with doing the documentation of the scene. So I'm there basically walking room to room, documenting what I see, how things are as saw them that night. We're not touching anything. We're not moving anything really. This picture does show that we at some point took a cutting, but like I said, the letters were lab based. So that's the lab personnel asking us to do stuff and document it.
And so what here in 467?
So this is a shot of the living room, and it is showing the couch, and then it is showing evidence marker R, which was a red stain on the couch, which has now been cut out of the couch.
So now I'm going to go to 469 at this point. What is that?
So this is after Allison has been placed in the body bag. This is called the medical examiner seal. They seal the body bag for chain of custody.
So this is just a photograph of what would be a seal with the medical examiner information?
Yes, it gives it, so we document the seal with the seal number.
Okay, that's 469. Now we're kind of moving to different area of the home, but do you recognize this picture, 470?
Yes, it is the security box, the screen. I believe it was like a little tablet.
And as we move through some of these additional photographs of this tablet, just to remind ourselves, this is the first night you're there is the evening of the 18th into the early morning hours of the 19th?
Correct.
And so this is some information that you are present for, although maybe someone else is taking the actual picture of this tablet?
Yes.
Okay. Was it your job to then kind of look at the information that was coming from this tablet and analyze it as it related to other facts potentially known at that point? Or were you more of the documentation and collection role?
I was at this point purely documentation.
Okay. So if I'm moving through these pictures, and I might ask you a little bit about what this information coming from this tablet is, but my question to you is, you weren't tasked with kind of compiling an understanding of what the information meant as it related to the investigation?
No, I was not.
Okay. That might be a better question for a different witness?
Yes.
Okay. That was 470, so I'm moving now to 471. So is this that same tablet?
Yes, it is.
And now, what are we looking at?
So on this tablet, when you look into the history, it is showing you all of the conditions of the doors throughout the house that have monitors on them.
And are you the best person to tell us which of these descriptions corresponds to which door?
I can't explain where they are,
Okay,
yes.
so help me understand.
So the master bathroom door is located in her master bathroom on the east wall, I believe. It's actually in the master bathroom.
Where does that lead to?
Goes to the backyard.
Okay.
The front door is the front door of the house, leads to the front yard. The garage door is, I believe, the door that is in the laundry room that leads out to the side yard and the garage. but there also was like an electric door on the garage too.
And what about, well, I'll go to the, what about front door? That might be obvious. You might have said that one already.
Yeah, the front door was in the front of the house that led to the front yard.
Okay.
Okay, Joe, please pause. The clock has stopped. We are on the clock.
Orient us a little bit, but as you're looking at this tablet, is this in, well, tell me about the
Hold on, I'm getting there. Hold on.
So these times
I'm
are
setting up the
showing
next one.
actually car entry and exits from those doors.
Okay.
Okay.
So
now
what are we looking at?
Okay, hang on a second. We're going to go to Court TV. Right now, I have it where the clock's on the screen and it says "Stop the clock, movement in courtroom," and that's what I'm going
Ruh-roh.
to do.
Hold on. Let's go. Let's go to Court TV. Stop the clock. Court TV.
Yeah, the big old clock.
Brian Walshe, day 10.
Hey, y'all. Hey, y'all.
Who's in the house?
Angela is here.
Angela.
Yeah,
I'm
but
so
Joe,
glad.
you ain't leaving, so you're still the co-host. Angela and I are here to support you in your endeavor to learn co-hosting. And by the way, Joe,
You're a riot.
well, Joe, yeah, because I actually asked Ada to ask you, so because both Angela and I will be gone or was gone, so now we're back. So you ready?
Yes, I got it pulled up. Hold on. Let me get over to StreamYard. So StreamYard is so funky. Like you go to present and then you go to stop. And all right, where were we at in that? I don't even know. Does anybody have any?
Just go to the very end. Just go to the very end. It says stop the clock, and it's a big old clock in the middle.
Share screen. Day 10. All right, I shared that. Stop the clock.
Okay.
So we're there.
Yeah. Okay. Let me pop you up so you can share it.
Hold on. Is that Ada's feed or is that Court TV's feed, Joe? Because I see chat.
That's Court TV speed right
Okay.
now.
Yeah.
We're good to go.
You ready? Boom.
All right.
Clean your screen up, Joe.
Boop. Like that. Does that work?
Make sure it's big.
It's as big as it gets.
Okay.
That's what she said.
Honey saying her verdict sentences are tingling. Could it be a verdict, or could it just be the end of the day? Since it's one here, 2, 3. It's 4:13 there. So I don't want to burst anybody's bubble, but let's see what's going on.
Yeah, the jury always has a dilemma, especially on a Thursday. Are we on a Thursday?
Joe, did you push start?
We're on a Friday. I did. Yeah.
Okay. Well, you're frozen again. Do whatever you did the last time because.
Okay, there we go. Playback speed. Let's go to 2.5. Oh, it did get paused, but now we're at 2.5 speed. It says 410 and we're at 414. So we're going to go at 2.5 speed to 414. But the jury always has a decision to make on a Friday afternoon. Like, do we want to come back on Monday or do we want to come back with a verdict today?
Okay, Joe. Okay, yes. Never mind. My camera just started to move. So hang on.
Oh, there we go. Holy
Holy
cow.
As is my custom at 4 o'clock, I
Playback
send a note on every day
speed.
deliberating,
Let's go
asking if they want
back
to stay until 4:30.
to.
That note will be
Oh,
marked
yeah,
as
yeah, yeah.
identification.
Slow them down.
And it gives them the option
Yeah.
of staying until 4:30 or suspending and coming back on Monday in this instance, and they've elected to do the
I'm
latter
going to back up just a little bit.
Okay.
I backed up too
on
far.
every day the jury's deliberating.
All right, here we go. We're going to hear everything that the judge has to say about this because it's all
Okay.
relevant. Come on, Judge. Come in here. Come on. Hello, Judge.
Oh, just give it a second. She'll come in.
All right. Everybody be patient. She's going to come in here in a second and she's going to talk about the jury's options about whether or not they want to stay and deliberate the rest of the day or they want to go home for the weekend and come back on Monday. And that was actually a relevant discussion, I think, in Lori Vallow Daybell's June trial for conspiracy for first-degree murder of Brandon Boudreaux, because they only sat in the jury room for like 20 minutes at about this time. And then they came back and the next day in like 15 minutes had a verdict.
Back on the record in Commonwealth versus Walshe.
Thank you. As is my custom at 4 o'clock, I send in a note on every day the jury's deliberating, asking if they want to stay until 4:30. That note will be marked as the next exhibit for identification. And it gives them the option of staying until 4:30 or suspending and coming back on Monday in this instance, and they've elected to do the latter. So we'll bring them in, send them on their way.
Wait, she said they're going to do, wait. She said they're going to do the latter.
Yeah,
No,
so that
we're gonna
means
back
they'll be
up.
back on Monday, I think, is what I think that I gathered from that.
I'm going to back up just a couple seconds to hear that again.
Okay.
We're going to hear that one more time.
She
They
did say
elected
the
to do the latter. I thought the latter was they're going to stay until 4:30 and see if they can hash it out. But I could be wrong.
no, they're going to go home and come back on Monday.
I think
Okay.
so too.
All right. We're going to hear it again. Come on, Mr. Clock. Speed up a little bit.
Who's the wild card?
Here we go.
Your Honor, we're back on the record in Commonwealth versus Walshe.
Thank you. As is my custom at 4 o'clock, I send in a note on every day the jury's deliberating, asking if they want to stay until 4:30. That note will be marked as the next exhibit for identification. And it gives them the option of staying until 4:30 or suspending and coming back on Monday in this instance, and they've elected to do the latter.
Oh, okay. So staying till 4:30 to hash it out was option one, and she said they elected to do the latter, which is coming back Monday. Okay.
Yes.
I got it now. I got it. Sometimes I'm a little slow on the uptake, but I like to pay attention to the details, and that's a detail that's very important in this.
So we'll bring them in, send them on their way.
R for ID, so marked.
That's interesting though, because all of us keyboard jurors have already come to the conclusion that this guy is guilty. And the jury is like, yeah, we're going to come back on Monday. So that's really interesting because we've already come to our conclusions and they have not come to a conclusion yet. Is he vaping? Oh no, he had his finger on his lips. I thought he was vaping in court. I'm like, dude, not cool.
All rise in the court. Jurors entering.
I'm gonna go see Mom, but otherwise I would maybe on Monday if we're.
Back in session, you may be seated.
Welcome back, jurors, to the courtroom. And thank you for your work today. And I'm going to send you on your way for the weekend. I remind you, jurors, that the rules still apply. They will apply until you reach your unanimous verdict. I'll remind you of those rules now, jurors. Don't speak to anyone about this case. Don't do any research about this case. Continue to have open minds as you evaluate the case and as you wait to see if you are going to evaluate the case. Don't access any social media or any news media over the weekend. Hope you have a good weekend. Get some rest, and we'll see you back here ready to work on Monday morning. Thank you, jurors.
Thank you.
All right, to the court, please. Jurors, follow me.
Joe, please go to private chat.
Okay. I'm going to have to end this court TV stream also because they start to do things like advertise and talk stuff. So as soon as we get out of that, then I'll head over to private chat.
Just as sure as council, make sure you're back here a few minutes before 9 o'clock in the morning on Monday. Have a nice weekend.
Thank you.
Where do we go with that?
Joe, okay, when you do that, Joe, put the EM trial back up for me so we can pop that back up.
Okay, hold on. I don't know. I have so many windows open right now. I have so many windows open right now.
Okay, it'll be the last one, but okay, folks. So Monday morning, a little bit before, so we'll be back at 6 o'clock my time, which would be 8 o'clock Ada's time. I'm used to thinking Pacific Coast time, and she's used to thinking Central time. Thank you for your patience today. We are getting things together. And just as a reminder, on New Year's Eve, Ada is going to be doing a New Year's Day or New Year's Eve live stream, which will be opening up, the phone lines. She's going to have us on with her, and we're also going to have probably other guests. So please come in and spend a little bit of your New Year's Eve with us and let us know how you're doing and what you're doing. And we'll have some fun time talking law and cases and whatever happens. I know we're doing a 2025 year in review. Don't know too much. Okay. East Coast time would be 9 a.m. your time.
Yes, 9 o'clock. That's what time zone I'm on, Ari. I'm on your time zone too.
Okay. So I have
Thanks everybody for your patience. We had some technical issues, but I think we kind of worked through them for the most part. And next time will be much better. All right. Everybody good?
I
Yeah.
am good. I do have to say I'm a little shocked that they decided to come back on Monday.
Yeah, they kind of did that in Lori Vallow-Daybell's trial, in her first trial, which was for conspiracy to red drum her husband Charles Vallow. We were a little bit surprised that they did that, but then in the second one, they deliberated for 15 minutes after they came in the next day. So it was really quick, and I kind of feel like that's the direction they're going with this, but you never know. You never know what questions jurors have. You never know what evidence they want to see again, what questions they have for the court. But we'll be here to monitor all of that.
And remember that when they had that snafu with the evidence numbering, remember they had some problems with numbering earlier in the trial, and I guess they didn't fix some photos and their numbers were off a little. And I think because of that question that they had, that could have possibly also caused part of the delay of them coming to, a verdict today.
Yeah, that's a good point because that happened in Lori Daybell's Idaho trial where the prosecution didn't provide disclosure of evidence as they should properly. And so her life sentence or death penalty was taken off the table because of the prosecution's mishandling of some evidence and disclosure. So that's a very good possibility in this case too, that maybe they mishandled, maybe they misnumbered some stuff, and the defense didn't have everything they needed. You never know. All right. Are we ready to wrap this up, folks?
Angela, do we want to stay on and work some more on the Ian Mitchell trial?
I'm good if you are good. I mean, I don't think we have, I did try to keep up with it as best I could, on where we are, I think, ish. We can run through it. I don't know that we may only have about an hour left. If you want to, we can, or we can end the day.
What's going on with this screen? Yeah. Joe, how much longer do we have left on this stream?
Oh, good Lord. You're asking me a really tough question. I think about an hour-ish sounds about right. Of the Ian Mitchell testimony.
Okay. What timestamp do you have right now?
I think I closed that window out.
So where I remember listening on my way back home, I have us at about 4 hours, 15 minutes, and the whole stream itself is 5 and some odd hours, with breaks, of
5:44.
course.
So about an hour and a half left.
Yeah, that's what we have roughly.
Okay,
Yep.
why don't we go ahead and try to get this one out? So, because it looked like they did not have court today, and then we can start on Monday, and we would be caught up with the actual trial.
That sounds good to me.
Okay. Do you want me to start broadcasting it, or do you want to broadcast it?
Well, do you want to stick around for about an hour? Are you interested in the trial and want to stick around?
Yeah, absolutely. I can.
Okay, we'll pop it up from yours because you have the extra soundboard roadcaster stuff.
All right. You tell me what timestamp I should start at.
I got 4 hours, 14 minutes, Joe, because we
Okay.
were already on the next witness.
All right. We're observing evidence there. All right, here we go.
Okay.
Let me share screen. Allison Feldman. Here we go.
Okay.
That. All right. All you have to do is share that, and we're good to go.
We're zoomed in photo in 409.
Perfect. Thank you, Joe.
Can you explain what the purpose is of the different
Joe, please remember to go to private chat. Thank you, Joe.
The purpose of the far away, medium, and close-up is just to give us an idea of where we are and what we're looking at. So we have orientation of everything, but also different lighting of impression to get better detail.
And the AA and the AB placards, are you able to tell from this particular photo what they're denoting?
Those are just marking that there were two separate areas that we were documenting for shoe impressions.
I'm now going to show you Exhibit 410. Is that a different part of that same alley?
Yes, it is.
And can you explain what we're looking at in this photo in terms of direction?
In terms of direction, we're looking further down in the alleyway and just along the edge of the back wall to the residence.
So there appear to be in the middle of the photo 410 two additional placards. Those other impressions that were noted that you were asked to photograph?
Yes.
Or I guess I should say possible impressions. In Exhibit 411, are those close up, or I should say more zoomed in photographs of those two placards?
Yes, they are.
Now, in looking at Exhibit 409, the AA and the AB, I think to probably everybody in this room except we may not see anything. So I'm going to now put up Exhibit 412, and I'm going to ask you about this. First of all, can you, that might have made it worse. Can you see that little white piece of paper in the upper corner of the photograph?
Yes, Anne.
What is that?
That is a marker that we use on in our photographs, I should say. And that is so we know what the item is, the case number, what the placard number is, and the directionality. We can show which way is north or up.
Okay, and if you can see on that little white piece of paper, I asked you about placards AA and then A and B. Do you see what is representing in this particular photo?
Yes, that is PMAA.
Okay. And you have that ruler around a particular area, and it looks like from this photo, you can kind of see something in the center. Is that what you are capturing?
Yes, it was.
I'm now going to put photo 413 up there. What is the difference between 412 and 413?
The difference is the item number. This is showing PMAB.
So that is the second impression that you were asked to document in that area by that, what is that thing called? It was like a
utility cover?
Yes.
Yes, it was. This was the
Okay.
second one.
Now I put up again in Exhibit 411, A, C, and AD. After you placed the placards, did you then employ the same procedure by bringing out the ruler and doing a different type of capture of those possible impressions?
Yes, I did.
I'm going to show you Exhibit 414. Which one of the impressions are we looking at in this photo?
This is PMAC.
And then in 415, it looks like the AD is also captured in this, but is this the same type of capture of the impression?
Yes, it is.
Now, after you completed your work in the alley, did that essentially complete your work in the alley?
Yes, it did.
You weren't asked to photograph anything but those two areas that we just saw?
Correct.
After the work in the alley, were you then asked to photograph a vehicle that was parked in the driveway 8526 East Monterey Way?
Yes, I was.
What type of vehicle was that?
I would have to refer to the notes.
Sure. I believe your report is up there. If that will help refresh your recollection. Okay. May I just try to assist the witness? For
You may.
ease of time here?
Do we know what page or not? What was it? Do we know the bottom? 507. Hmm. Maybe. Okay. Yeah, that is. Thank you.
And remind me the exhibit number that this is.
Can you look on the cover?
30.
Oh,
30.
Exhibit 30, and I believe she's referencing between 524 and 530.
it's 30. Yes.
Thank you.
Okay. And to answer the question, based on my report, I was photographing a 2009 BMW 335i that was a door vehicle.
Okay. Now, I'm going to put up, I believe the defense is also willing to stipulate to exhibit 300, 301, and 302.
And is that correct?
That is correct.
It's ordered admitting exhibit 300 through 302 into evidence.
I put up what's been admitted as exhibit 300, and we're seeing this photo again. If you look at the time, does that denote that this would have been kind of your second task on February 20th, 2015?
Yes, it does.
So this looks to be about 2:35 p.m.
Correct.
when you began these photos? Exhibit 301, do you recognize that?
Yes, I do.
And what do you recognize that to be?
That was the vehicle in the drive of the residence that I photographed.
I want to ask you, when you photographed the vehicle, did you photograph both the interior and the exterior?
Yes, I did.
And we saw in that photo that the vehicle was still confined within the crime scene tape. Was that how it appeared when you were asked to photograph?
Yes, it was.
Did you have to get into the car to actually photograph the exterior or the interior, or were you able to do that without disturbing anything in the car?
I was able to do it without getting in or disturbing the vehicle.
On this particular day, were you asked to do anything other than simply photograph the car?
No, I was not.
There's a few things in your report that I believe you mentioned seeing a car. And I just want to cover a couple of those things with you. I'm showing exhibit 302. Do you recall that?
Yes, I do.
And what do you remember that to be?
Referring back to my report, that there was dry cleaning on the rear seat and water bottles in a what appeared to be a tan sweater.
And then I'm going to show you what's already been admitted into evidence as exhibit 62. Did you also notice that and photograph that?
Yes, I did.
And what is depicted in that photo?
It is a drink container from Paradise Bakery that has contents in the bottom of it.
And again, you weren't asked to collect anything from the vehicle, is that fair?
Correct, just document.
So you do the work in the alley, Then you were asked to take photos of the car. And then finally, on the same day, were you then asked to take additional photos and then collect additional swabs from within the house?
Yes, I was.
Now we heard, as I mentioned earlier, from CSS Bree Davis, and she mentioned, she told us about the swabbing process and the use of, she referred to them as Integra swabs. Do you typically, as you utilize swabs, refer to them at whatever time frame you're using them by the name of the brand?
Yes, as the brand changes, you may change the way that you identify the swab, but they are all the same.
So if you've referred to them or someone's referred to them as Integra swabs or Capture swabs, we're talking about essentially the same type of swab. It just might be a different brand name at the time that you're using.
Yes.
Did they typically all appear the same way?
Yes, they did.
We heard about the swabbing process, so I don't want to go through that whole process with you. The only thing that I want to ask you is, as a crime scene specialist group, do you try to remain consistent in the way that you swab items, surfaces, stains?
Yes, and that is part of the 16-week on the job training, that everybody does things in the same fashion, so the work is consistent across the board.
Okay. Stretch break. Stretch break. Another expert witness. She's talking about the swabs that they take and that the fact that they have different brand names of swabs that vary from crime scene to crime scene, but the fact that they're all the same in the manner of collection of swabs that they take. So this is actually really good testimony, and I appreciate the fact that the prosecutor is going down this route. I think the jury probably appreciates this too, because you can have multiple brands of swabs that you take, DNA swabs, and they can all lead to the same result, which is a connection between the defendant and the crime scene. I think that's what we're looking at here. Just a quick stretch break, a quick mental stretch break, and we'll get back to it.
Now, when we heard from CSS Davis earlier, she mentioned, I think it came out on cross-examination or maybe even direct examination as well, that sometimes, despite your best efforts, when you're utilizing swabs, the sticks will break.
Correct.
What didn't get asked, and I would like to know the answer and have the jury know the answer as well, is when that type of situation happens where you're swabbing something and the stick breaks, what do you guys do?
If a stick breaks, it breaks. The swab off the top of the swab is closed in a secured area. So we just put the other half of the stick separate from it, and you send that all to the lab. But if it breaks, it doesn't affect the swab or what you have swabbed it on. If you start swabbing and it breaks pretty soon, you impound that swab as well as the second one to make sure you got the entire surface you needed.
So sometimes if a stick breaks, you may not need to do another swab. You're just fine utilizing what you had done with the first swab.
Correct.
And then there may be times where you just want to make sure you were able to collect, absent the breaking of the swab, what you were intending to collect, so you may utilize another swab.
Correct.
And regardless, if anything breaks along the way, you're not just throwing it, you're packaging it with the rest of the evidence.
Correct.
Okay. Okay. And if you feel the need to have to refer to your report, as I know moving forward on this particular day, there were a lot of photographs taken as well as swabs collected. So just let us know if you need to do that for purposes of a record. After you completed your photography with the BMW, I believe you moved to the living room floor area to take some photos and collect some swabs in that sunken living room area. Do you recall
Yes.
that? I believe the defense is also stipulating to the admission of exhibits 306 to 303 to 314.
Any objection?
Oh, Your Honor.
It's ordered admitting 303 through 314 into evidence.
So I'm going to go ahead and put exhibit 306, and the jury's familiar with this photo. I think they've seen something like it before. Can you explain what your role was here as the photographer, kind of what you're asked to do?
Yes, I was asked to assist lab personnel with documenting where they were planning on needing swabs from. So this was an overview of the living room floor with areas marked of what swabs they were wanting documented and swabbed.
So if I'm understanding you correctly, some other crime scene person came in there, placed the cones, placed the little placards that we're seeing, and prepared the area for you then to go in and do the swabbing and then photography.
Yes, they were crime lab personnel.
And I know it's kind of hard to see. Essentially, are we looking at what later became documented as L5A, L5B, and then 7, 8, 9? I guess it's actually L5A, L5B, all the way through L18.
Yes.
Okay. What does that mean?
The L numbers were what the lab was using to indicate what they had marked for their own documentation purposes. And the different areas that needed swabbed and were documented.
So would you agree that 306 captures most of the area in its entirety?
Yes, it does.
And then as we move into exhibit 307, is that kind of zooming in on more specific areas that you were asked to swab?
Yes, it was.
And we're seeing in this photograph, and here's probably a better example in exhibit, there's little white stickers. In this particular photo, it's below what's labeled L11. What do those markings denote?
Those are similar to what is in the footwear photographs that were in the alley. This is for lab personnel to know what sample it is, which way is up or north, and to indicate what case it is from.
And so this is kind of another example. It's exhibit 309. And essentially, do you then document from a distance and then a little bit more zoomed in the specific areas that you are swabbing and photographing?
Yes, everything is given an overall mid and
and you're not responsible for anything beyond this particular day, taking pictures and collecting the swabs.
Correct.
Any comparison or testing, is that done by other folks at the lab?
Yes, that's all lab personnel.
Okay, so I'm going to show you just exhibit 310. Is that another marking of L15?
Yes, it is.
Same type of situation in exhibit 311 for L12.
Yes.
And then again, we're seeing L13 in exhibit 312.
Correct.
Exhibit 313, I think, is showing L10.
Correct.
And exhibit 314 showing L14.
Correct.
I want to show you photos that look a little bit different than a few of the photos that we've looked at. I'm going to start with what's been admitted as Exhibit 303. I'm going to have you tell us what we're looking at and why does this photo look different than some of the other photos?
The reason it looks different is the lab used, they would have to explain this, a chemical that needed a certain type of lighting to be photographed. So I was asked to take these photographs for them, which is why it's a different color.
So when we're looking at photographs that might have a different lighting, and is that so the lab and you guys and I guess people like us later on are able to better see what you are swabbing and or trying to capture?
Yes, even just for lab and us personnel, just to be able to view what it is, it had to have certain lighting.
Without being trained, is it fair to say that most of us, if we walked into that scene, would have a difficult time seeing what you all are seeing?
Yes.
I'm going to show you another photo. It's Exhibit 304. Same type of request by the lab.
Yes, it was.
And then Exhibit 305.
Same type of photo.
Okay. And we do have people who assisted in the next steps of this that I think would be, are those the better people to explain kind of what we're looking at?
Yes, they can tell you the chemicals and what light goes with what photography, so it makes a little more sense.
Okay. Now, we heard from crime scene specialist Palma about her involvement in the case, which was taking overall photos prior to anything being done at the scene, and then coming back and taking some additional photos when there were placards put up. We've heard that the processing of this scene, is it fair to say, kind of went on a rolling basis?
Correct.
So not one person can stay there until everything is done. You guys have shifts, you require sleep, and so you kind of have to follow each other. Is that fair?
Correct.
So we mentioned that you were brought in to take some additional photographs. And let me ask you this. When you came in and documented things at various placards, were you also taking swabs of these items or just taking photos?
On which day?
On February 20th, when you're taking photos of the different areas of the house. And let me put some photos up and I'll give you an example.
That's right. She has to take a break, don't forget.
Yes. I don't know when you would like to take the break.
We can do it right now if you want to. Is this a good stopping time?
It's up to you.
So we do have to build in one more break this afternoon. Let's go ahead and take that break right now. Please remember the admonition. We'll call you back close to, let's say, around 3:25 or 3:30. Thank you.
All right, there we go. We have a break. Woo! Can we bloop, bloop, bloop? Let's find that video. Let's bloop, bloop, bloop.
The music.
Oh. All right, we're going to play back the 1.25.
Letter placard. Do you know the documentation than you do letters via numbers? Exhibit 322, again, I believe these placards end with 51.
Yes.
Exhibit 323, is this just a different perspective?
Just a different angle, yes.
Question for you. Can
We
you
figured
look
it out.
at, I'm gonna flip this photo, Exhibit 323. Do you see what's listed as placard 50?
Yes, I do.
Now, we've seen a picture of this staining previously, and it was previously marked with a letter placard. Do you know the distinction between the letter placards and the number placards?
Was it L?
H.
It was H. And I would have to look at the notes to see what they indicated, what they were marked as.
Okay. Are you aware that the crime lab had come in and done some swabbing and photography a few days prior?
Yes, and we don't see those reports, so that would be different from what we were doing.
Do they use a different documentation than you do, letters via numbers?
Yes, and they do different reports and different programs as well.
So if you were doing some documenting of the same type of stain, if you were doing it for your own separate purpose, with that same stain, could it possibly then have a different placard assigned to it to denote the difference between what the lab is doing versus what crime scene specialists are doing?
Correct.
Would that make sense why then what I think we all have learned is PMH in this case is now documented with placard 50?
Correct.
Okay. Moving on, I'm 324, again, more staining with placards.
Yes.
325, a close-up of additional staining.
Yes.
Again with Exhibit 326.
Yes.
We're moving to Exhibit 327. Is this you telling the readers that we're moving to a different area of the home?
Correct.
In Exhibit 328, is this still placards that are signifying additional staining in the home?
Yes, they are.
329, a more zoomed in photograph.
Correct.
Same thing. Exhibit 330, moving into the hallway.
Yes.
331, further staining in that same hallway.
Can I refer to my?
Yes.
Yes, that's indicating in the laundry area.
In the hallway area?
In the hallway, sorry,
Okay,
hallway
I
area.
just want to make sure we're talking about the same thing.
Yes,
And I'm going to
yes.
put 332 down. I think that'll be a better idea of, since you'll see placard 57 in there as well.
Yes, yes, the hallway.
Okay. And then Exhibit 333, still same hallway?
Hallway, yes.
How about Exhibit 334, still in that same hallway?
Correct.
So these placards were documenting additional staining that had been observed over the duration of when you folks were in there processing the scene. I now want to move to the next series of placards. And I think you're making your way at this point, given by Exhibit 35, into the guest bathroom.
Correct.
Okay. And when you went into the bathrooms and a few other rooms that are going to be documented with the pictures that we're going to see momentarily, are you then documenting items with photographs that is your understanding, or items that are going to be collected by crime scene folks and detectives after the documentation part is
correct?
Okay. So moving into this bathroom, we Exhibit 336. I don't think we can see the placard there, but are you able to see that there are various cabinets and drawers that are documented with
Stickers? Yes.
Okay. Exhibit 337 with placard 59.
Correct.
Was it your understanding that there was going to be plumbing and sink traps and things of that nature collected case?
Yes, it was.
Is that what your photo is reflecting in terms of in this picture?
Yes, it is.
Okay. 338, Exhibit 338 is telling us we're now in the master bathroom. Is 339 reflective of that bathroom?
Yes, it is.
And we see placard 61, I believe.
Yes.
Okay. And again, is that marking the plumbing?
Yes.
We're seeing placard 60. Are you able to tell what that is?
I would have to check if that was that plumbing on the other sink.
Are you able to check that for us?
I believe that would be in who collected the report,
Okay.
what documented that.
All right, that's fine. We can come back to that at some point with some other person. Exhibit 341, is that just showing a side bite of the two cabinets?
Correct.
Okay, we're moving into the kitchen now, exhibit 342. Again, as we move through some of these photos, starting with 343, are these placards representative of the photos of the various sink traps that at some point were collected?
Correct.
344 appears to be a zoomed in version of that same area.
Yes.
And it looks like in 345, there's placard 62. You're now telling us with your placards that you're moving into room 347. Let me ask you a question. In some photos, we're seeing a glove, in some photos, we're not seeing a glove. Can you explain that?
Yes. When I'm holding a placard, if a glove is in some photos, that may indicate something needed to be opened or altered. So we had the protective equipment on to do so.
Which I think is going to lead me into exhibit 348. Is that a closed cabinet door?
Yes, it is.
I'm going to show you now exhibit 349. Is that opened?
Yes, it is.
Since you are now having to open it to document what's inside, would that explain why you would have a glove on?
Yes, it does.
And inside that we see placard 63 and 65.
And 64, yes.
And 64, which is kind of in the corner.
Yes.
I think I'm going to show you a better view of that in exhibit 350.
Yes.
Okay. You're now telling us that we're moving into the living room in exhibit 51.
Correct.
I believe later, I'm going to put up exhibit 352. There were a few additional markings that had been put down, L17 and L18. Is that you coming back to get photos of those two placards?
Yes, it was.
Okay. And then in terms of exhibit 53, is this just another example of lab asking you to document something in a different light source?
Correct.
Okay, exhibit 354, you're now telling us we're outside in the pool area. Is that fair?
Correct.
355, you see placard 66
Yes.
from a distance. So does that acquaint us to what side of the pool we're looking at?
Yes, it does.
And then 356, a more zoomed in photo of placard 66?
Correct.
Are you able to tell, I know what's coming, but can you tell from this photograph what that placard is representing?
The placard is representing something in the water.
Okay. And 357, exhibit 357, are you able to better see that sort of in the center of the photograph?
Yes, I am.
Moving into exhibit 358, was that then retrieved from the pool?
Correct.
And photographed? Who lays down that piece of paper?
I do not recall.
Okay, you're just simply taking the photo.
Correct.
And then exhibit 359, is that a more close-up photo?
Yes, it is.
And what did that appear to be to you when you were taking a photograph of that?
A clump of hair.
Okay, next batch. And I'm going to move through these quickly. These are admitted exhibits, so the jury will get to look at them more closely. So I'm just trying to give them an idea of what you've done. So we heard testimony again from CSS Bree Davis earlier that when she was in the home, she swabbed a bunch of light switches.
Correct.
Were you then asked to come in and then take photographs of all those light switches that she had swabbed?
Yes, I was.
Okay. And was that in various rooms of the house?
Yes, they were.
Okay. So we are going to move through these pretty quickly as well. Is this you telling us in terms of light switch activity that we're going to be looking at things in the laundry room?
Yes.
Okay. And that's Exhibit 360, Exhibit 361. Is that a far, like kind of a zoomed out photograph of light switches that are on that back wall?
Yes.
Exhibit 362, is that a close-up of those laundry room light switches that Miss Davis had testified she'd swabbed?
Yes.
Moving into the kitchen, Exhibit 363, are we then going to now look at light switches that were swabbed by her and then photographed by you in the kitchen?
Yes.
364, do you see that light switch that is kind of by the cabinets?
Yes, I do.
Okay. And Exhibit 365, is that light switch?
Yes, it is.
Let me ask you this. We see things LS-1. Is it a safe guess that that is light switch?
Yes, it is.
Would the one be what that's representing in terms of the total amount of light switches in that particular room?
Yes.
So let's say 45 light switches are done. They're not going to be 1 through 45. They're going to be 1 through whatever it is in that particular room.
That would be something CSS Davis would have to answer since they labeled them.
Okay. Exhibit 366, also in the kitchen.
Yes.
And it appears that underneath that cabinet, kind of in the center, there's light switches there.
Yes.
Is that then a close-up of those in Exhibit 367?
Yes, it is.
Exhibit 368, another set of light switches in the kitchen.
Yes.
And then Exhibit 369, is that a close-up of those particular light switches?
Yes, it is.
In Exhibit 370, you're telling us we're moving to the dining room light switches.
Correct.
Exhibit 371, in the somewhat center of the page, is that what we're looking at from a distance?
Yes, it is.
Exhibit 372, is that a close-up of that?
Yes, it is.
I'm going to ask you, I know you mentioned CSS Davis would be the better person to answer the question. Does it appear, though, as we're in the rooms, they're starting over at 1?
Yes, it does.
Okay, so does it appear that the numbers are based on the cumulative amount of light switches in that particular room?
In that section, yes, it does.
Okay. So Exhibit 373, another light switch that was
Correct.
swabbed in the dining room. Exhibit 374, a close-up.
Yes.
In Exhibit 375, you're telling us we're moving into that. Is when you say foyer, what are you referring to in the house?
In the front entry of the home.
Okay. And Exhibit 376
Yes.
is showing that light switch to the left of the front door?
Correct.
377,
Yes.
same light switches?
Same light switches.
There is something missing.
Yes.
Okay. Were you aware, even if you weren't involved, that at some point light switches were removed?
I was not aware of that.
Okay. For another witness. Exhibit 378, is that telling us that you're moving into the north-south hall?
Yes, it is.
And then in Exhibit 379, are we looking at the light switches in this particular hallway?
Yes, we are.
380, is that a close-up of that switch?
Yes, it is.
Moving into the east-west hall, Exhibit 381.
Yes.
Exhibit 382, is that the light switch to the left of that door?
Yes, it is.
And then in 383, is that a close-up of that light switch?
Yes, it is.
Exhibit 384, we have the west bedroom.
Correct.
And then Exhibit 385, is there a light switch to the left of that dresser?
Yes, there is.
And in Exhibit 386, is that a close-up of that light switch?
Yes, it is.
Exhibit 387 is denoting we're moving into the office.
Correct.
Is Exhibit 388, looks like a light switch to the right of the door frame?
Yes, it is.
389, is that a close-up of said switch?
Yes, it is.
Exhibit 390, are we now moving into the north bedroom?
Yes, we are.
And is Exhibit 391, is there a light switch to the right of that door frame?
Yes, there are.
Does 392 represent a close-up of that same light switch?
Yes, it does.
Okay. 393, the guest bathroom.
Correct.
Exhibit 394.
Yes.
Appears the light switch is to the left of that door frame.
Correct.
And then Exhibit 395, is that just a zoomed in version of that light switch?
Yes, it is.
There also appears to be a light switch shown in 396. Is that in that, and that's in that same bathroom?
Yes, it is.
Okay. And in 397, is this a close-up version of that light switch?
Yes, it is.
Okay. And then moving into the master bedroom as reflected in Exhibit 398. In Exhibit 399, are we looking at a light switch that appears to be to the left of, looks like the closet?
Correct.
And 400, is that a close-up of that light switch?
Yes, it is.
Moving into our final room, Exhibit 401, the master bathroom. Exhibit 402, is that a light switch that appears to be to the left of another door frame?
Yes, it is.
And is 403 a zoomed in version of that light switch?
Yes, it is.
And then Exhibit 404, looks like faintly you can see a light switch to the right of the toilet.
Yes.
And then in Exhibit 405, is that zoomed in?
Yes, it is.
Okay. So as Bree McKenna is swabbing away, you are snapping away,
Yes.
documenting everything that she is taking samples from.
Correct.
Now, you mentioned that you swabbed, you mentioned that you took photographs. I want to ask you, in your job, what steps are being taken by you as crime scene specialists to avoid contamination between the various things that you are collecting and swabbing?
We change gloves between any item that we touch. So for one item, you put on a fresh pair of gloves, you handle that item, package it. If you are going to touch a separate item, you have to get a new pair of gloves before you do so.
So one of the things that we heard from CSS Davis is that if you're taking swabs and you're just touching the stick and you're not touching the area that's collecting the evidence, that you would not have to change gloves in between taking a different swab. Is that part of your policy?
Policy changes. What policy was at the time? We would have to check.
Okay. Is that how you did things back in 2000?
Okay, we got to talk about this glove changing thing for just a minute because it drives me nuts. Because you see expert witnesses for the prosecution that get up in the stand and they get a package, whether it's in a brown bag or it's in a box or whatever it is, and then they wear these vinyl gloves to open it. No, dude. Do you know how many germs and DNA and contamination things are on the outside of that package that you're opening up in court? Like, and even then, the DNA determination has already been made. Like, why are you wearing rubber gloves to open up this package in court? That's evidence. So she says a really relevant thing right here, that It depends on what the policy is, but it's just like, so I have a Serve Safe manager's certification. And when you handle things that have the possibility for cross-contamination, like raw poultry, raw beef, raw pork, raw seafood, even raw vegetables like potatoes can have the possibility of cross-contamination. So when you wear gloves to handle those things, you discard your gloves every single time, and they don't do that in court. And I like the fact that she's pointing out that you should discard them every single time. That's good policy, but that doesn't happen every single time in court. So I'm going to keep going with this, but just know that that's like a trigger point for me. Like the whole gloves thing, you just wearing gloves does not protect you from cross-contamination, does not protect the evidence from cross-contamination. You have to handle the changing of gloves appropriately. You have to discard them every time you touch something that could cross-contaminate something else. Here we go.
2015? Do you remember?
I don't recall.
Okay. When you're talking about touching other items of evidence, let's say, for example, I'm at the house and I'm a CSS and I am collecting this tissue box. I have a pair of gloves on. I put it in a bag. I seal it. I then want to come over to another part of the house and I'm going to collect this box over here sitting.
Hey, you guys.
But I then have to change gloves because I'm touching another physical piece of evidence.
Correct.
Hey, you guys.
So as long as you are handling something where that particular.
Hey, where are you now? In the hospital? Yeah. Doctor come in yet? No. I couldn't get Walter. I couldn't get John.
Bloop, bloop, bloop. Sorry, I bloop, bloop too much. Let's go back.
393, the guest bathroom. Swabs, though. And if you need to look to your report.
Yes, I'm going to refer to my report.
All right, this is a better bloop, bloop. Here we are.
Evidence collected says that all of the L swabs marked that I documented were impounded by me.
Okay. Now from CSS Davis, we heard about a process where swabs are taken back to the crime scene specialist lab area, which is different from the actual crime lab.
Correct.
And so if any of those swabs needed to be dried, is that something that you would have done? We heard kind of about a process that you guys would do when you got back to the lab with swabs. Is that something that you did on this particular date, or do you know if those were just impounded and done, things were done at a later date?
I'll check the report. Since we were there for multiple days, things were probably impounded at a later date.
Okay. So some things, depending on who wanted to test what at what time, we heard about a temporary locker process and then things getting moved to property. There's a chain of custody that reflects all that. Is that fair?
There's anytime you impound an item, it starts a chain of custody for that specific item.
And we're talking about a chain of custody. What does that mean to you?
That means that I say I've had this item in my property since I collected it. Then I say whether it was put in a temporary locker for safekeeping until it was impounded, and then I say where it was impounded to in property. From their property can say where they put it in their building, and it lets you know anybody who checked it in and out from there.
So does a chain of custody, if understanding you correctly, document every single person who has ever handled an item evidence?
Correct.
Okay, moving into your last day at the 8526 Monterey home, did you in fact respond one more time on February 21st of 2015?
Yes.
The same way that you did on the 18th and on the 20th, did you wear protective equipment?
I would have to check for it.
Okay.
Do we know what page that is? Is that right after it? Oh, sorry. Oh, yes. Okay, and yes, we would for the third day, yes.
Okay. And how can you tell?
I impounded a lot of items that day, so we would have had the protective clothing on to protect the items that were collected.
Okay. So let's talk about what you did on February 21st, 2015. As you had done on the prior 2 dates, on that particular date, did you check in with somebody to give you an idea of what you would be doing in the home that day?
Yes, I did.
Who was that?
That, according to my report, was again CSS Carpenter.
Okay. And you mentioned that on this particular day, you collected and later impounded various items from multiple rooms within the home.
Correct.
Now, was this a day where some of these larger items in the home, furniture and things of that nature were collected?
Yes, it was.
To describe for the jury what steps were taken to protect the furniture before it was hauled off.
Since we were packaging larger items, we started from the very top of every item. So a couch, we took off each cushion carefully and placed it either in paper or plastic packaging. We had large sections of plastic, large sections of paper bags that we were able to build to the size of the item that we were impounding. So we would take the item, package it as is, and then put that to be impounded. So we did that layer by layer for every item.
And then these large furniture items, how'd you get them out of there?
We, with detective help, had them carry them and take them to a truck to transport.
And when you say a box truck, U-Haul type of vehicle?
Like a U-Haul type vehicle, yes.
The defense is stipulated with the state to the admission exhibits 548 through 560.
Objection?
No objection.
It's ordered admitting 548 through 560 into evidence.
Now, on this particular day, were you working with 2 other crime scene specialists?
Yes, I was.
Do you recall who those were?
Yes, CSS Alexic and CSS Nets.
Okay. And when you arrived to photograph, well, actually, you didn't take the photographs on this particular day. You did collection and impounding. Is that fair? When you arrived, were the placards of the items that they wanted you to collect and take away, were those already placed?
Yes.
Okay. And on this particular day, did you start with items that were photo marked with these photos that we're hearing about 68 through 79?
Yes.
So I'm going to show you what's been admitted as Exhibit 548. You mentioned CSS Metz was there assisting. Was she the one taking some of these photographs?
Yes, she was.
Okay. And Exhibit 49 shows placards 68 and 69. Are those represent some of these large items of furniture that were collected and pounded?
Correct.
Same with Exhibit 550. We see placard 70. Is that reflective of the table that was taken?
Yes.
Exhibit 551, placard 71, a comforter.
Correct.
And then Exhibit 552, looks like that 72 in the upper left corner. Is that the fitted sheet?
I would have checked my notes if that was fitted or flat.
Okay.
Was the fitted sheet, yes.
Okay. And then Exhibit 553 looks like there's a placard for each of those 2 pillows. Is that what that's representative of?
Correct.
Okay. And then Exhibit 554, are we in a different bedroom now?
Yes.
Okay. And there's placards 75 through 78. And is that representative of various parts of the bedding that you collected from this room?
Yes, it is.
Moving into the living room, Exhibit 555, I think we're looking at what is marked as 79. Is that the couch?
Yes, it is. The couch as a whole, and each cushion got its own separate indicator.
Okay, now you can't really see these in the photo, but is it fair to say that every single, excuse me, it's getting late in the day, every single pillow was marked with a letter and then packaged and taken?
Correct.
And then finally, the jury's heard about a portion of a beer bottle that was located on this last day. Is that what we're seeing in Exhibit 80?
Yes, it is.
Okay. I think Mr. Kirchler will have some additional photos of that.
Okay.
Also, on this particular day, you said that you had been working with Mark Carpenter, your supervisor.
Correct.
Was it your responsibility on February 21st to remove and collect, along with Mark Carpenter, certain hardware in the house?
Yes, it was.
I'm going to show you Exhibit 557. Do you see that? Are those the laundry room cabinets?
Yes, they are.
Are each of them marked with a sticker?
Yes, they are.
And I think at this point, they are labeled 1, 2, and 3. Are you able to check your report to confirm that?
Let me check. Correct. They are labeled as knob 1, 2, and 3.
Oh, was it your understanding that these knobs had previously been swabbed on another day by another set of crime scene specialists?
Yes.
Exhibit 558, did you then collect the hardware from what appears to be the kitchen sink?
Yes.
And I believe those items are 1 and 2?
Correct.
Exhibit 559, is it your understanding that is the dresser from the master bedroom?
Yes, it is.
Did you take every single knob from that dresser?
Yes, I did.
And again, are they all marked with stickers so we know which knob came from where?
Correct.
And then finally, Exhibit 560, was the same thing done with this particular nightstand also located in the master bedroom?
Yes, it was.
And again, was each knob marked with a specific sticker?
Yes, it was.
Okay. Okay, we're almost done here, just a little bit more. You mentioned that you were also working with crime scene specialist Alexic on that day.
Correct.
Was she taking photos while you were doing the collection and impounding?
Correct.
Exhibit 490.
We're almost done here, just a little bit more. If you ever hear your pastor say that, you know that it's a lie. This sermon is going for at least another hour. Just saying. We don't have another hour to go here. We have way less than an hour to go here. So hang in with us. We're almost to the end. But only because it wasn't the pastor that said that. We're almost done here.
96. Is this placard reflective of some of the photos she was taking?
Yes.
Exhibit 497, did you collect these 2 closet doors?
Yes, I did.
And are they denoted with placards 81 and 82?
Yes, they are.
In the backyard, Exhibit 498, did you take this gate latch?
Yes, I did.
Exhibit 500, which is showing placard 85, what was collected here?
That was for the front deadbolt.
Okay. And then we have Exhibit 501. Does that appear to have a placard for the beer on top of the cooler as well as that particular cooler?
Correct.
And is this a more zoomed in version in Exhibit 502?
Yes, it is.
I believe you were asked, as your final assignment, were you asked to process additional areas for possible latent prints?
Yes, I was asked to process the hallway wall opposite of the doors that I took for any latent fingerprints.
Were you ultimately able to find any that you were able to collect?
No, it was negative results.
Like February 18th and February 20th, at the conclusion of your involvement on February 21st, did you then author a lab report memorializing everything that you had done on February 21st?
Yes, I did.
And then you were responsible for impounding the items that you had collected?
Yes, I was.
So like we've heard from other folks, were those either taken directly to the property annex of Scottsdale Police Department or put in a temporary locker so it could undergo that proper chain of custody?
Yes, they were.
And everything that day was individually packaged that you had collected and impounded?
Yes, it was.
Okay. My last question to you is, did you ever come into contact with anybody by the name of Ian Mitcham?
I have not.
I don't have any additional questions. Thank you.
Thank you.
Blue ping 1.25 speed. We're almost to the end of this.
All right, cross-examination, Mr. Kirchler, whenever you're ready.
Judge, I'll take the 15 minutes or so, but I may a little bit more.
Okay.
Just let you know. Good afternoon. I'm not going to go through everything that the state already did. Do you have your report in front of you?
For which day?
All of them?
Yes, sir.
It should start at 5:24 and go through about 5. Actually, it goes the other way. Sorry. Do you have it though, right?
Yes, I do.
There's two types of reports. One's handwritten, correct?
Correct.
And one's typewritten.
Correct.
And you did them both?
Yes.
And they document what you did on the 3 days that you were at the scene, correct?
Yes, they do.
I want to talk to you starting with the 18th, okay?
Okay.
That's the first time you're at the scene, correct?
For 5/24, I have the date of the 20th.
Go backwards a little bit. So for the purposes of, I just want to make sure you had your report. I'm not asking you to look at
Okay,
stuff yet.
then yes.
And this is kind of in follow-up to what the state asked you. So on the 18th, you're in charge of the Pharaoh.
Yes, I am.
And the Pharaoh is a device that allows you to take accurate measurements of each of the rooms, correct?
Correct.
And you put those targets on the wall, correct?
Yes.
It can produce like a 3D image almost, correct?
Correct.
And diagrams.
Yes, sir.
And it's like laser almost, that it's that accurate, right?
Correct.
So when you are assigned this task on the 18th, the scene is pristine, correct?
It's as is, yes.
Nothing has been moved.
Not to my knowledge.
And you're with crime scene specialist McKenna, now Miss Davis, correct?
Correct.
And when you come back on the following day, you're assigned to take photographs, correct?
Correct.
Now, a day has passed, right?
Yes.
People are still working at the scene.
Correct.
And things are now moved, correct?
Correct.
And we talked about the backyard. I'm going to start there. That was the first thing that you did, correct?
Correct.
You went in the backyard and you were directed to look at these shoe prints.
Correct.
And I want to bring you to your report regarding those shoe prints. First of all, it's 406. This kind of 406 through 408.
She has them.
I'm sorry. I'm going to show you it's been marked as 406. You already saw that. That's the placard.
Yes.
Okay. And that is from the 20th. And what we didn't go over was photographed by S. Hans. That's you.
Yes.
And B1442. What's that?
That is my civilian badge number with the city of Scottsdale.
And you use that to identify things that you work on, correct?
Correct.
So we might see a item that's B1442 dash something, correct?
Correct.
And that signifies that you're in charge of that.
Yes.
I'm showing you what's been marked as Exhibit 407. Can you see that?
Yes.
Okay, on the right-hand corner of the photograph, you see a gate.
Yes, I do.
That is the gate that belongs to Allison Feldman's house, correct?
Correct.
If you look towards the left-hand side of the photograph, that is going towards Earl. Is that correct?
I am not sure what the name of the street is.
Okay. Her house is further to the right, correct?
Correct.
I'm going to, and what we're looking at here is AA and AB, correct?
Correct.
And that's next to that Cox yellow thing.
Yes.
You were directed to look at those two areas because there were potentially partial footprints, correct?
Correct.
And you documented that, correct?
Yes, I did.
Not only did you take a photograph of it, but you document it as a partial.
Correct.
And that means that it's not heel to toe, correct?
Yes.
There's a pattern in the dirt.
Correct.
I'm going to show you what's been marked as Exhibit 412. At the top, you have, that's PMAA, correct?
Correct.
And then it has
Joe,
a draw
Can
arrow.
you
to
enlarge the
indicate
screen,
north,
please?
And it's underlined. I don't know if you can see that.
Yes, I can.
And then there's, in the middle right here where my pen is, it appears to be some type of pattern. Is that
correct?
Joe,
That's
can
the
you enlarge
partial
the screen,
footprint
please?
that you
Something
identified,
happened.
correct?
Yes, it is.
And,
Thank
and
you.
the ruler that is there has a scale on it, correct?
Correct.
And that is in millimeters or millimeters, right?
Yes, sir.
And that's 0 to 300.
Correct.
That's 12 inches, right?
Correct.
So, and we're running a little bit low on time, but so that's AA, that's a partial print.
Correct.
AB is also designated, or you document as a partial print, correct?
Correct.
That pattern's a little bit more difficult to see, correct? No?
To some people, maybe, yes.
You can see it though.
Yes, I can.
It is not heel to toe, correct?
No, sir.
You make it, you document as a partial print.
Yes, sir.
And that was Exhibit 413. I'm going to show you what's marked as Exhibit 414. You see that?
Yes.
And again, that is PMAC.
Yes.
and you put that as a partial, correct?
Yes, sir.
And then I'm going to show you what's been marked as Exhibit 415. And that's also a partial.
Yes, sir.
And that's Exhibit 415 showing a D.
Correct.
Now, in your reports for each of those prints, you put that there's no direction.
Yes, sir.
And that means that you can't tell us facing one way where the heel is or where the toe is. You can't tell. It's just a print, correct?
Correct.
And that's for all 4 of those.
Correct.
Okay. I want to talk to you a little bit more about what you did on the 20th. When you go into the house, you told us that you took some photographs, correct?
Correct.
And you took about 271 photographs, correct?
Correct.
And you went through the whole house again, correct?
Correct.
And somebody had already done that on the day before.
Correct.
When you went into that house, we talked earlier that things had been moved a little, correct?
Correct.
And it was not a pristine scene.
Correct.
I want to talk to you about specifically the living room.
I think that's a really good point for true crime followers to acknowledge, because she went in at first and took a whole bunch of photos in the initial crime scene. Somebody else came in and took some photos. Then she came back and took more photos. And the defense attorney just said that crime scene was not pristine, correct? And she said, correct. That can be a big deal for me as a jury member, as a juror. Like, at what point in time does a crime scene go from being pristine to being not pristine? And how much does that affect my verdict in the end? Because obviously, even at the very beginning of a trauma scene, you have police, you have paramedics, you have people disturbing the crime scene, disrupting it, adding elements of uncertainty to it. So now the defense attorney is actually bringing this out as a point of defense. That crime scene was not quote unquote pristine. And was it ever pristine? Was it ever pristine? Because as soon as you bring in the first responders, they're already trampling over evidence. They're already introducing their own evidence, their own DNA, their own whatever to it. Just a thought. Just a thought in this case. Pristine, you will never, ever, ever, as a prosecutor, have a quote unquote pristine crime scene. As soon as first responders show up, they start going backwards from pristine to something else. And that's okay because they have a job to do. But it does make your job as a prosecutor harder. And it does give the defense an avenue to argue something. All right, here we go.
We need the living room photos, I'm sorry.
Which ones?
Starting with 301 through. Not here. Sorry. I'm going to show you what's been marked as, hold on a second. .306. Well, let me show you 300 first. This is, you'd agree that's the placard we talked about earlier.
Yes.
Okay. And then as part of that, 306 is the living room.
Yes.
Do you agree with me there? Now, on the day before when you were taking your Faro, when the scene was pristine, none of these cones were there.
Correct.
None of those
The
placards.
scene was never pristine, dude. From the minute first responders arrived on scene, it was never
actually
pristine.
moved, correct?
I would have to see a photo of where it was before.
I'll do that in a second.
Okay.
Before I get off of this picture,
yes.
There was also some tables inside that they're not there anymore, correct?
Correct.
And there's like in the middle, before you get to this phone, there's like a apparatus.
Yes.
Is that crime scene stuff?
Sir, that's lab personnel.
But it's not something that was pristine there the day before.
Correct.
And that's plugged in, going along the top of that stair, correct?
Correct.
And when you're taking these photographs, I'm going to show you marked as 307. There's quite a few, correct?
Quite a few what?
Stains or L, whatever you call those, L whatever.
L markers, yes, there are quite a few.
And your job is not only to photograph that, but also to swab those areas, correct?
Correct.
And you documented that you swabbed those areas in your report.
Yes, I did.
I had heard earlier that you didn't swab it. Was I mistaken?
She may have been talking about the light switches on a separate day.
Okay, but in the living room, you swabbed all those spaces, correct?
Yes, sir.
And it's documented.
Correct.
Judge, I'm about halfway done. This is before I go into the next part.
Okay.
This is probably a good.
All right, we're pretty close to that 4:30, so we'll go ahead and break for today. As you know, today is Thursday, which means we are dark on Friday. We'll see you back here Monday at 10:30 a.m. We really appreciate your service, and please remember that admonition as you go home. Please do not watch any news stories or read any news stories or talk to anyone or text anyone about the case, and we'll look forward to seeing you back Monday at 10:30. Thank you very much.
Okay, we can go ahead and stop it if you want, Joe.
Yeah, let's see if she has anything else to talk to the other attorneys about, like if they have something. Sometimes they have a couple little things to talk about. Nope, that's it. All right.
Yeah,
All right.
this court,
That answers the question. Yeah.
for some reason in Arizona, when it gets to a certain point, it's almost like it's on automatic timer. It just shuts off. Like I think day before yesterday, it was like almost at the end of a sentence, and it just boom, cut off. No more.
Yeah, right. Then they just did that. They
was
did that
like-
again, but just so in Lori Vallow Daybell's trials, they sometimes had things to talk about after they dismissed the jury. So that's the only reason I was like holding out for like maybe they have something to talk about. Nope, they got nothing to talk about. They're all done. Oh man, that was crazy. That was crazy.
Yeah. Yes. First thing is I want to give a big thank you to Joe about being here today for Ada and help us out for our appointment. So I want to give you a round of applause.
I'm happy to help out. I love all y'all. So Love everybody in chat. Love all the mods. Thank you.
Okay. The other thing is, Joe, I hope you come and join us because we're going to be running this case Monday while we're at verdict watch and whatever else with Brian Walsh, and then we'll continue on. So this is a good case. It's another case that has to deal with a red room and a missing body. And it's an old case because of when it became a cold case because they could not match the DNA, and then through familiarial type DNA match, they
Right.
found this guy. Okay, um, and he has a Supreme Court hearing document, but what basically happened was they took it all the way up to the Supreme Court because he got stopped for a DUI or DWI, and they drew blood on him for blood alcohol level. They did 2 vials, and apparently, the way I remember reading it, one of them was supposed to be destroyed after a certain time. Well, it didn't get destroyed, and then they started running, familiarity DNA, and
Yeah, the
something.
the Othram DNA technique is really fascinating to me. I was at CrimeCon for the Othram DNA session, and
Mhm.
I got to ask them a question, and it was great. And I got to meet them actually in person afterwards. But like they have opened up the possibilities by like 20,000, 30,000 times what the usual DNA results will come back with because of the familial DNA. And
Yes.
it has been challenged in court, and it will continue to be challenged in court, but for the most part it has withstood the challenges in court.
Yeah, now all the challenges that I've seen with that particular type of DNA has only been up to the state level um, Supreme Court. I have not yet seen uh, it make it all the way up to the U.S. Supreme Court, but I could see it heading that way. Just like
Yeah.
they tried years back and it got squashed because, as you know, the military has its own DNA bank, okay? And that's to identify, any military member that they're trying to identify, like the POWs that are coming back from other countries. However, that DNA cannot be searched for anything else. There's like a really tight lid on it. And somebody tried to, say that's not right. We should be able to do that. And so far, it's withstand the no. So I think more and more DNA is going to become uh, involved with cases. I remember when DNA first really started to get tried in cases back in the O.J. Simpson case. And
Yes. Yeah.
you talk about boring. They brought in these big doctor like X-ray light to where you could look at their their film and you could see it. Oh God, I was about ready to fall asleep. But it's come a long way. Let's put it that way.
It has like it's first started coming around like late 90s, and then early 2000s it evolved, and then the 2010s it evolved even more, and it's been challenged in court and it's been upheld for the most part. But the Othram thing is like a whole new another level of looking at ancestral DNA and like looking at third, fourth, fifth, sixth cousins DNA when you submit your DNA for an ancestral check on one of those websites.
Yes.
The FBI is saying they can access those. And in Brian Koberger, they challenged that initially and said, you can't look at those. But then eventually Brian Koberger pled guilty, right? So I think it still has to be carried out, and it still has to be challenged in court.
Yeah. Well, the Brian Clover case also the defense lost. I'm pretty sure they were appealing it. It was partly because they thought it was an illegal search and seizure because it came out of the garbage, or I think it was his father. But once you put that garbage can on your sidewalk, okay, that's
Oh
not
yeah,
your
that's
property.
public domain. Oh yeah, that's public domain. Like if
It,
it's the public right away, then anybody is fair game to take a hold of that garbage and look
yeah.
through it. Yeah.
So that's withstood time. The one thing that people doesn't look at is the other side of the coin on the DNA. Yeah, it will help close cold cases, but we've had a couple of, like look like the ones up in New York, and I think the one that the attorney that's on the King trial had in Massachusetts, where when they ran the DNA on somebody else and it went into the system, somehow it popped that it turned a couple of guilty pleas into non-guilty that got turned over into innocent because the fact that there was a mix-up or there was a a the DNA that they said matched did not match. Okay, so they've closed cold cases with that, but they've also freed a lot of people that were actually innocent that was falsely not falsely
Yes,
accused, but was
absolutely. Absolutely. There have been people that were convicted of being guilty that have been released. And then on the other hand, we have like the Gilgo Beach murderer that was found guilty because of the DNA matches, like and Brian Koberger. Like it's a balance we have to figure out as a society. Like how much DNA investigation do we agree to and how much do we not agree to? Like if you
well,
find Pete Hewerman guilty and Brian Kober guilty, is it worthy? So the old saying is it's better to find one person not guilty than one person not guilty of a crime than 1,000 people guilty of a crime they didn't commit or something like that, whatever it is.
yeah,
Yeah, you know
yeah,
what I mean?
yeah, and I agree with you. But the thing of it is that as science evolves, I mean, if you think about the astronomical numbers that came out back in the 90s and how it seems to be getting slowly and slowly and slowly fine tuned in, um, the numbers are getting smaller. And I'm not going to say they can ever pinpoint it because unless they take DNA from today to forever of every baby that is born in the world, there's no way you're going to get that number down. But it could get down to a little bit more accurate where people will trust it a little bit more. So that time will tell.
Yep. Yep. Time will tell. Time will tell.
Okay. So I want to, okay, I'm going to go ahead and end the stream. Just hang around, Joe. I want to thank everybody for coming today and staying with us again. Thank you, Joe, for covering for us when we had to leave. Um, Thank you, chat, for sticking around with all the glitches and all the oops and the goofs. And, it's, uh, as some people say, streaming is dynamic. Okay. And I wanted to tell the last couple of weeks that we've helped out Ada behind because of, personal matters with her, that I've really got more waking up about how dynamic streaming can be. So Monday morning, 8 a.m. for Verdict Watch for the Brian Walshe trial. 10:30, 12:30. Yeah, 12:30 Central Time for the Mitcham Trial. Y'all have a wonderful, safe weekend. Remember, tomorrow is the Army Navy football game, and the last thing I want to say is, go Navy!
Go Army!
Okay. Y'all have a good night. Bye bye.
Take care, everybody.
Have a good night.
Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.